Let us pray. Almighty God, we willingly acknowledge you as a supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
President.
Honorable Senators, I have received a request for leave of absence from Senator Evans Welch for today's sit-in. The leave the member seeks has been granted. I've also granted leave of absence to Senator Anil Roberts, who is ill. Honorable Senators, I am awaiting correspondence from Her Excellency in respect of the absence of Senator Roberts, so therefore I will ask if we can revert to this item on the order people later in the proceedings.
Urgent questions.
Senator Mark.
Thank you very much, Madam President. To the Minister of Health, can the Minister explain why the donated 80 vials of Pfizer vaccines arrived in this country without the necessary and proper documentation?
Madam President, good morning to you. Good morning to this honorable chamber and to all listening. Madam President, let us contextualize this. Trinidad and Tobago has a history when it comes to donations of receiving donations very often, sometimes by the container load, pending documentation. International aid agencies over the years have done this, and what we do is hold these things in bond pending the arrival of full documentation. More recently, in the case of receipt of AstraZeneca vaccines, which were not yet documented by WHO for EUL, we accepted a gift of 2,000 doses, held it in bond, pending documentation. The instant case is no different as we have done for donations over the years. The vaccines were imported again, and they are being held in bond pending further documentation, as I have outlined with precedent. Thank you very much.
Madam President, can the Minister indicate why the CMO, Chief Medical Officer, and the Ministry were not apprised of this donation before its arrival at the Piaco International Airport?
Accurate statement. If you listen to the CMO's comments yesterday, once we were informed by customs, we liaised with customs and took the vaccines into our custody pending full documentation, as we have done in the past with donor agencies and with the AstraZeneca vaccines.
Next question, Madam President, to the Minister of Health. can the minister indicate who will be vaccinated with the 80 vials of Pfizer vaccines which were recently donated to this country?
Minister of Health.
Very much, Madam President. So as stated in the public domain by the Honorable Minister of National Security, they will make the final determination as to who will be the recipients of these vaccines. The Ministry of Health makes vaccines available, but we do not specify individuals. It is up to the agency, whether it's a private sector agency, a public sector agency, to decide who will do that. My information is, as in the public domain, it will be reserved for members under the remit of the Ministry of National Security.
President, can the minister deny or confirm that these vaccines or vials have been imported for private citizens within this country closely associated with the ruling party?
That question is not allowed.
Madam President, may I proceed to the third question, therefore? To the Honorable Attorney General and Minister of Legal Affairs. In light of the recent arbitration award, amounting to approximately $1 billion in favor of A&V Oil and Gas Limited, will the state be filing an application to the High Court to seek to have this arbitration award set aside?
Thank you, Madam President. Madam President, Senator Mark's question is as dangerous as the one he just last asked. There is no award for $1 billion. Let's start with that. There's a black and white written judgment which starts at 84 million TT dollars. So that flight of fantasy that Senator Mark is on, he's on his own. Secondly, this is a matter engaging the attention of Petrotrin. The Office of the Attorney General has no dealings with this matter and never has. This matter will be considered by their counsel as to whether an appeal is in order, and it is important to bear in mind that this matter arose from a gross untruth, or rather an unconfirmed position put forward by the Leader of the Opposition. So the decision is one which is under review. The three arbitrators in this matter, Sir Dennis Byron, Lord David Hope, and Justice Humphrey Stallmeyer, held unanimously in favor of the claimant in those proceedings. The matter is under review, and this caution is offered to Senator Mark in particular. Stop exaggerating figures when the black and white figures are starting at $84 million, Madam President.
And the Honorable Minister, who is famous for hyperbolic statement.
Senator Mark, please, yes, state your question.
Honorable Attorney General, to indicate whether he is not conflicted in this matter as Attorney General, and whether, Madam President...
No, there's one question to ask, and I will not allow that question. You have one more.
Can the Honorable Attorney General indicate who were the lawyers representing Petrotrin and, by extension, the state in this very important arbitration matter, Madam President?
Sure, Madam President, I'm very pleased to say that Mrs. Deborah Peake of Senior Counsel led the team of lawyers acting for Petrotrin. And let me underwrite this statement in plain English. I have, as Attorney General, no role in this matter. Therefore, it is ludicrous to even ask if I have a conflict if I'm not involved. Again, a flight of fantasy that Senator Mark is putting onto the table.
That you are involved and you are conflicted.
Senator Mark, I will ask you to withdraw that statement. But just, you have one more, yes.
I don't know why the AG is so flighty this morning. Madam President, let me address the final question to the Honorable Minister of Social Development and Family Services. Given reports of the financial burdens being experienced by homes for the elderly, can the minister indicate what measures, if any, are being taken to assist said homes?
Social Development and Family Services.
Mr. President, the ministry has not received any such reports, but notwithstanding, the ministry provides subventions to 8 homes for older persons and payments for accommodation and care for older persons under the community care program. Subventions to the homes are made on a quarterly basis, and payments were made up to March 2021 for 6 of these homes that submitted their up-to-date documents. Payment under the community care program was made up to April 2021 for accommodation and care for 90 persons at 17 homes for older persons.
Madam, can I ask, Madam President, through you, given the financial crisis that has arisen affecting these elderly homes, whether the Honorable Minister and the government would be inclined to look into this issue to provide additional subvention to avoid these elderly age homes and the personnel therewith experiencing undue hardships?
I repeat that we have not received such reports, but we will ask our Division of Aging to look into it.
Yes?
Can I ask the Honorable Minister whether, based on the information that was publicized on this matter, whether the Minister intends to meet with the association and its president representing the homes for elderly with a view to soliciting more information on this matter, Madam President?
Minister?
Madam President, if this is necessary, it will be done.
I think I'm through, Madam President. Thank you.
Yes, thanks.
Questions on notice? Questions for oral answer?
Government business.
3 questions for oral response and 1 for written response. The government will answer all 3 for oral response, and we've submitted the question for written response. Thank you.
Senator Mark.
President, before I ask my question, may I ask whether I can raise a matter at this time? And Madam President, it's brief. When we last met, there was an undertaking or an understanding, I should say, that having deferred these questions to today's date, we had a principled agreement afterwards that this should be in addition to the 3 questions that would have qualified for today's sitting. So in all, we were supposed to have 6 questions. So I don't know if it's possible that we can look at that as it relates to the agreement under 137.
Well, Senator Mark, first of all, no such agreement was conveyed to me, and the standing orders are such that if a minister is unable to answer a question on a particular date, that question may be deferred to a subsequent date. And that question will be included with the other questions that were due to be answered. As I recall last week, you made the request that all the questions which the ministers were prepared to answer last week, you asked for them to be deferred to this week. Therefore, according to the standing order, only 3 questions can appear on the order paper in your name, and that's the 3 questions that were deferred from last week. Okay?
I would not detain us at this time. Madam President, can I go on to the questions? Okay. Question number 104 to the Minister of Sport and Community Development.
Thank you very much, Madam President. On behalf of the Minister of Sport and Community Development, with respect to the proposed hosting of the Guyana versus Trinidad and Tobago World Cup qualifier game, the Ministry of Health advised the TTFA Normalization Committee by letter dated February 19, 2021, that their draft COVID-19 return to play operational protocol did not satisfy the required 14-day quarantine period. The Ministry of Health's guidelines for the repatriation of nationals from high-risk countries were provided to the Normalization Committee. The guidelines require all nationals returning to Trinidad and Tobago from high-risk countries to quarantine for 7 days at a state or state-supervised quarantine facility, followed by 7 days in home quarantine. And these requirements also apply to non-nationals who obtain exemptions to enter the borders of Trinidad and Tobago.
Okay. Next question, Senator Mark.
Number 105 to the Minister of Public Utilities.
Business.
Then, Madam President, the government has not taken any decision to privatize the Water and Sewage Authority. Thank you.
Senator Mark.
Madam President, may I ask the Honourable Minister whether the government has taken any decision to engage in any arrangement with the Inter-American Development Bank with a view to obtaining a loan to strengthen the overall operations of the Water and Sewage Authority?
Senator Mark, I won't allow that question because it does not relate to the question posed or the answer given.
The Minister categorically state that there is no intention on the part of the government, either in the immediate, short, medium, or long term, to find a private sector partner to operate and to ensure the efficient functioning of the Water and Sewage Authority in light of his earlier answer.
Senator Mark, I won't allow that question.
Madam President, can I ask, therefore, whether the government intends to restructure the Water and Sewage Authority that can, in fact, result in private sector partnership arrangement to make that utility more efficient?
Senator Mark, I won't allow that question.
Is there any intention through the minister to retrench thousands of workers at WASA if the government has decided to restructure WASA within the framework of a private-public sector?
Senator Mark, that question does not arise. Senator Mark.
Question number 107 to the Minister of Education.
Minister of Trade and Industry.
Thank you, Madam President. Students applying to the UWI St. Augustine for academic year 2021 would have had to submit their applications in July 2020, a most uncertain time in the world and in Trinidad and Tobago due to the onset of the COVID-19 pandemic. Schools were closed, the university was operating fully online, and this level of uncertainty would have impacted decisions about future study options for many students. This decline in both graduate and postgraduate admissions has been noted as a trend in a decrease in applications globally from low-income students. Interestingly, Madam President, the so-called big-name colleges internationally halted SATs and ACT testing rules and saw large increases in applications, but this is not the trend in smaller colleges and universities. The UWI has been experiencing small decreases in admissions since 2015, as there are many non-UWI options for post-secondary study locally and also internationally. However, the impact of the pandemic on the admission numbers of 2020-2021 should not be overlooked. Further, information received from the UWI St. Augustine has shown that the number of programs offered to new students admitted over the 2015-2016 to 2020-2021 has fluctuated around an average of 284 programs. Programs offered at the undergraduate level peaked at 112 in 2017 to 2018, but generally averaged 107 programs over the period. Provisional data showed a minor decrease in the 2021 academic year, whereby 100 programs are offered at this level. Programs offered at the pre-university level remained stable at 2 programs offered over the same period. Provisional data showed an increase to 3 programs offered at this level in the 2020-2021 academic year. Programs at the postgraduate level remained relatively stable over the period. In the number of programs offered at this level returned to 178 programs in the 2019-2020 academic year and further decreased to 140 programs in the 2020-21 academic year. The campus administration has advised that a number of taught postgraduate programs are not always offered in each academic year. Further, the campus School of Business do not offer postgraduate programs for the 2020-2021 academic year. Accordingly, any fluctuation seen in the number of programs offered to new students is not considered significant enough to impact the country's professional labor force. Thank you.
Senator Mark.
Can I ask the Honorable Minister if she can be a little more concrete and specific by sharing with the Senate what would the numbers involve as it relates to what has been described as minor declines that is not significant? Can we get from the Honorable Minister what was the actual number of students that really did not access that tertiary education because of the circumstances that we have outlined?
Minister.
Detailed for you already that the programs remain constant. It would not make economic sense if there was minimal attendance to offer the programs. So implied is that there has been some fluctuation, but not generally a significantly low participation by students, or else the programs would not be offered.
Senator Mark.
I'm just trying to get from the Honorable Minister, through you, Madam President, if the information that is available to you points to numbers, whether it is significant, insignificant, or minor. So in other words, can you share with us any data as it relates to numbers?
The numbers were shared with you with regard to each level and in terms of the tertiary programs. As I said before, postgraduate programs remained relatively stable, and I gave you the numbers for that, increasing from 178 programs in 2015-2016 to 192 programs in the 2016-2017 academic year, and then, of course, returning to 178 programs in the 2019-2020 academic year, and further decreased to 140 programs in the 2021. I've given you the idea of the number of programs that have been available over the last 5 years, and that should be an indication of the level of participation at both the postgraduate level, the pre-university level, the undergraduate level. I've given you enough details in terms of program availability, and you can match these in terms of level of participation by students.
Senator Mark.
Madam President, I thank you. I thank you.
Government Business Bills, second reading.
Attorney General.
Thank you, Madam President. Madam President, I beg to move that a bill entitled An Act to Amend the Sexual Offences Act, Chapter 1128, be now read a second time. May I just confirm, Madam President, the speaking time in this House?
You have 45 minutes.
Thank you very much, Madam President. Madam President, I rise to continue the reform of laws designed to protect our most vulnerable. Today we come to this honorable chamber to amend the Sexual Offences Act. The Sexual Offences Act, by Act number 27 of 1986, brought into sharp focus significant consolidation of the law, and then over the period of several years, in particular by the year 2000, significant reforms were introduced, but not operationalized in large part. And then, over the course of the several decades that followed, we saw the laws move along in incremental amendments until the last 5 years in particular, when articulating systems to treat with the criminal side of sexual offenses in criminal proceedings, how they are managed, how we treat with our children in children's courts, how we treat with the concept of recidivism, was all tied in to further amendments in the Sexual Offences Act. Very importantly, operationalization of the mechanism to use a sex offenders registry was brought to life. In the 2000 amendments, we had a Part 3 of the Sexual Offences Act, which unfortunately was not well thought out and did not work, as a result of which no person in Trinidad and Tobago was placed on the sex offenders registry. Why? Because the law simply could not be implemented. For instance, in Part 3 of the 2000 amendments to this Act, you were required upon conviction, while you were making your way to prison, to miraculously attend at the police station to be registered. And therefore, the judiciary had the very difficult situation of thousands of sexual offences matters having come to life in Trinidad and Tobago with absolutely no one on the sexual offenders register. None. Zero. We as a parliament, under this government, amended that law. We repealed Part 3. We inserted a new Part 4 to cause a sex offenders registry. We created a register and we created a website. The register is that list or document where every sex offender so ordered by a court is placed. And the website is when it is made public on a website managed by the Commissioner of Police pursuant to a court order. What happened is that we got to see this law go to work. And in going to work, very importantly, there's an interesting decision that stands now. This is the State and Joseph before the Honorable Mr. Justice Hayden St. Clair Douglas, delivered 9th December 2020. And in focusing the purpose of this bill and the things which we seek to cure by the amendments before us now, I'd like to put this into perspective. First of all, before I get to the dicta of the Honorable Judge, permit me to say that we are now well accustomed to this country crying out for more protection for the most vulnerable, in particular in relation to the horrible circumstances of sexual abuse, sexual offenses. Many people are so impassioned that they cry out for more, but when you ask what more can be done with specifics, there is unfortunately not a clear thought presented, or there is disagreement for good reason. On the one hand, we have people that want to see transparency to know who all offenders are at the moment on which an allegation of an offense comes about. And then on the other hand, we have people that say, no, let us seek to rehabilitate. Let us keep the names private. Let us not go there. Let us avoid attacking an alleged offender unjustly. Those are legitimate concerns from both perspectives. As a parliament, as a Senate, I sat under the chairmanship of the leader of the Senate bench, Clarence Rambharat, Senator Rambharat, and we engaged in a special select committee where we invited considerations in the last round of amendments, the principal round of amendments that we made in treating with sex offenders, mandatory reporting, etc. And coming out of that experience, I can say certainly, there was a very powerful voice which turned up in the interest sectors that said, look, let us take our time in subjecting people to the scrutiny of sexual offense allegations. Now, as a matter of fact, unless you are dealing with a child victim or a child offender, the publication of who has committed a sexual offense by way of allegation, who's on a charge for rape, a charge for this, a charge for assault, those things come out in the newspapers. They are published as open forum unless a court says otherwise. So, in our newspaper reports, we have stories like this. April 2021. Tobago man, 29, denied bail for sexual penetration of a 14-year-old girl. Laborer, 22, granted $175,000 bail when he appeared in court charged with 3 counts of sexual penetration against a girl. 26-year-old man, sexual penetration of his 12-year-old brother. Princestown businessman charged 1 count indecent assault against 17-year-old boy. 23 Carenage man charged with 1 count of sexual penetration of a girl. 55-year-old laborer of Mayaro, sexual penetration of a 5-year-old boy. March 2021, no bail, 40-year-old man who robbed and raped a 76-year-old pensioner. Diego Martin, fisherman, 58, charged assaulting 2 7-year-old girls. Security guard, 41, 14 charges of rape. 14 charges of rape. 1 charge indecent assault against a 17-year-old girl. 47-year-old Plymouth man, 15-year-old child. February 2021, Princestown laborer. 22-year-old woman dragged into a bushy area, beaten and raped by man, etc., etc. Crime and problem analysis of the Trinidad and Tobago Police Service, rape, incest, sexual offences. I took a small snapshot to show what the state of society is treating with, who we are, what we are. In the period 2016 to 2021, 2016 to 2021, as at February 2021, reported rape, incest, sexual offences, 2,573. Criminal indictments filed, 2014 to 2019, 245. Convictions for sexual offences, the period 2013 to 2018, 916 convictions. Criminal indictments filed by term, again aggregated in the hundreds. Now, in this context of Trinidad and Tobago, with 916 convictions at the Magistracy and High Court, 916 convictions, what is the status of our sexual offences register? 1. Why is it 1? That's why we're here. Should we look at something else? Are we to pay attention to the marches against sexual violence, murder, rape? Are we to do something to give people a fighting chance? Is the vulnerable to be protected? This is where I come back to the dicta of the Honourable Mr. Justice Sinclair Douglas. And I'd like to put this on the record, paragraph 1 of his judgment. Sentencing note. I quote, the judge is quoting here. I never completed school as a result of having my kids at a young age. I had my daughter at the age of 13 years old. I was then a Form 1 student at the Barataria South Secondary School. After giving birth to my daughter, I went back to school and continued my schooling. I had advanced to Form 2, but became pregnant again with my son. I was 14 years old. I never returned to school after having my son. The judge says, these are not the words of a young female in some isolated plantation or far away from rural community in 1940s Trinidad. These are the words of a young female who resides in an urban community in Trinidad in the 21st century. In the view of this court, this is unacceptable. There's one other paragraph that I thought ought to be put onto the record. And here is where the judge, in looking at sentencing of a particular individual in this matter, asked a question. He said, a question, that's at paragraph 17, a question is often posed to children and young persons about their ambitions and aspirations when they grow up. The responses are likely to be varied and as limitless as the frontiers of a child's imagination. Chef, professional footballer, professional athlete, doctor, lawyer, representing the West Indies, going to the Olympics, singer, actress, air hostess, model. Even with the wide variation in childhood ambitions and imaginations, this court has never encountered a young girl whose ambition was to have her first child at the age of 12, to have 2 children by the age 14, and to have 3 children by the time she had attained adulthood. When we listen to a factual scenario of thousands of convictions of the abuse of the vulnerable, we must obviously then go to the Children's Authority. The Children's Authority statistics in up to 2021, as at 2021, March 31st, for the period 2015 to 2020, the number of cases reported are 27,837. 6,402 of those cases are for sexual abuse alone. What is grippingly horrific is that the cases for sexual abuse for children include children between the ages of 0 to 4 months. So this is the backdrop of the Society of Trinidad and Tobago within the parameters of Section 13 of the Constitution. Why Section 13 of the Constitution? Section 13 of the Constitution we're treating with the principle applied across any law in general. Is it reasonable in a society such as Trinidad and Tobago that we may make laws to protect the vulnerable? We make laws under Section 53 of the Constitution for the peace, order, and good governance of society. We're making a law today. Now, what does this law say? Is it reasonable in Trinidad and Tobago that we ought to have these amendments? Is it proportionate to the rights that are in issue? The rights of the victim, the rights of the accused, and the rights of society as a whole. Because there is a social arrangement between the individual and the collective, and that is on test here today. So what does our bill propose? Our bill is set out comprising 21 amendments. For the ease of honorable senators, I'm going to ask, I had a consolidated version of the Act done. I'm going to circulate it to all honorable senators, showing all of the amendments that have been made, particularly the last 2 amendments that this government piloted in creating a new sexual offences register, and the matters which we did in December 2020, where we amended by Act number 29 of 2020, where we amended shall to may in respect of the absolute requirement to have a mental assessment report. And then the amendments that we propose now are set out in that Act. It will help honorable senators when we get to committee stage. Let me start by saying that I've received some very useful submissions from the Law Association, some of which are agreeable, others of which are distinguishable and therefore not proposed to be accepted, but I'm sure they will come up in the course of this debate, and I intend to address them in large part in the wind-up and at committee stage. But let's get to the bill. So the first few clauses of the bill, Madam President, what time is full time?
You finish at 8 minutes past 11, some 20 seconds after that.
Thank you so much. So the first clause, this Act is the Sexual Offences Amendment Act 2021. Second clause is a proclamation clause. Third clause, the Act that we're amending, the Act means the Sexual Offences Act. Fourth clause, we seek in Clause 4 to amend Section 2, which is the definition section of the Principal Act. And in that, we seek to, in the definition of register, we correct some cross-referencing because we're making some amendments further down. So we change 47.1 to 46AA. In sexually transmitted, we're putting an and at the end of that because we're now going to introduce a defined term of the website. And that will become apparent in a moment. The website is the public sex offender website established under 46A. Let's get to what we're doing in the substance of the bill. In Clause 5, we're deleting the National Sex Offender Register, a single register, and in the heading, we're now putting sex offender registers, plural, because there are going to be 2 of them. We are saying in this particular structure, that then springs to our amendments in the bulk part as to the rationale behind this bill. But let me go through a few cursory matters to do it clause by clause. Section 6 amends Clause 6 amends Section 45 of the bill. And what we're doing in Clause 40, in Clause 6, in Section 45, we are improving the applicability of this part, the sex offender registers, to people who are the subject of conviction in Trinidad and Tobago and people who are also the subject of conviction outside of Trinidad and Tobago. Why? Because later in the Act, we provide that people who are convicted of registrable offences outside of Trinidad and Tobago must report within 2 days. If they're spending more than 2 days in Trinidad, they must report to a police station and have themselves registered. That takes care of the situation of deportees or migrants, etc., so that we can have an understanding of where we stand in relation to sexual offences. Let's go then, Madam President, to Clause 7. Clause 7 is where we set up the two registers, the National Sex Offenders Register, which is a non-public register, and then the Public Sex Offenders website, so that there's a clear distinction between the two. In Clause 8, we make an important amendment to Section 47. Now, allow me to stick a pin. The Law Association, in their comments, signaled that they couldn't understand why people who were the subject of conviction under the previous law were not being included in the current register. And let me answer that plainly. They can't be included because the court is functus. When they passed through the court and they were convicted, the court at that moment never made an order that they go on the register. So we couldn't go retroactively, revive a case which was completed, in respect of which there was no appeal, there was no order to put you on the register, and we therefore said anybody that was convicted prior to the coming into force of our new part can't be put on the register. And I'd just like to remind that this was the subject of significant debate in the Special Select Committee. We had a significant amount of commentary. Senator Chote, as she then was, participated vigorously and agreed with this position. So unfortunately, the Law Association probably didn't have the benefit of those submissions or didn't recall, but that's why people, the thousands of convictions that are on the record, cannot be included. So we seek in Clause 8 to make an amendment to Section 47. And we say the National Sex Offenders Register shall contain information in Schedule 3 and pursuant to Section 54. And then we say the register shall not be accessible to the public. A recommendation has come in for us to consider whether we should exempt this register from the Freedom of Information Act. That is something that we perhaps can consider at committee stage, because Section 35 of the Freedom of Information Act allows things which are said under Section 34 of that Act to be prohibited to still in the public interest be disclosed. So it may be an opportunity to close that door for good reason, because there is another aspect of it. The other aspect is the public register. We, very importantly, make sure to maintain the control and custody by the Commissioner of Police. We make sure that there are security arrangements around it. We get to Clause 9. Clause 9 seeks to repeal and replace Section 48. Section 48, in its original form, is the public access to the register. And what we are doing here, essentially, we're amending the marginal clause. Unfortunately, the rule is you can't just amend the marginal note on the side of the position. You have to repeal and replace. So it looks like a substantive amendment. It's not that substantive. We are seeking to repeal and replace. We are ensuring that the Commissioner of Police shall have a public sex offenders website, and that this website shall be maintained with the information provided. Note, we have said that we would put the locality of the sex offender, not the address, because the learning tells us you ought not to give the specific address, but rather the area, Port of Spain, San Fernando, as it may be, to avoid the concept of victimization. There's a notice and caution that you can't intentionally use these things without justification. There's an inquiry in respect of use. Use is the plain and ordinary meaning, and it is subject to lawful excuse. So if you take that register and you share it for the purpose of caution, you may have a justifiable reason for doing so and therefore not have a problem with the law. In any event, this was decided by our Special Select Committee when we amended it in the last Parliament, and accepted by both houses of Parliament. Clause 10 treats with the court to order the sex offender to comply with Part 4. Now, Clause 10 here had initially a mandatory registration exercise for the grievous aspects, rape, incest, subnormal personality, children, etc., any breaches in the Children's Act. That was mandatory. You had to go on the register. We amended that law by way of amendment to the schedule to include repealed offences under the old Act, Section 6, for instance. So we included mandatory reporting. It was taken care of in the very case that I read by Mr. Justice Sinclair Douglas. And then we had a discretionary position where a court could consider every other offence as going onto the register, subject to an application under Section 54, where the court considers it's not appropriate to put you on. For instance, it was a case of incest, the family may fall into odium, the child may be prejudiced. What we do now is we say every sexual offence is to go on the register. However, that is subject to the individual making an application to not go on the register or to certain circumstances. You have appealed the decision. Your appeal is still pending. In those circumstances, you do not go on to the register, or you make an application to the court and say, I do not wish to be named as a person on the sexual offences register for the public side. I want to be off, and the court considers that. I flag that we intend to make amendments in relation to this, to put in prescriptive time frames so that the court considers how you get to that decision. If you make an application that you should not go on to the register, and that application is determined against you, we're going to include the rights of appeal, and that you should not go on to the register until the court tells the Commissioner of Police, okay, it's clear to put you on because we have rejected the application. So I'd like to caution that that is not a removal of the discretion of the court, Madam President. That is, in fact, maintaining the discretion of the court. What we're doing is we're just turning it in a different direction. Mind you, Section 5 of the Constitution allows for an onus to be put upon somebody to reverse the burden. That is clearly recognized as not tripping the Constitution of Trinidad and Tobago in any rights fashion. So the discretion is maintained when you look at the Act as a whole. Madam President, when we look to Clause 11 and we see the amendments to Section 50 of the Act, it's at Section 50 of the Act where we do the surgery of making sure that we preserve due process, subject to subsection to a court shall, where he's appealed the conviction, or not appeal the conviction. We take the steps as to when the Commissioner of Police ought to put you on the record. Why? Because inquiries came from the Commissioner of Police saying that there was uncertainty as to when you ought to come on. Should you come on to the register only after you have come out of jail? Should it be in a different scenario? So what we have done is to provide clarity because of the working experiences that we've had in applying this law. Very importantly, the new Section 50, subsection 2 says, where a sex offender is convicted of a registrable offence, he may apply to the court to be exempt from having his information published on the website in Section 48. The conditions that the court ought to consider are set out in subsection 4 here, the court in making its determination. Please note, Madam President, that what we did is effectively move the conditions set out in Section 49 as it's originally stated, put it into Section 50 so that we preserve the court's discretion and give the indicating factors as to what ought to be in the mind of the judicial officer in considering the application to not be put onto the register. This Section 50 is closely related to Section 61 of the law, and Section 61 is where we deal with exemptions from registering or reporting. So please read Section 50 along with Section 61. Madam President, again we seek in Clause 12 to harmonize the approach of the time frame to make better meaning of the law as stated. We change within 4 months of discharge to within 4 months before discharge so that we can work out the timeframes for reporting. Clause 13 fixes cross-references as a result of amendments that we propose. Clause 14 removes the word registered from registered sex offender because the initial report of a sex offender, at this point, that person is not registered yet. That person is only a sex offender. So it is a tidy up and clean up. Madam President, Clause 15 takes the similar approach of disaggregating the sex offender versus the person who is a registered sex offender. The sex offender is a person who has received the decision of the court that says you are a sex offender, but you're not yet registered until you go through the registration requirements set out in the Act at the police station pursuant to the court order, etc. Section 61 is proposed to be amended. Here we are harmonizing the exemptions from registering or reporting. And what we're doing here is we're doing two things. We're cleaning up the approach and we're bringing it in tandem with a law that we've already amended, Act number 29 of 2020, which we did in December of last year. Section 6 of that Act amended the Sexual Offences Act. We deleted shall, we put may, and we said where a report is requested. Why? Because a court may not always, in its discretion, decide that it wishes to have a report presented. It may have been presented in other circumstances. So this is to bring harmony with law that this Senate has already passed in December of last year. Madam President, Clause 17 again keeps with this concept of may and shall. It is to bring us in tandem with what we did in December of last year, where the court, in looking at factors, in making a determination pursuant to an application, may request a mental health assessment report. And we then take the opportunity to clean up the difference between sex offender and registered sex offender. Madam President, Clause 18, again, is to bring us in harmony with that December amendment, the may and shall amendment. That is Act number 29 of 2020, Section 6. So what we're doing is we're cleaning up the rest of the Act in line with what we did already as a Senate. We, in Clause 19, again, make the distinction between a registered sex offender and an offender. In this case, it is a registered sex offender that we're speaking about. We seek to amend, Madam President, in the remaining clauses, the regulations. We seek to raise the fine from $50,000 to $250,000 and imprisonment for 5 years. Why? Because we already amended the Interpretation Act as a Parliament last year, and therefore these figures have to be brought in line with the Interpretation Act as amended and could not stand below because the laws would be in conflict. In any event, having amended the Interpretation Act after this Act, that would apply, but it's unseemly to not fix it while you have the chance. It's just changing the law in its expressed form in line with what it ought to be. Madam President, we also seek to cause amendments to the schedules attached to the Act. Again, we're raising $50,000 to $250,000 and 6 months to 5 years, and that's in the DNA Act. We are doing that again because we amended the Interpretation Act already, and that's for breach of the rules, of regulations, forgive me. We are seeking to add the Police Service Act amendments, introducing who a sex offender is as opposed to a registered sex offender, and we're making that distinction there in the consequential amendments. Madam President, that's the heart and soul of the amendments. Let me break it down in simple form now. The bill before us intends the creation of two registers. A register which remains with the Trinidad and Tobago Police Service and which is not open to the public. That register has everybody on it. The minute the court makes the order, the register is populated because the court says so. What we seek to do is to create a public register, which is a website operated by the Trinidad and Tobago Police Service. That public register is one where we are putting the flow to get there as follows. The court makes an order that you're a sex offender. You shall be put onto the register unless you say to the court that you don't want to be put on the register. The court then exercises its discretion in that application. We seek to cause some amendments to the bill to tell you the time frames to apply and what happens. Second thing, we seek to harmonize amendments that we've already done. Last year in December, by Act number 29 of 2020, we amended the shall and may in respect of the request for a mental assessment report. We are harmonizing that into the law now. Thirdly, we are also causing harmony for the amendments that we made to the Interpretation Act. In the Interpretation Act, as we have it amended now, we raise the ceiling for offences, breaches of regulations, up to $250,000, etc. Madam President, these amendments come while we are in the public domain at present, the Office of the Attorney General, discussing further amendments. And the further amendments I'm flagging now are to treat with things like voyeurism, revenge porn, criminalizing the disclosure of intimate images and videos, etc., against the will of someone. That is not criminalized in our law. We are seeking to treat with the concept of further harmonizing bail and how it relates to this. We are discussing the issue of whether the concept of corporal punishment is still relevant, because there's a corporal punishment law for rape. We are also seeking, Madam President, to cause a tie-in of resources. Why are we seeking these things, Madam President? Because we're also asking in the public domain, relative to further amendments proposed, that we consider a register of sexual offences charges. Why? Because, Madam President, if you go for a certificate of character in this country, the police are looking for convictions. The fact is that sexual charges, offences charges, are public, unless you're dealing with children or child offenders or the court says otherwise. They are published in the newspapers. People come to you for a job, for inspection, etc., and you have no idea of what they are before the courts on. And when you see our country correctly rise up and say, how can monsters be walking around unbridled in this country with 10 and 12 and 14 charges for rape or assault, etc., it's because there's no register for these things. None. Now, of course, we must factor these things in the concept of a small island state, a small society. But where do we get the protection balance? Because, Madam President, I'm giving notice that all of this flows into the regulation for the PH and taxi and maxi and driving industry, which is tied into this. And therefore, the government's approach is an holistic plan where we give the vulnerable or the innocent or the unaware a fighting chance at knowledge, where we give people that ability to also think twice before they do something. Now, Madam President, I recall my mother constantly telling me stories of what it was like to be afraid whilst growing up that you did something wrong because you will get punished in school. On your way home, the neighbor cut your tail, excuse your French. The neighbor will discipline you. By the time you get home, your parents discipline you twice for the shame at school and the shame in coming home because you just couldn't do it. In Trinidad and Tobago today, we are almost immune to horrible stories. We are immune to violence. We have armchair critics. We have politicians. We have commentators who seem to have no bounds. There is no degree of civility or accord. There are no limits that are out of bounds now. You will leak images. You will say things. You will make up stories. The concept of telling a gross untruth is a reality in this country because who cares? You just make law. You make fact. And in our country, I dare to say, we are at a very dangerous crossroad where it is not what is the truth, It's what is the version of the truth you select for yourself. And therefore, legislation like this is designed to bring us back to some degree of normalcy, to put some degree of boundary and exercise. I dare say, Madam President, that I consider this law to be entirely proportionate. I dare say that this law is reasonable in a society such as Trinidad and Tobago. Madam President, I ask you to note that we are not asking for any 3/5 majority passage of this law for a very good reason. The reason is it's all in the discretion of the court. Once we have the comfort of judicial discretion, we are in a better position in terms of proportionality and therefore constitutionality. We are seeking to protect our vulnerable in society. This law was designed without the other laws that are in discussion, specifically so that we can take amendments one after the other after we have consultation. And we've had wide consultation on a number of matters. I wish to thank the Law Association for providing fulsome comments, which were very useful in this regard, Madam President. I also thank several members of the public for sharing their points of view in respect of this. I am certainly very interested in having the perspective of my learned colleagues in this chamber so that we can move towards a better form of law as we get to law which is good for the peace, order, and good governance of our society within the meaning of Section 53 of the Constitution. Madam President, as I said, we'll do two things. One, circulate a marked-up track change version of the Act so that honourable members can follow. And then secondly, Madam President, we do propose to introduce amendments to treat with some of the issues that I have identified so far. Madam President, I thank you for this opportunity to pilot this bill, and I beg to move.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Sexual Offences Act, Chapter 1128, be now read a second time. Senator Lutchmedial.
Thank you. Thank you, Madam President, for the opportunity to contribute on this Sexual Offences Amendment Bill 2021. Madam President, I wish to say it up front that I support any measure, any legislative or other measure that would curb the tide of violence against women in this country, and children, and particularly sexual violence. We spoke recently, we had the opportunity through the very important motion brought by Independent Senator Richards to discuss some of the issues of sexual violence, violence against women and children in general, but particularly we mentioned some of the sexual offenses and the prevalence. I don't know if it is that we just have more reporting at this time, or if it is that we've just seen a drastic increase, but over the years it has simply gotten worse, and the Attorney General has read a couple of headlines. I could tell you that the headlines and the reports in the newspapers, as a former prosecutor, I could say, it doesn't do justice to some of the things that you see and that I have seen over the years. When I was back in my 20s, I remember as a child who was very sheltered, I would read things in files, and then I would meet victims, and I would have to go to court and deal with cases, and at the night I would have to ask my mother to sleep with me because of some of the horrific things that I saw and dealt with during the day. It's that bad. It really is that bad, and no newspaper report could even do justice to what women experience in this country, and children, and even young men and boys experience now with sexual violence. So I am in support of measures, proper measures that would curb the tide. Now, the first thing, of course, that I have to say is that and the Attorney General addressed it towards the end of his contribution, is the removal of the special majority. The 2019 amendments, which this bill seeks to make changes to, will pass with a special majority. And the Attorney General is on record in the Hansard, when this bill, that 2019 bill was debated right here in the Senate, I think it was on the 5th of February 2019, saying that, and he says, what about your 3/5 rights, your right to privacy and family life, Section 4? Yes, it is stripped in this bill. So how is it was stripped in the 2019 bill when you had a non-public register? And now when you are seeking to create a public website where a person's personal information, whether a person is convicted or not, whether they deem them monsters or not, they still have constitutional rights, whether we like it or not. I don't like it at all. I do not like it. And I want to say very openly, because there's a lot of criticism of attorneys who defend people in court or who take up constitutional cases and so on. It is not that you feel the individual deserves certain rights, It is that you feel that as a society as a whole, it is important to preserve rights. And I cannot see how, when a bill in 2019 introduced a register that was non-public, that the Attorney General could say that it tripped that 4C right to privacy. And now, when you are creating a public website, that right is not being violated. So, Madam President, as I said, I am all in favor of certain information being made public once a proper process is followed, but I do feel that this ought to have been special majority legislation, and I would not like to have a law passed that isn't passed through the proper process and procedure. Will it withstand Section 13(1) scrutiny by the court, proportionality and the whole Surat Barry Francis type test? It perhaps, yes, it will, because we have to take into account the conditions under which we are operating at this point in time and what has become so prevalent in our society. But there's no reason, in my respectful view, and this is a trend that we are seeing sometimes, that special majority legislation is being, the majority clause is just being removed. And that is a dangerous and frightening incursion upon the rights and freedoms of people, where you are basically saying as an executive, we are passing this whether there is support or not. A more appropriate approach would perhaps to have a little more consultation and engagement so that there can be agreement and we can make sure that these laws are passed properly. Now, the other thing that I believe is a little bit of an incursion upon the concept of separation of powers is the amendment proposed to Section 50 and in the Clause 11 of this bill. The creation of the public sex offender website and what information is to be published there, it says that the court shall do it. This is the same argument that was raised when we had the pepper spray debate and about the revoking of the permit. It is the same thing that I have raised all the time on bail. The executive ought not to be using the legislature to command the judiciary. The judicial officer seized of all the facts of a case is the person best placed to make a determination. When a person is convicted, there are so many permutations, there are so many different factors that may weigh into and may be present in a case that the judicial officer ought to make the determination whether or not the person's information ought to be published. You have to consider a number of things. Now, of course, you've included the clause where I think it's subsection 2 of the new section 50, where the offender can make the application to become exempt from having his information published on the website. Well, I respectfully, and there's a list of things that the court shall consider. Respectfully, Madam President, I want to suggest that in Section 51, that we revert to discretionary may, that's subject to subsection 2, the court may, where a person has done so and so, order that his information be, and he has exhausted the appeal conviction or appeals process, order that his information be published, and therein list some of the factors, together with the catch-all at the end, any other compelling reasons in the case. that the court should consider before ordering that this public publication on the website be made, so that in every single case the court is compelled, or use the language in such a way that the court is compelled to consider it and make a determination. I say all of this in the context that sometimes the offender may not care one way or the other, so he may not make the application under subsection 2. But what about the victim? The victim has no right here to say that, listen, if you publish, and the Attorney General used the exact example I wanted to use, a case of incest. If the victim feels that by publishing the information in relation to her attacker who committed incest, an act of incest against her, will expose her identity and it will forever be something that she has to carry the shame and so on of, the victim ought to have a voice, and the perspective of the victim is something that the court should consider. So the mandatory aspect of this should be the factors that the court must consider when making the determination, but the ultimate decision on whether or not the information should be on the public website should, in my respectful view, remain with the court. Madam President, the other aspect of this that I wanted to look at is the review mechanism. Now, I believe that initially in countries such as the United Kingdom, they did not have a built-in review mechanism, and it was challenged, and it was found that it would be contrary to the rights under the European Convention to not have a review mechanism put into place. So we have put into place a mechanism where someone can make an application. I have found the UK system to be a little bit more accessible. Under this system, and correct me if I'm wrong, and I'm happy to hear that a bill with all of the amendments is being circulated, but that would have been really helpful before the debate. And I would like to urge the Attorney General to perhaps provide us with those things maybe a day in advance. But it is the I'm sorry, I didn't hear him, but or he could get the Law Revision Commission to start working on updating the website with the laws. But the point is this: the burden is on the person to come to the court and make an application to say, well, these are the reasons why I should be, I should not have to report any further, and I can have my information removed from the website. We are a society where a lot of people do not understand, or they do not have the resources to approach the court for these types of orders. You're looking at someone who may have served a term, they have come out of prison, they have challenges, all of the challenges that are faced by persons who come out of prison in terms of financially and otherwise, and you put the burden on them to make this application. In the United Kingdom, they have a system whereby through the reporting process, the police are actually allowed to determine whether or not you can actually go to the police station and say, well, listen, I've been reporting here for X amount of time, I've attended this session, that counseling, therapy, whatever it is, and after 5 years of coming out of prison, serving my 7-year term, 5 years after, I wish to be removed, and the police can then trigger whatever they need to get, whether it's an assessment by a professional or whatever it is, and make a determination. There's significant guidance provided to the police in how they should do it, and there is an appellate process if the police refuse it, so that the person could actually then make the application to the court. But the first line where the determination can be made is the police. Now, I think that's a very useful type of mechanism that they have put in place in the United Kingdom. It means that every person who wishes to have a review done after they have reported for a number of years and after they have been listed for a number of years to have that mechanism triggered. You see, it's not just about imposing punishment on someone that they're forever branded on this website and that they must remain there. Or it's not just about offering protection to the general public of knowing who sex offenders are. We must also look at rehabilitation. We must also look at the concept of ensuring that people can re-enter society, and these people have to live when they come out of prison. So if it is that someone really does commit to reforming themselves, it sounds strange to say reform when you think of the grievous type of offenses, but there are lots of offenses captured as sexual offenses, and sometimes they aren't they aren't all of such a nature that you can say from now, listen, there's no hope for this person needs to forever be branded and placed on this website, and we must know of them and their whereabouts and so on for the rest of, for all of eternity. So make the process of the review mechanism a little bit more accessible, I believe, and as I said before, allow the court to determine whether or not it is in the best interest, given the circumstances of the case, whether the person should be placed on the public website to begin with. Madam President, the amendment to Section 57, well, Section 57 generally deals with notifying the police of a change in circumstances when the person is offended, when the person is registered. And I would like to suggest that we include a mandatory requirement that the information be updated within a specific time. Again, with sex offenders, it is very important to know the location. We live in a country where people give their address as where they were born and where they perhaps grew up, and that is their registered address, but they haven't lived there for a very, very long time. They stay by a girlfriend somewhere, they're doing this, they're doing that, and the monitoring of people, and I see this all the time in the court when bail is granted and people have to do the reporting under the bail requirements. The police have a very hard time sometimes locating them afterwards because people move around a lot and they stay by family, friends, whatever it is. So any change in circumstances really ought to be immediately notified, and it's there in the law, but we should include some sort of a process and a time frame in which it must be updated on the website, because this website is really not for the police, it's for the public. So if a person notifies the police within the required time frame, let's say the offender does his part, but the police fail to update the records, and that's not a far-fetched notion. That happens all the time. In fact, and the AG raised the issue of criminal records. There are many, many people who have actually threatened to sue the Commissioner of Police for failing to update their criminal records and showing pending matters which have been, so it's not true to say that the police don't only look for convictions, they also look for pending matters. In fact, your certificate of character, when you apply for it, they check both matters. The problem is that the system isn't updated because it is the duty of the police officer when the matter is completed to inform the Criminal Records Office to update the system. So you have had people, and I've met people who applied for jobs, and when they went for a certificate of character, they had been charged 15 years ago for resisting a police officer and using obscene language. And of course, the matter, went through the court system, thrown out, whatever it is, and it is still showing up on their record. If we do not update this website in a timely manner, it will really defeat the purpose. It will defeat the purpose because the general public, you could have a registered sex offender of the most violent nature who has served his term, but he's now back into our society, coming into your area, and you wouldn't know. And that's the importance of the locality factor, and that's why one of the things that they ask you that the bill includes, and I support it, is the inclusion of locality, and that was there since 2019. In the United States, you actually just put in your location on an app and it will show you popping up around you, and it's actually quite scary if you do it, about the number of sex offenders registered right around you. Now, I think that's a bit extreme, and of course, in a small society like ours, that would have a number of different consequences. So, but it is important sometimes to know who are your neighbors and whether there are people in your area who have moved into your area and come into your area who have been convicted of certain types of crimes and offenses. The primary reason for the creation of a register is really so that the police in the area as well must know who are the people in the area and that they have to do some monitoring, because that is the only real way to attack and to try to deal with the problem of reoffending by sexual offenders. So I flagged the issue of the retroactivity, and I understand what the Attorney General has said about it being, the court being functus and not being able to make the order. But I would like to suggest that perhaps persons who are presently serving a term that we can, and again, if there are further amendments to be proposed, I think one of them has to be that we find a way that persons who are presently serving a term and who will be coming back out into society in the next 3, 4, 5 years, that we find a mechanism to capture them via some means of reporting. Because the persons who are going to be charged now or who are having their matters heard now, they are going to go into the prison if they are convicted. So them coming onto the website and is really many years down the road. But what happens with the ones who are presently in there? They are the more immediate problem that we have to deal with as a society. And I'm speaking here as a woman, as a mother, as you know, someone who has to walk the street from time to time and to live in this society. I want to know if tomorrow or next week a person who was convicted of a violent sexual offense 10 years ago is coming out of prison. So I would urge the Attorney General to give some consideration. Again, put it out there for consultation with all the necessary parties. I take the point of the Law Association raising the functus issue. Perhaps I agree. There may be civil mechanisms. They call them collateral orders that judges can make and so on, and the state can apply for in other jurisdictions, to have persons, to impose some sort of reporting requirements on people who are coming out of prison. Because we don't want to have, it's like a generation of sex offenders who would be coming out of prison now and living with us until the rest of, and only the ones who are convicted post the passage of this bill are the ones who will be there on the website and who we are allowed to know about and who we are allowed to monitor. Madam President, just briefly, I want to deal with the issue of, you know, having a philosophical approach to dealing with sexual violence in our society. Because a register and even a public website only addresses the middle of the problem. The middle of the problem being the persons who have offended and are now before the courts. And I'll get to that in a little while about them being before the court. But we also have to look at what gets someone there. What is wrong in a society when you have these numbers of cases of sexual violence taking place? So a register and a website places the burden on the citizen to look around, look over your shoulder, find out who your neighbors are. Very useful, yes, but it places the burden on you, the innocent party. We really do need to have more things in place to prevent us from having these things happening to begin with. And I think other senators, I'm sure, would talk about it. And when I read the debate in 2019, I saw that many senators spoke about these things. And then we also have to look at the issue of reoffending, recidivism. What are we doing to help? Putting someone on a website and putting your face on a website and letting society know that you are a dangerous sex offender really does not prevent you from reoffending. In fact, there are some, and this is where the balancing comes in, there are some persons who are adamantly against public sex offender websites because they feel that that level of putting this person out there, it really prevents this person from being allowed to re-enter society and become a meaningful contributor to society. And it can actually encourage reoffending because, let's be real, when a man comes out of prison and if he has a propensity to commit these type of offenses and he's now on a website where anyone can check his name and see that yes, this is who this person is, he may not be able to get a job. He may not be able to get a number of things. And I have no pity for a person who is a sex offender who comes out of prison and perhaps faces those things as a human being. I probably don't. But we have to look at we have to take away that emotion and consider now when that person, that offender, is back out into society living among us and he suffers the backlash of society because it's public knowledge that this person, name, address, name, location, and photograph, is a sex offender. What is he going to do? If you have that propensity, and if we do not have enough things in place to help them, the offenders who are returning to our society, deal with their problem that they have, because they have a problem, are we just creating a situation that is ripe for reoffending? And that is something that we have to look at. So a person coming out of prison, yes, we have to balance the need of the society to know against what will help them. So let us I'm just saying it has to be that there are other measures such as mandatory counseling, mandatory attendance at whatever type of therapy is needed to help these people while they are reporting. And you have the system here now where they are registered and reporting, so you know who they are. Growing up sometimes, I remember visiting my grandparents and so on, and they would say, well, so-and-so, he went to jail, and people in the neighborhood just kind of know that there was something about this man, and so they would tell you, well, don't walk that way when you're going somewhere, and that kind of thing. But nobody ever reached out to those people to find out, or to try to fix, or to try to mitigate the risk of reoffending. Instead, they are branded, and they are treated in such a way that it may encourage them, and the reaction that they may have to society it would not be helpful to anyone, not their potential victims, not society as a whole, and certainly not them. The other issue that we have, and the AG flagged it, that we have a situation where a lot of people who are charged are walking around. Now, I have to say I do not support persons who are charged being placed on a public register. It may be reported in certain circumstances in the media, but that is that really does to me offend against the innocent until proven guilty principle and the constitutional right that you enjoy to your innocence. The newspaper reporting you and putting it out there, I mean, yes, in the digital age, it may be accessible and so on. And a lot of times I've noticed the media leave out names, but they publish enough circumstances that the person could be identified. And I have my views on that. But in any event, once a person goes on a public register and they are merely charged, the damage to your character is done. And I think I spoke about it before in this house of cases that I did, where after 6 years, a victim recanted against someone she accused of rape. And for 6 years, an innocent man stayed in prison without bail because of the allegations and so on. But the same thing could happen here. An innocent man could have his face plastered on a website for years until a victim perhaps recants or he's found not guilty by a court and the process goes through. So I don't support any publication for persons who are merely charged. What I would say is that it is frightening that for sometimes 10 years, a person charged with multiple offenses and perhaps who has reoffended whilst on bail for one reason or another is still amongst us and walking amongst us. And the solution to that has to be that we expedite the criminal justice process. I have made the suggestion before of specialized courts to deal with gender-based violence issues, both of a sexual nature and domestic violence type crimes. These matters involve families, they involve crimes of such a nature that you really want to give the victim the soonest possible avenue for closure. You also want to create an environment that is conducive to having these trials done, and specialized courts can address that. It would also mean that these matters are pulled out and channeled through a system whereby they are not just bogged down with it. Because you see, the thing about it is that capital matters get priority in the court because persons are deprived of their liberty. And once you have that happening all the time because of the amount of murders we have and the amount of so on, the criminal justice system is simply overburdened. And so if we want to get these persons who are charged off the street in the quickest possible time, and on the register and in a prison, then it really is important for us to look at the justice system and to expedite these matters as quickly as possible. Another suggestion that I would have, Madam President, may I just ask what time I'm supposed to finish?
You finish at 2 minutes past 11. You have some 37 seconds after that. So 2 minutes past 11, 37 seconds.
It's 11:29.
Oh.
2 minutes past.
I'm sorry. 11:42:37.
Thank you. Thank you, Madam President. Yes. So another suggestion, and I think this warrants some some consideration. Sexual offenses are such that a lot of it is he say, she say, as we say sometimes. And what would improve upon the rate of detection as well as the rate of conviction is really employing more scientific methods of crime solving. The statistics from CAPA that I looked at as well, yes, they are frightening in terms of the number of matters categorized as rape, incest, and other sexual offenses. In 2019, you had 352 reports, but the detection rate was 82. 82 matters of that 352. That's really, really poor. 372 matters in 2020, 129 detected. So far for this year, 127 with 39 being solved. Now, when you are depending on eyewitness evidence, for example, when you are depending on a rape victim to remember the identity and all of that, and to be, not just to remember, but to be brave enough to come forward and give the statements and give the reports and go through the process. A lot of people, even though they report crimes, they do not follow through with the identification process and so on because they just don't want to have to do it. But if you have proper DNA ought to be a standard method of crime solving when it comes to sexual offenses and prosecutions. We will not just raise the level of detection and we will also raise the level of conviction because you have scientific, irrefutable evidence being placed before a jury as opposed to a victim who, it is heart-wrenching when you have to see victims give evidence in sexual offense matters. It is really, really heart-wrenching, and how many of them are incapable or just simply unwilling to do it. It is scary. It allows these same people who we want to put on our website to walk free. So having a website is nice, but we also have to put things in place to make sure that we have enough people and that we capture all the people that we need to get onto that website. So we need a higher level of detection and prosecution for these offenses. Madam President, just briefly, and I know one of my colleagues will probably touch upon this a little more, there are certain provisions in this act that deals with the court, when the court has to exercise a discretion, for example, to expunge someone from the register. We are now making it, we have removed the mandatory requirement for a mental assessment. If anybody needs to be mentally assessed, I think it is a person who has committed an act of sexual violence. So I don't know that the court, that it should be discretionary. I think that sometimes things that prolong a process, we try to remove it so that it will expedite the process. But what we should really be doing is making sure that it doesn't take so long. So a lot of the times, it is discretionary for the court to order various types of reports, from social workers and all of this. But the more information the court has, the better. And I don't feel that a discretionary mental assessment should be included in these amendments. I think that the court ought to, they must be mandated to have a mental assessment done if they are going to remove someone from a register. To me, a mental assessment, I'm not a doctor, maybe Senator Deyalsingh would shed some light on this, but I think that having a proper mental assessment done on someone who was a sex offender and wants to now be removed from a register and not be subjected to the stringent requirements of reporting and so on, you really want to make sure that they are not going to reoffend. And a mental assessment is a very useful tool in making that determination. So I think it should be, as a matter of course, that those things ought to be done. I do believe that perhaps the freedom of information power that the Attorney General said he wanted to discuss, whether it ought to be circumscribed here, I think that actually these websites, the National Register really ought to be kept confidential if that was in initial intention. And if you have a public register and the court, not the legislature, but the court determines who should be placed on it and what information is there, then I cannot see it being generally open to the public to make a freedom of information request. So I think that warrants some further consideration and discussion as well. But I am not really in favor of exempting things from freedom of information. information, really, if a legislature wants to make a big impact, we should actually be telling people when they must utilize information. One of the things that I've seen in foreign jurisdictions is that there are certain types of activities and certain types of employment that you must actually, it is important, for example, for a preschool to vet applications by persons against the public sex offenders registries, particularly the child registries. And other countries have special registries for child sex offenses. So that is something as well that we have to look at. Should we be including in this legislation now that it is mandatory that persons who are running certain types of daycares and preschools and sporting clubs and cultural clubs and so on? I believe that the judgment quoted the facts of that case, of the judgment that the AG quoted from, where the girl had been impregnated twice before she entered Form 2. It was from a teacher who was teaching steel pan to her. And when you have people with those types of propensities being allowed to interact with young children and so on, it really is a danger to society. So a meaningful piece of legislation would mandate as well that persons running these types of organizations check these websites. Why put the information out there when people may not even be using it? And it might sound strange that people don't use it, but I've actually seen where very cunningly people are able to convince others that, you know, they were wrongly accused and set up and things like that. So perhaps making it illegal in some way, or having very strict measures in place to vet persons who are on these registers when they are applying for certain types of activities. In the United Kingdom, they restrict your internet access if you are guilty of certain types of offenses, sexual offenses, of course, in like child pornography and so on. They restrict your use of the internet. And if the police find you, and of course they have the technology to monitor your access and what you're looking at and so on, if they only find that you have done that, it's straight back to prison, because those are some of the types of orders that the court is empowered to make. So they are really they have really taken offender management to a whole different level. And that is where I hope to see that we could actually reach. And offender management involves everything, including rehabilitation, going down as the person is.
Senator, you have 5 more minutes.
5 more minutes, yes, thank you. So all of this is part of that philosophical approach that we have to take towards crime fighting and towards sexual offenses. Madam President, I would perhaps circulate an amendment in light of what I have proposed, particularly with Section 50 and the placing the discretion back to the court about the public website. Again, I am firm in my view that a court really and a judicial officer sees of the facts of every single matter that comes before him or her is really the best person to make a determination as to whether or not someone should be publicly listed on a website. I agree that mandatorily it should be that they come onto the National Register, that is the private register that law enforcement has access to. I have no challenge with that. But once you are placing a person on a public website and you're placing information about them, remember, this is a very small society, and you do not want to have a well-intentioned piece of legislation and a well-intentioned scheme be maligned and bogged down by unintended consequences. And so, as I said, the one that comes first to mind is the identity of the victim, preserving that anonymity that we should be offering to victims, and all sorts of other types of permutations that could arise in sexual offenses. And so I would ask the Honorable Attorney General to give some consideration to leaving that discretion with the judicial officer. Madam President, I thank you very much.
Senator Thompson-Ahye.
Thank you, Madam President. This bill for an act to amend the Sexual Offences Act seeks to make some changes to the Sexual Offenders website and register. I should first like to thank the Honorable Attorney General for kindly providing us with a consolidation of the various amendments to the Sexual Offences Act. Perhaps a consolidation can also be done of the legislation pertaining to child justice. Some months ago, I submitted an article on reforms in child justice in Trinidad and Tobago for publication in this year's edition of the International Survey of Family Law, and the editor suggested that it would be useful if I could annex the relevant law. I had to tell her that in Trinidad and Tobago, because of the numerous amendments that have been made and were to be found in various pieces of legislation, that would be too difficult. Finding the law here is a researcher's nightmare. CPC and Law Reform Commission take note. Persons who are not lawyers in the chamber have particular difficulty. So today we're dealing with the sex offender registries. An earlier amendment to the Sexual Offences Act exempts child sex offenders from being placed on the register. And I agree totally with this amendment. But I want to say that the legislature and social services should address the issue of juvenile sex offending, which anecdotal evidence suggests is much more prevalent than we realize, especially within families. Brothers and sisters, cousins, stepbrothers, and so on, with devastating long-term effects on young girls. Now, the Honorable Attorney General spoke of horrific statistics put out in the annual report of the Children's Authority. And I would like to say that I served on that care committee for some years, and one day when a case came before us of a 10-year-old girl and one younger being sexually abused at night, I asked that I be relieved and promptly resigned from this committee because I just could not deal with it anymore. So children are suffering, and we need to work on the best that we can. And I know the gender-based unit is doing much better than before because we never used to get follow-up with the police. But things have improved, but there's still a lot of work to be done. One must be mindful, though, that this bill, as all laws pertaining to sexual offenses, deals with detection of a crime that is traditionally grossly underreported. What we have, therefore, to deal with today is an inaccurate measure of the true incidence of such crimes. And further, this bill is applicable only to those who have been convicted. So the pool of sexual offenders who are affected is even smaller. If we think that in enacting these amendments to determine which sexual offenders get on the register, how, for how long, that will make us and our children safe from sexual predators, we are being delusional. Sexual offenders who come to the attention of the law represent only the tip of the iceberg. When we looked at how many sexual offenders convicted are in prison today, I can't believe that I'm hearing that there are 11 convicted offenders in the prison, 5 for rape, 5 for indecent assault, and 1 with sex with a minor. So all the others are on remand. What is happening? Clause 6 of the bill seeks to widen the applicability of the register to apply to sex offenders who have been convicted of offenses outside of Trinidad and Tobago and may even be a registered sex offender abroad. To me, that seems very logical because a sex offender, when traveling to another jurisdiction like ours, is not going to leave at home, but is very likely to bring with him, well hidden from view and undeclared to customs, the weapon he used to commit the crime abroad. And given his propensity, may very well use it here. We know what is happening, and we have had at least one precedent of a registered sex offender from outside Trinidad and Tobago entering this country undetected in just 2020. So we know he was Nicki Minaj's husband, although it was carnival time. To all intents and purposes, fortunately, he did not make mass here. Clause 7 of the bill provides for the establishment of 2 sex offenders register, We have a National Sex Offender Register, which will not be accessible to the public, and the Public Sex Offenders website. Now, perhaps the rationale for having these two separate registers is to arrive at a balance between the right of the public to have information about a sex offender in their neighborhood and the human rights of the offender, his family, his wife, and children, to have some degree of protection from vigilantism and victimization and other self-help behaviors which do not aid recidivism, rehabilitation, or reintegration. Now, when we look at Clause 8, it provides for the Public Sex Offender website to omit from public view certain particulars of the sex offender, which are included in the National Sex Offender Registry. It places the National Sex Offender Registry under the control of the Commissioner of Police. The Commissioner now has control and custody of the register and is responsible to maintain the register and ensure that the information entered therein is in accordance with the Act and any other written law. He must ensure that the information published is accurate. Now, herein lies the rub. The Commissioner of Police is required to, and I quote, make reasonable security arrangements to protect the information contained in the register against unauthorized access, collection, misuse, alteration, disclosure, or disposal. Now, Clause 9 places the Public Sex Offender website under the control of the Commissioner of Police. So he's taking care of both. This website now is accessible to the public, subject to an application being made for exemption from publication under Section 50. Clause 9 states that the information in relation to a sex offender is to be placed on a website, and the information in subsection 4 is the name, the former names and aliases, the date of birth, the photograph, the locality in which the sex offender lives, and convictions of registrable offenses committed by the sex offender, including the date of each conviction. So all of these will go there. My question, though, is, should it be subject to an application for exemption, or should it be subject to a successful application for an exemption? It seems to me that unless the offender's application for exemption is successful, his particulars will be included on the register. Omission from the register follows a grant of exemption, not an application for exemption. As with the National Register, the Commissioner has the responsibility, as I said before, of making reasonable security arrangements to protect the information published on the website against unauthorized access, collection, misuse, alteration, disclosure, or disposal. Now, Madam President, in 1978, I took part in a play on campus called Justina's Calypso, written by Earl Lovelace and directed by Gregory Maguire, playing the role of Justina. I remember a line from that play. It went like this: "It ain't have no secret in this place." Madam President, I'm an avid reader of daily newspapers. I listen to talk shows on the radio and television when I can catch them. And if I have to give an alternative name for the country of my birth, it would be Busmark Country. Name has nothing to do with anyone in the chamber. Madam President, many in the media seem to have access to high office holders who help them busmark for some consideration. It may be love or money. Whatever the reward, Lovelace was right. It have no secrets in this place. So we have given the Commissioner of Police the responsibility of making reasonable security arrangements to protect the information on the website and on the National Register. But what is reasonable? I consider the threshold of reasonable security arrangements not high enough. I recommend a change in wording. The Commissioner should not make reasonable security arrangement, but instead, I would recommend that he makes every effort to protect the information published on the website against unauthorized access, collection, misuse, alteration, disclosure, or disposal. The phrase "make every effort" is a higher standard to me, in my mind, of care than to make reasonable security arrangements. Now, Clause 10 amends Section 49 of the Act to enact a new provision, a new Section 49(2), which reads, where a person has appealed his conviction, the court shall, pending the completion of the appeal, withhold making an order in accordance with subsection 1. Now, given our record of time periods for an appeal, what is it now, 5, 10 years? If the offender is out on bail pending his appeal, his name may never reach the register for years. And this would defeat the purpose of protecting the population from the sex offender. Some offenders have clever lawyers, well able to manipulate the system. What is the status of the plans to expedite the hearings in the criminal justice system? Has the building out of the criminal court in the towers on Ryson Road been placed in jeopardy by the massive unexpected expenses occasioned by the government's efforts at alleviating the devastating effects wrought on the economy by COVID-19? Maybe we can have an update from the Honorable Attorney General to say what is the position to date with those ambitious plans with the criminal justice system. In Clause 11, we find that Section 54, sub 4, the factors that the court should take into account in deciding whether or not to grant the application of a sex offender who wishes to be exempt from having his information published on the website. Clause 11b seeks to amend Section 53 and states that before making a determination, pursuant to an application for an exemption, the court may request a mental assessment report from a psychiatrist. The report from the psychiatrist is at the top of the list of the factors that the court must take into account in determining the application. Now, this reminds me of a saying my dad used to say whenever any heinous crime was committed. Daddy used to say, he either mad or he bad. Clearly, the legislature is of the same mind. So, but what some categorize as a mental affliction is discrimination based on gender, power, and control. My view is that what should be at the top of the list is at number 4 on the list, the risk of reoffending. That's what should concern us most. What is the risk of that offender reoffending? The most important consideration. Clause 6 is also relevant to the application to be exempt from registration as a registered sex offender pursuant to Section 54. Again, the risk of reoffending is critical. Clause 16 amends 61 in Section 61 in 2 respects. Not only exemption from registering, but also cessation of reporting. When do I stop reporting? So you have a schedule of the offenses and the period for reporting. The Medical University of South Carolina publication in 2010 of a study entitled Evaluating the Effectiveness of Sex Offender Registration and Notification Policies for Reducing Sexual Violence Against Women concluded, among other findings, that a follow-up of just over 8 years that registered sex offenders were not less likely to recidivate than non-registered sex offenders. And one of the problems we have in this society is the lack of research studies. One of the recommendations in that report was to limit the duration of the period of SORN, S-O-R-N, sex offender registration and notification. The study recommended that since few low-risk offenders will sexually reoffend, and that even high-risk offenders are less likely to recidivate as they age, because when you get older, you slow down. As they accumulate time in the community offense-free, registered sex offenders should be providing an opportunity to be released from the requirements after a reasonable period of law-abiding behavior in the community. And they suggest 5 to 10 years in the community. Every year that you go and you have any lack of offending should be taken into account. Now, how effective is the sex offenders registry? In the February 2006 issue of Corrections Today, which is published by the American Correctional Association, there is an article entitled Understanding Policy Programmatic Issues Regarding Sex Offender Registries, written by Matthew Lees and Richard Tewksbury. And in that article, the authors state, if I may, Madam President, that while sex offenders have always been subject to particularly severe sentencing laws on harsh treatment from society, the past decade has seen a development, emergence, and proliferation of a new form of criminal sanction, the Sex Offender Registry. So it has reached here now. The heightened awareness they continue of sex offenders can generally be attributed to the Jacob Wetterling Crimes Against Children and Sexually Violent Offender Registration Act of 1994, a law that formalized the practice of registering sex offenders in statewide databases. Sex offender registries were subsequently made publicly accessible almost always via the internet through Megan's Law. And most of us would have heard about Megan's Law, which was passed in 1996 in response to a brutal murder of Megan Kanker, a young New Jersey girl, by a registered sex offender living anonymously in the community. So this and subsequent legislation was created to deter potential sex offenders and reduce instances of sex offender reoffending. So it was really organized and came into fruition to deal with children who have been sexually abused. Such moves have also served to provide at least an illusion of increased public awareness of sex offenders, enable community members to protect themselves and their children through greater knowledge, and to provide a sense of creating safer communities. So, are we really going to get safer communities? Perhaps the most important reason for the creation of sex offender registry has the anticipated reduction in recidivism for sex offenses. But the authors concluded that the research to date suggests that sex offender registries may not be achieving the goal of deterrence or reductions in recidivism. Sex offender registration is a process that is well-intentioned, but as suggested by the emerging literature, fraught with problems, inconsistencies, and the potential for adverse consequences. So the need for continued research is clear. Public policy and the safety of communities will hinge on what research continues to show regarding the efficacy, process, and consequences of sex offender registry. So do I offer any hope, or is the picture all bleak? One promising sign of a successful response to sexual offenders is restorative justice. Anne-Marie McClendon, in an article entitled Restorative Justice as a Response to Sexual Offending, addressing the failings of current punitive approaches, published in 2008 online issue of the Sexual Offender Treatment, which is the official journal of the International Association for the Treatment of Sexual Offenders, IATSO, advocates the use of restorative practices with sexual crime as a proactive, holistic response to the problem. And we did hear the Attorney General, the Honorable Attorney General, talk about a holistic response, and is ultimately as a more effective means of reducing the incidence of sexual offenses and sex offender recidivism. So McCallender states that at best, the criminal justice system can only ever hope to deal effectively with those offenders who have already come to the attention of the law enforcement authorities. And that's a very small number of offenders. Some research show fewer than 5% of offenders are ever arrested. And evidence from self-reporting studies, when you speak to the offenders, they reveal that they have committed much more offenses than they are being questioned about. But there is not enough reporting, so they are not being detected. So child abuse often remains hidden and undisclosed. Low level of prosecution attributed to the low level of reporting. Sex offender registration and community notification impede offender reintegration. What do we want at the end of the day? Do we want these persons to return and be reintegrated in the community? So restorative justice and as alternative views crime not as a violation of the law, which necessitates punishment, but as harm to people and relationships, and seeks to redress or restore that harm. So it involves engaging the offenders to help them appreciate the consequences of their actions, encourage reparation to victims or the wider community, and reintegration of the offender. It is used, restorative justice, the term, to cover a wide range of programs. Conferences in one form where the offender and the one harm, they get together with their supporters in a restorative justice conference in the presence of a trained facilitator, and we have several trained facilitators in Trinidad and Tobago now, and also with the community being represented to decide how to repair the harm. Some judges in the United States are also using intimate abuse circles as a restorative response to domestic violence. And you have circles of support and accountability being used widely in Canada for the last 10 years with reintegration of selected high-risk offenders at the end of their sentences. And an evaluation of circles in Ontario found that high-risk offenders had a reduced rate of recidivism of over 50%. In the book Restorative Justice Today, Practical Applications, published in 2013, Anne Hayden and Catherine Van Woomer, in an article entitled Restorative Justice and Gendered Violence, compared how the criminal justice system dealt with the needs of female victims and offenders against restorative justice. And they advocated the victim survival panels, where you have a range of victims meet with perpetrators, not the same persons who had perpetrated the crimes against them. And they sit and they listen, the perpetrators, to the narratives of the women. It can be very painful to them. And what has been emerging is that on hearing of the pain suffered by the women, actually hearing the pain, they begin to feel that sense of empathy. That is a feeling that is being evoked. And they get in touch with their own feelings and their own victimization. Because as we always say, hurt people hurt people. So where did it all start? And I want to tell the story of Frank, who sexually abused his granddaughter. It's a true story, and it involved a single sexual act against the granddaughter. But it evoked a lot of turmoil in the family that before that incident, the family was very close-knit. Frank had a wife of 36 years. He had 7 children. 3 of his sons came to the conference that was convened, and they all spoke about what happened, because first of all, he had denied the charge. He said he didn't do it. But when he went and he thought about it, he said, I should not be putting my family through this. I confess I did, euphemism, interfere with my granddaughter. So the conference recommended periodic detention, suspended prison sentence, and 2 years supervision and counseling or therapy as recommended by the probation officer. And the court accepted the recommendation. But what came out of the conference, and that's why it's so important to understand why the crime happened, is the fact that he said that hitherto he had been a model citizen and father and all of that, but he was introduced to a lot of pornographic material in books and videos, and there was born the harm that he perpetrated. So perhaps one of the things that we should look at is to redouble our efforts to eliminate what we have heard is the huge amount of pornographic material circulating in this society. Because certainly it's putting ideas in people's head, it's getting people aroused, and it's causing them to commit crime. Now, at the end of the day, I am not advocating that we throw out the register and say no sex offender registry. But what I'm saying is that we must understand the limitations of the use. That we explore, alongside the use of the register, such options as being offered in the field of restorative justice for a long-term and effective solution to the heinous crime of sexual offenses. So let us not close our minds to alternatives. Let us understand the reality of what we think we're doing, what we would like to do, and how best we can do it. And Madam President, I thank you.
Senator Bethelmy.
Good afternoon, Madam President, colleagues, and citizens joining us on ParlView and the Parliament channel. Madam President, in recent times, we have seen the proliferation of violent crimes and sexual acts against our women, children, and vulnerable members in society. This is due to the very real fear that our women and children are being targeted by a minority of men who feel emboldened by their ability to carry out such crimes. So, Madam President, this bill could not come in a better time, and its impact cannot be discounted as we empower our protective services to safeguard those they have sworn to protect and provide our citizens with the information necessary to protect themselves and their families from sex offenders. Madam President, I will not be long as I come behind many illustrious speakers learned in law. However, I will focus on the following points. I will give an overview of the current situation and why it's important for us to protect our women, children, and vulnerable in society, and what the government of Trinidad and Tobago is seeking to achieve with these bill amendments. Madam President, I stand before you not just as Senator Yokymma Bethelmy, not just as a legislator, but as a sister, a friend, a daughter, a cousin, and a godmother. I stand before you, Madam President, as a witness of female friends being sexually assaulted in public by complete strangers, as a confidant who has heard the experiences of many females and other vulnerable members in society about being sexually offended from childhood straight into adulthood. I've read numerous newspaper articles about local and international sex offenders ripping the innocence from our children. I've unfortunately seen the disgusting videos shared through social media about children being sexually molested. I've heard and looked at trafficking documentaries. Madam President, I have seen it all. And if I have not seen it all, I don't want to see anymore. I think that I'm fed up. According to UNICEF, approximately 1 in every 10 girls under the age of 20 has been forced to engage in sex or perform other sexual acts, although the figure is likely much higher. Roughly 90% of the adolescent girls who report forced sex say that their first perpetrator was someone they knew. So, Madam President, who are the sex offenders? It's usually the nice guy. It's usually the stepfather, the brother, the teacher, the coach, the guy that everyone trusts and has easy access to our children. They are usually the people that we love and respect. Madam President, the study goes on to say sexual violence results in severe physical, psychological, and social harms. Victims experience an increased risk of HIV and other sexually transmitted diseases, pain, illness, unwanted pregnancy, social isolation, and psychological trauma. Some victims may resort to risky behaviors like substance abuse to cope with trauma. And as child victims reach adulthood, sexual violence can reduce their ability to care for themselves and others. Many victims of sexual violence, including millions of boys, never tell anyone. Madam President, children cannot defend themselves against these individuals, and it's exceedingly rare for a child to make a false claim about being sexually molested. And this has been proven study after study. Madam President, protecting our women and our children is everyone's business. Through God's blessings, our women are creators of life, and our children are our future. Without fully functional youth, Madam President, I have no future. You have no future. We have no future, Madam President. And it is of utmost importance that we protect our future. Madam President, I know the conversation of abuse and neglect of children is an awkward discussion to have, but it is one that is necessary. And for that, I just want to say thank you to our Honorable Attorney General for being our champion legislator and for bringing bills dedicated to protecting our women and our children. I say thank you to Senator the Honorable Clarence Rambharat and the other members of the Special Select Committee for their contributions in this matter. I say thank you to Senator Paul Richards for his motion that examined the deficiencies in our current systems in place And last but not least, I thank our Honorable Minister of Gender and Child Affairs for all of the work that she has done within her ministry. Madam President, under the astute leadership of the Minister of Gender and Child Affairs, the government of Trinidad and Tobago has placed several programs in place, such as the National Child Policy, the Be a Hero initiative, which was designed by the West Indies Cricket Board. It integrates sport and education to create heightened awareness of abuse with a focus on being a hero by breaking the silence against child abuse. We have on the ministry's website, there's also a child zone where children can go and visit and actually interact with friendly graphics and videos and workbooks that actually raise awareness about child abuse and to really educate the children about what is right from what is wrong. We also have the SARA project, which is safeguarding and rescuing all humans from human trafficking. And we also have partnerships that the ministry forged with NGOs and the Tobago House of Assembly. And this was really aimed at providing all citizens on both islands who have been victims of abuse in any way with a safe place to be after. The ministry also has the support of the TTPS, Child Protection Unit, and the Children's Authority. But even with all of these programs in place and all of the work done thus far, we still have to pass necessary legislation to support the programs that we have put in place. So, Madam President, on to the burning question. What are we seeking to achieve with these bill amendments? Madam President, through these bill amendments, we seek to support the work that the Children's Authority has already been doing. We seek to support the Child Protection Unit of Trinidad and Tobago and all other agencies working together to protect our nation's children. Madam President, let's examine some of the amendments in the bill. Clause 7, which seeks to amend substantive legislation to give effect to the National Sex Offenders Registry and the Public Sex Offenders website. But why do we need this amendment? You see, Madam President, the government has been burdened with competing interests, balancing the rights of a convicted sex offender while protecting jealously our citizens and general public to live a life free from fear without unnecessary encumbrances. The introduction of this register will assist our law enforcement agencies to monitor and track our registered sex offenders as means of expediting investigations and criminal acts. On the other end of the spectrum, the register will allow the average man or woman the opportunity to vet the people that they interact with, live around, or even expose themselves and their families to. It will allow for the individual to take responsibility in implementing safeguards with the additional information made available to them. Madam President, what the government of Trinidad and Tobago is trying to do is not anything new. We are not reinventing the wheel. This model has been used in the United States of America's Department of Justice, where they have something called the SMART Initiative or the SMART Program, which is the Office of the Sex Offender Sentencing, Monitoring, Apprehending, Registering, and Tracking Department. And this is really aimed at, it's really a system in place that monitors and collects all the necessary data that is needed as far as dealing with sex offenders. Madam President, I know citizens and activists and some of my colleagues on the other side may have some reservations with the register being made public, but personally, Madam President, I would like it to be public, and some may argue that we are violating the rights of perpetrators. But what about the rights of our children? What about the rights of our women? What about their rights, Madam President? Which brings me to clause 8 and 9. Madam President, these seek to bring balance and highlight the other end of the spectrum, which is protecting the perpetrator and protecting our citizens from themselves. Madam President, as said earlier by my colleagues before me, the National Sex Offenders Register will be monitored by the Commissioner of Police to protect against unauthorized access, collection, misuse, alteration, disclosure, or disposal because this register will have detailed information. But why? Why are we giving access of this detailed information solely to the Commissioner of Police? You see, Madam President, the bill before this Honorable House is one that not only affects the lives of citizens, but it's one that stirs strong emotions in our hearts and that can sometimes get us in trouble. Madam President, we may sit back and not truly feel the full brunt of crimes experienced by fellow citizens until it hits home. So, we have seen videos on social media from across the world, right here at home, of citizens taking the law into their own hands and seeking justice on behalf of the victim. To answer the question why the Commissioner of Police is the only person who will have access, it's to protect against vigilantism. Madam President, when we look at Clause 9, where we speak about the sex offenders' website being made public, the public will have access to it, but it too will be controlled by the police commissioner and will set out specified information on sex offenders. But reasonable security measures will be put in place and to protect the information on the website against unauthorized access, collection, misuse, etc. The new amendments will prohibit the publication of the sex offender, and it will require locality similar to what our Honorable Attorney General spoke about. We are not going to put the person's exact address, we're just going to put where you're located. Madam President, the Sex Offenders Register will allow for persons to protect themselves and their families, because how can we tell who we are interacting with, especially in a day like today? We really have to provide our citizens with the necessary information to continue guarding themselves and their families, because even with the various programs that I spoke about earlier, even with the different units that I would have discussed earlier, our citizens are still at risk. Madam President, the Sex Offenders Register, Madam President, we are focusing on the face-to-face interactions. What about internet? What about taking a closer look at technology, which has revolutionized our daily lives? The internet has evolved from being a specialized communication tool to one that is common in our workplace, schools, and homes. And on the flip side, it can be used to facilitate crimes such as human trafficking and child pornography. Madam President, the internet is used as a medium by sex offenders to target vulnerable children and citizens for sexual exploitation. But how can we protect our children if we do not know who they're interacting with? Madam President, the old saying goes, it takes a village to raise a child. But I want to change that saying and say, it takes a village to raise and protect a child. It should not just be looking at John when John is misbehaving. It should be observing John and knowing what is happening with him, observing his behaviors, and if you hear that John is being sexually abused, at least report it to the right authorities, not to take it into your own hands. Madam President, we are not at all saying that the Sexual Offenders Register will stop sexual crimes, but it is a tool that can be used to deter possible sex offenders. Additionally, Madam President, this piece of legislation will create further reinforcement for the programs that address the socio-cultural change needed to treat with the underlying issues that promote gender-based violence and child abuse. The problem of sexual violence and child abuse and violence against women and our vulnerable members in society is of national legislative priority, and the government of Trinidad and Tobago will continue to actively work towards protecting our women, children, and vulnerable members in society. With that, Madam President, I thank you.
Senator Seepersad.
Thank you, Madam President, for the opportunity to contribute to the debate on the Sexual Offences Amendment Bill 2021. Madam President, considering the sexual assaults and brutal murder of far too many women in Trinidad and Tobago, the fear of sexual predators and the general safety of citizens, especially women, continue to be highlighted in the media. Citizens are also actively participating in protests to demonstrate their frustration about the brazen actions of violent sexual predators. All sexual-related crimes are heinous. Statistically, sexual predators are mostly men targeting women. A recent IADB study found that 20% of women surveyed in Trinidad and Tobago had experienced some form of sexual assault, but few reported these attacks. Reasons for not reporting include social shame, fear, the tedious legal process, lack of access to redress and justice. Fortunately, the Me Too movement has emboldened women of all backgrounds to come forward. Nevertheless, victims suffer permanent psychological scars. Imagine 1 in 5 women suffering unspeakable trauma in silence and having very little or no support mechanisms. Imagine daily having to pretend that life is normal, life is okay. Madam President, I firmly believe that victims require state-provided, well-resourced, dedicated, ongoing services to deal with the mental, physical, and emotional trauma. Every effort to reduce, if not eliminate, these offences is of critical urgency. Therefore, Madam President, I am in support of measures to reduce the incidence of these crimes. Between September 2019, when the Sexual Offences Act was passed, and January 2021, 326 people have been charged for sexual offences. However, as at February 2021, as the Honourable Attorney General mentioned, only 1 person was registered on the National Sex Offenders Register. He will have to register with the police station in his district for 7 days after serving a 9-year prison term. And his name will remain on the register for 10 years, and he must report annually. However, hundreds of sex offenders sentenced prior to the new law in 2019 cannot be placed on the registry as retrospective punishment is unconstitutional. Clauses 8, 9, and 10 of the bill. Madam President, the primary focus of the bill is to establish 2 registers, the National Sex Offenders Register and the Public Sex Offender website. The databases are valuable tools for monitoring and tracking sex offenders following their release into the community. The TTPS will have a crime database, the National Sex Offenders Register. While a sex offenders registry is not unique to this country, the registry sets out to capture the personal data of persons convicted of sex crimes. The database is under the direct control of the Commissioner, direct control and custody of the Commissioner of Police, who will be responsible for populating and updating the database. The database is structured so the TTPS will have access to additional details, including, among other things, photographs, fingerprints, DNA profile, etc. The subset of the registry is the Public Sex Offenders website, which will be released online for the public use and will contain information such as the name, former names, etc., photograph, locality, not specific addresses, to avoid victimization, and the conviction and conviction dates of the offences. The subset of the registry is expected to be expunged after a predetermined period. However, it is almost impossible to remove data which has been proliferated on the World Wide Web. Also, cyber criminals may download the data and use it for further crimes. Madam President, while every effort to reduce, if not eliminate, these heinous offences is commendable, I would like to raise a few concerns, especially since the constitutional right to privacy is being taken away for registerable sexual offenders. My concerns are: 1, the security of data. As already mentioned, the internet is not secure, and confidential personal information can and will be misused. 2, the integrity and accuracy of data. Data capture must be both accurate and complete. It cannot be one or the other. 3, confidentiality of the extended personal details in the care of the Trinidad and Tobago Police Service. No system is secure enough that hackers cannot compromise. And 4, what redress is there when a conviction of a person on the database is overturned because of new evidence? Global Sex Offenders Registry. Madam President, I'm asking that the Honorable Attorney General consider connecting the Trinidad and Tobago National Sex Offenders Registry with countries such as the United States, Canada, and Europe. The TTPS will have a centralized database to collate information on sex offenders and allow sex offenders to be tracked across borders. There's also software that can be used to intercept registered sex offenders who try to message children on social media. We need sweeping changes, Madam President, to reduce the violence against women. Clause 10 of the bill, amendment to Section 49 of the Act. The amendments in Clause 10 removes the role of the court in determining who is included in the National Sex Offenders Registry, for how long, and whose details go on the public sex offenders website. Under the existing Sex Offences Act, a person convicted of a registrable offence will only be required to be registered at the discretion of the court, Section 54(1). A person can apply under Section 61(1) to be exempted from registration, or under 62(1) for the cessation of the reporting requirement. Under this bill before us, all registered sex offenders must be included in the register. The court must now order the registration of all persons convicted of a registrable offence, subject only to an application for exemption. Further, under the existing Act, the public was denied access to the register unless the court ordered under Section 49(4) that the offender's information be published on the website. Madam President, under the proposed bill, there seems to be no situations under which the public may have access to the register. The effect of the amendment is to make registration and therefore reporting under Section 54(1) an automatic consequence of conviction. The obligation is on the offender to satisfy the court that an exemption from the reporting requirement is appropriate. Madam President, I don't agree with the court's discretion being removed. Section 48(1) of the Sexual Offences Act. The effect of this section means that the following information is not included on the website: that the sex offender is a citizen or resident of Trinidad and Tobago, that the sex offender was convicted of a registrable offence by a court in or outside of Trinidad, that the sex offender completed his or her sentence before the commencement of Act No. 19 of 2019. I'm not sure why this information is not included on the website, but I believe it should be. The public should know that the sex offender has served his or her sentence. Finally, Madam President, protection and mitigation strategies. Madam President, relevant legislation such as the Sexual Offences Amendment Bill 2021 before us and the imprisonment of sex offenders are valued because it protects the wider society, especially women. It can potentially encourage citizens to obey the law, since convictions have severe and long-lasting consequences. However, laws, no matter how punitive, may not always deter someone from committing a crime. We also need education and awareness. In Trinidad and Tobago, treating sexual offending needs to be multifaceted, and this is resource-intensive. Studies have shown that sex offenders tend to lack victim empathy, display emotional loneliness, and possess inadequate problem-solving abilities. This is confirmed in Fisher, Beach, and Brown 1999 and Marshall and Barbary 1990. These factors may contribute to the onset of predatory sexual behavior and crimes. Intervention strategies such as early detection of personality and mental disorders is crucial to successfully tackle the issue of sex offending. Psychological testing, counseling, and medical treatment are necessary to identify and treat antisocial behaviors and enhance emotional competencies to prevent and mitigate sexual violence in our country. The criminal justice system in Trinidad and Tobago has to prove efficient and effective in charging, convicting, and rehabilitating sexual offenders through psycho-educational interventions during incarceration to end impunity for acts of sexual violence and all forms of gender-based violence. Reducing case backlogs and delays in trials is critical for both the victims and the accused. This will also mean that persons will be incarcerated more timely if found guilty, rather than being out on bail for years, the ability to continue their violent behavior. Finally, Madam President, Honorable Attorney General, I also look forward to you bringing legislation to the Senate which deals with, among other things, sexual harassment and the registration of public transport, including PH taxis, in the shortest possible time. Thank you, Madam President.
Senator Deyalsingh.
Thank you, Madam President, for allowing me to partake in this discussion. Madam President, the incidents that the Attorney General relayed about persons having committed such atrocious acts, actually, I was looking at the media reports recently, and for the past month, it actually pained me to see what our citizens, what our ladies, mainly ladies, have to be undergoing. You know, it seems that we are not a civilized society anymore. But you see, Madam, it's not just in Trinidad. In the United States, there are about 900,000 sex offenders registered. So it's a global problem that we are facing, that we have to try to appreciate that, listen, something we need to do different, not just in Trinidad, but all over. The Megan rule, as was mentioned before, started when a young girl, a perpetrator, moved in across the road from her, and he had two instances of sexual assaults before. And if the parents had only known that, they would have been able to set their guard up. They would have been able to look at their daughter. They would have been able to be more vigilant. So it was really the voice of the people that resulted in this Megan's Law coming in to part and, you know, actually giving us these sexual registers, but just not in the United States. In the UK, there's what you consider the Sarah's Law, where a young girl, again, was snatched from playing in the playfield with her relatives, and her body was found mutilated. And again, the sex offender then had previous instances. So you see, it's a global problem. And you see, the terrible figures and the statistics we see, we may think that, hey, you know, we are in a bad way. But it's actually worse than that, Madam. Because you see, 3/4 of those sex offenders who are the sex offenders out there are never even brought to the forefront. So it's really a hidden epidemic. Statistics have shown that a lot of persons do not even come forth to say that they have been raped, to say that they have been violated. So really speaking, out there are individuals who are posing in Men of Cloth, about Boy Scouts, leaders, doctors. There are persons out there who are actually are great pretenders. They are pretending to be sometimes those persons in a jacket and a tie who may protect society, and very pious individuals. But we have to realize most of those individuals out there, 75% out there, are just waiting around. So this list, it's really, I think, well needed. But it is not to say, as other members mentioned, it wouldn't cause a major dent, because the majority of persons are not being caught. So therefore, this hidden epidemic, how do we get these? How would this help? Because remember, we have heard discussions where the recidivism rates may be, in a sense, in a way that, it may not, it's a low level of recidivism in those individuals. Some people quote 15% in contrast with general crime, which is around 30 to 40%. But remember, madam, those countries have better capacity to rehabilitate an individual. So those countries are an advantage. They have a system there. We here may not have that capacity, so we may be putting persons out there who, if we are not aware about them, are not aware about their past, about their deeds, we may be causing an injustice and not protecting society. So even when we say have and register, we have to understand a lot of those individuals are not even caught. A lot of those individuals are individuals who are out there. And even when you catch these individuals, the conviction rate seems to be very, very dismal. So you found that, when you looked at even figures in United Kingdom had some figures where the crime survey of England and Wales, 144,000 victims of rape or attempted rape, but only 55,000 were reported, and only 1,439 convicted. So therefore, the low detection rate is something that we have been seeing globally. And so therefore, we have to realize that those that we catch are only a minority. And that minority, we need to put the full brunt of the law to let persons see that the minority of those persons that we catch and go before the courts and are charged are persons who could serve as a buffer or as even as a preventative measure for others. The 75% people out there who are waiting, in the wings, who have done their acts, let them realize the law is coming after them. So you see, putting somebody's face in the social media, having that out there, having digital boards, newspapers, it sends out a fear or caution that that we can show that we are interested in showing the persons that we, as the government, as a state, as a government as a whole, with the population, willing to put measures in place. We wouldn't know the minds of a rapist who's going to be raping next, but we put systems in place and laws in place where we can certainly help the situation. So we have to appreciate that, a lot of the persons who actually escape justice are persons who may also escape by hiring a good lawyer. We may have cases where there are certain untouchables. So the few that we catch may with a good attorney, may with a delayed in the legal system, the judicial system, we may be actually letting out persons there who should have really felt the full brunt of the law. When I looked, Madam President, at the situation of the diluted effects, I'm thinking, of the reoffenders, diluted in the sense that the figures doesn't show the true picture. I'm thinking that, even though we have those individuals who are not being reported on, we have to get to those individuals. And we have to get those individuals because those are the individuals out there who are getting away. Now, the Me Too movement did bring persons to report instances. We also realized that if persons could get faith in the system, they may come forward more. I have seen patients in my clinic, elderly patients, older patients, I'm saying, that, when we go into the therapy, they have been raped as a child. They never spoke to anyone. They kept it in, and it presented with mental illness later on. So we have to appreciate that we may not be getting this piece of legislation is excellent. It's going to give us a register, but we will be missing out at a broader section of society. Those in the closets willing to just be hidden, not be known, we don't have any idea which persons are there. And I'm thinking, madam, we have to appreciate that, it's not just here. Right now in Belgium, there's a major problem where the legislators are now in Parliament trying to go after the change in the law. They actually realized that there was a rape recently, about 11 days ago, where five teenagers between the ages of 14 and 19 actually raped a young girl, and a 14-year-old girl. and it is presently causing an outrage, and the Belgian Parliament is thinking about actually looking at rape of a minor under the 14, increasing the sentence to 28 years. The significant fact is, madam, it was 5 teenagers between the ages of 14 and 19 involved in this manner. So even though some senators may say we have to protect children who are committing crimes, we have to realize more and more children are going out and doing atrocious crimes. About 10 years ago in the UK, a similar thing happened where 15 persons actually raped a girl in a stairwell. 15 boys between the ages of 13 and 19. And this girl actually almost killed herself. Now, the case in Belgium I mentioned, that girl committed suicide. 4 days after she was raped in Belgium, she committed suicide. So we have to appreciate the sexual offender can drive persons to have psychiatric illness, lifelong problems. They can also drive persons to actually commit suicide. So we have to put things in place. It's not just the Manu Benjamins who, in our society, who could keep 2 sisters captive for years. It's the ones that are looking, saying, good, the stepfather who goes through the mother to get at the daughters, the doctors who use their position, their privileged position, to go after children. Right now, there's a big controversy going on with the WHO. 2 doctors who were in Congo actually impregnated persons there. And the European Union actually was telling the WHO representatives that you have to have a better policy in place for handling your staff who comes here. So even though the doctors may come here to work or other persons may come here to work, we need to track them by this legislation. It was President Obama actually who had who had actually looked at legislation of having persons extended their boundaries for children. And he had passed that when he was in office to try to see if somehow he can reduce trafficking in children. So while we are looking at different persons having the means to escape one country to another. Some persons look at third world countries. We can come down there. We may not have good laws. They may get away. So they may use our third world countries as fodder for their activities. Now, Operation Global Sex Offenders Registry is also seeking to somehow have a link with the Trinidad and United Kingdom and other countries to link these offenders. So Operation Global Sex Offenders Registry, I'm thinking it's something that our CARICOM head, our Prime Minister, should probably motivate our CARICOM, our 15 CARICOM nations to go on this registry, to share this sort of information with other governments that, to look and put a curb to this. Not only do we have to have that register, but I'm thinking this register should not, the Attorney General said we shouldn't have the address of the persons. I'm thinking, no, put the address. If you have, you're saying that vigilante groups will come about, but there are laws in Pennsylvania, there's a law that if you go after these people and try to somehow have vigilante justice or go after them, you put laws in place to go after those persons. But why I'm thinking it is necessary, because even there's something called Safe Virtual Neighborhood. It's an app where parents will know if a child goes near a sex offender's address. We had cases where sex offenders lured children to their homes. So therefore, if we are thinking ahead, have the address. I see nothing wrong with putting the address of these persons here, on the list. Now, the fact that you have 2 lists available, I am wondering what, definitely one list may be for the police officers to have and the other list for public access. And I welcome the Attorney General in his closing comments when he said he would be considering looking at other things, like looking at revenge porn, looking at once you are charged for a crime, even though you get away, it's public knowledge. Have that list there so people can see, because sometimes the court cases and a good lawyer may let somebody escape. So these are things that I would be looking and hoping we can put in place. Madam, you know, the law has to change to keep up with what society wants. And our society, I'm saying, you know, there's a lot of those crimes here, crimes against women, a lot of crimes here that, you know, we hope that we can somehow be able to put a dent into it. And the thing is, if crimes like this, if legislation like this can help, it's really therapeutic jurisprudence where you are trying to make laws to see if somehow we can help society. And part of it I didn't agree with, Madam, is when, you know, not putting somebody retroactively. So putting somebody who, when the law comes about, persons who are already who already did crimes, I think they should be added on because those persons could still pose a danger. And if the whole idea of this legislation is to get persons who are dangerous, if you committed a crime before this law, you should be put on that. I think it was California, I think, had an issue where they were deciding to put on persons retroactively from when their legislation came about. And I'm thinking we may have to put that to protect, because the whole idea is to protect persons. Some countries have orange flag, red flags against persons' name to see if they may have a great chance of reoffending, but sometimes it's difficult. Even if we, as a psychiatrist, are going to do some sort of assessment, a very smart sociopath can fool us, tell us all the right answers, and still get away. So we have to be very cautious. It's better to let society judge that living amongst us is somebody who committed a crime. And as one of the senators mentioned here, that you know, we don't want, if the community is responsible, we don't want John to just be abused. We want the community to get involved. But we also need, if there's Jake in the community who is a mentally ill person who had done an issue before or a sexual offender before, we also want the community to know Jake lives amongst us. We will not discriminate against him. We will not go like vigilante justice against him, but we'll watch at him. We'll warn our daughters and whatnot and say, look, living across the road, don't talk to that man. If he's fresh at you, come after, tell us. So we have a duty to put this there. And even though I'm suggesting, even though somebody has a mental illness like exhibitionism, which I have seen patients in clinics come, even though you have those individuals, we have to, it's an illness. We say, well, he is there. It's just like somebody have diabetes. He is there. He has that. Watch our little children. He may expose himself. So the information could be out there regardless of any sort of mental illness, if not just to warn persons that living amongst us, we treat them with kindness, we treat them, we look if they're having a meltdown, call the St. Anne's ambulance ahead of them, but we look at them to understand living amongst us are good people, bad people, people who are offended. And you see, when Sarah's law in the UK came about, when Sarah in the UK, they found, the government, Gov UK, published on the 4th of April 2012, that they found 200 children were protected from potential harm during the first year of this child offender registry. So it has its benefits. It has its benefits, and I'm thinking that the benefits are there, and I'm supporting totally this bill, but I'm thinking we have to look at the other aspects where I'm thinking it's lacking. Madam, there are gang rapes that are occurring. We have to know that, even when you see the two instances I mentioned in Belgium and in the UK, I remember in last year, September 15, Pakistani Prime Minister, in a case which rocked Pakistan when an individual car broke down. She had her children there. She pulled up her glass. She put up her glass. She called for help. Two guys came, broke the glass, and raped her in front of her children. And the Pakistani president at the time suggested he would not mind even having capital punishment, the death penalty for those persons. But he said that because of the trade status agreement by the European Union, he cannot call for that. But he also make mention that he is in favor of even castration and chemical castration and whatnot. Nigerian state also, in around same September last year, there was a case where you had the persons there also calling to change the law when it was found, it was a public outcry, just how we had our public outcry there, where, you found that the Nigerian Prime Minister there, I don't know if it's Prime Minister or President, actually made a a commitment that anybody convicted of raping anyone younger than 14 years under a new law will be punished with sometimes, and he was looking at the death penalty. So even if the Attorney General wants to bring the death penalty for certain heinous crimes of rape, I will support the death penalty in that area, because I'm seeing persons are driven to suicide, persons' lives have been destroyed. And the aspect of having reporting. Statistics show sometimes 19% of women and 13% of men who are raped since their 18th birthday would not even report it. And this was a recent study by Tajden and Tionis in 2006. And it matched the studies before Bachman in 1998, where he found there was only 1 out of 4 rapes were really reported. So our problem as a society is how are we going to reach to those individuals who are potential rapists, the persons who are posing as good friends, as scoutmasters, as doctors, as persons of society. Those are to really get to them, you have to really educate people and children that, hey, you have to report it. We also have to, as I'm saying, to look out, as members say about the village, we have to also look out the fact that the fact that we have to know that the society will come down with a full hand of justice on those persons. Now, the case I mentioned, madam, in the UK, where the 15 boys raped this teenager in a stairwell over 1.5 hours and filmed it, actually filmed it. The judge at the case, Judge Wendy Joseph, actually did something which I found was excellent. Now, people may disagree, but she said she is going to name 13 of the 15 persons, because she, even though we want to protect children, she said the identification of those individuals, in her opinion, would deter others. So while children or young people may think they can get away and get away with anything, it comes like, if you do something bad, we will not name you, we will treat you good. You could go back in society. We're not going to put you on a register, but that is wrong. I'm thinking this judge used her discretion. I think we need more cases like that. I'm also looking at the fact that if we have cases where, I think it was mentioned, where somebody could actually go before a judge and ask that judge to not put their name down. I think this is dangerous, because you see, individuals with money to hire a good lawyer could now sometimes go to a judge and get away rather than another individual. So I'm thinking this law, this part of that clause there, I'm thinking we should not leave that under the discretion of a judge alone. You see, let there be a tribunal where a judge could sit with the victim or victim's relatives, also sitting with a, so you have like a tribunal really, be sitting on should we put this person's name at all. Don't let it just be. Let it be a judge, a lay member, and one of the victims and victims to be that part to say, hey, because persons could say people could still escape this list if they have enough funds to hire a good lawyer. Persons could still say, well, we would not be put on this list because of the dating. So that dating, I'm thinking, has to go there. The sexual offenses I'm looking at, the fact that it is caught up, as certain other members, into a lot of other things. We have to look at the fact that even as the Attorney General mentioned, he was going to look at revenge porn, corporal punishment, voyeurism. I will say we have to appreciate the fact that looking at pornography is also laid up with it. So he has to come with this. There are statistics and figures that show that if you are demeaning to certain persons, if you have that level of porn that exists in, that level of porn could actually affect the minds of the individuals and make them more prone to commit violent acts. So we had forensic psychiatrists come out with the opinion often that, imagery affects children. It normalizes sexual harm by portraying a lack of emotion, relationships between consensual partners, unprotected sexual contact. And also, there was Dr. Sharon Cooper, a forensic pediatrician and lecturer in North Carolina School of Medicine, says that what children see, they could mirror it, something called mirror neurons. And she says pornography is arguably more sexist and hostile towards women than other social images. And it can lead young men and boys to think that it's socially acceptable and even, go to, aggressively towards demeaning women. So I welcome if the Attorney General could also look at this, because remember, the Pornhub survey showed we are very high in Trinidad and Tobago among other countries in terms of looking at porn. So somehow we have to look at porn, go into the, affect the minds of the children and affect the children. I look at the pieces of legislation that the Attorney General brought, and the majority of it I would agree with, except the two exceptions I had given. I also agree with raising the, where it was, it was mentioned that he was going to raise the fine to 250,000. I think it was clause 20. And I'm thinking if you're going to raise that fine for persons who breach it, somehow that should be channeled back in to help victims of sexual assault. Help them with their therapy and whatnot. Just put it in the government coffers. Get some way of putting this back. And we have to appreciate that, we may have to look at the sexual offences registry as he mentioned it. So he mentioned the register could be one for the public and one for private. Now, a lot of individuals may see a person who may be tending to be a sexual predator. I had a patient, a young girl, she was a teenager, and she was totally psychotic, schizophrenic. And in her periods of lucidity, she mentioned she was raped by her father. And she was raped by her father. So probably that caused her to trigger this mental illness. But what was very significant, during her period of lucidity, she mentioned to me that that father is now in another marriage with 2 stepdaughters. How are we going to warn that person, that new person in the relationship that we highly suspect? We had no proof because this girl was mentally ill. But the fact is, she did mention she was worried for these 2 stepdaughters because they all grew up in the same village. And in that way, we may have to put a sort of a list where persons could be put on that list when people could call. Just as how we have the Me Too movement, person could call and said, look, this teacher was inappropriate.
Senator Deyalsingh, you have 5 more minutes.
Thank you, Madam. That this teacher, this scoutmaster, this person made inappropriate comments to me. You call into the police commissioner's register department and say, listen, let us put somebody on that list. If I have a patient who said they were molested by a neighbor years ago, I would say, call in still. Now, we may not have the evidence, you cannot go after those people, but they are on a list. So if any future crimes occur, the police will have that private list where they could check back and say, well, listen, this guy had a history there. So we may have to get that list to get these closet rapists that did their harm, looking around, and it could be managed by the police commissioner actually to have it there in case any new rapes or come in the future, they can go back and check this individual. You see, Madam, this is really an event, I think, that today, having this register, I think it's needed. I think we have to even, as I say, expand it in the sense, I think, to put that address, expand it if you think people are going to misuse it for vigilante justice. But you see, the world has moved also for other registered lists. There's something called Clare's Law in United Kingdom, where for domestic violence, there was this lady who actually died in the hands of a lover, an ex-lover. And the parents agitated for Clare's Law, where they said, if you have domestic violence and you know that individual is such, you should be able to, the police would have a duty to warn that individual, or individuals could have the knowledge, you could approach the police officers to see if you can get that list. That will help us in domestic violence. So the Attorney General may have to look at something like that in our Domestic Violence Act, because we're already on register. So have a register of violent persons who are on that list. And you know, Madam, recently Australia and some parts of Canada also took that principle. So Clare's Law was really, was a policy, but other countries put it in as part of their law. And so the whole idea of having registers, having lists, is really to protect society, to protect a victim. And I'm thinking, well, it's not just Trinidad and Tobago, it's all over the world. We have attacks on women. Government have to ensure that we have the laws to prevent and deter, because the government cannot know what's going on in every rapist mind, or who will do it, or what's going on in people's doors. But government owes it to put laws like this, to put laws where no one can escape, to have quick justice, to educate persons, the society on toxic men, to educate the females that, there are persons out there. You all are victims. You could come, you could empower yourself, you can call in. And in conclusion, I'm saying, I welcome this piece of legislation. I think my dilemma, sometimes I treat both the victim and both a rape person, but I'm thinking, what is going on now? We need to strike that balance on the side of the victim until we could, ease up that social distress that persons are facing. Thank you, Madam President.
Senator Dillon-Remy.
Thank you, Madam President. Madam President, I am pleased to be given the opportunity to contribute to the Sexual Offences Amendment Bill debated here today. This bill certainly highlights an issue of great concern in our society, and it has been of great concern for a while, but specifically after the recent rape and murder of two of our nation's daughters, names that are well known, it is even more important. In perusing this bill, two overriding questions came to mind, namely the fairness of the initiative and the effectiveness of sex registries. Both terms have been discussed by previous presenters. These comments are of relevance to Clause 7 of the bill that seeks to establish two registers to be known as the National Sex Offenders Register and the Public Sex Offender website. In researching the efficacy of sex registries, I read several reports and research papers, some of which give evidence statistically about the value of registries. Others present information to the contrary. In an article entitled Trends and Issues in Crime and Criminal Justice by the Australian Government, Australian Institute of Criminology number 550 of May 2018, this article stated that there is little evidence that registries have reduced reoffending among registered sex offenders. In fact, some studies have shown that registries increased sex offense recidivism. Conversely, there is some evidence that registries act as a general deterrent to first-time or non-convicted sex offenders in the community, likely due to the perceived risk of being placed on a public register. In another article entitled Rethinking Sex Offences Registry by Eli Lehrer, published on the website www.nationalaffairs.com, article number 47, the spring of 2021, that article stated that the practice of requiring sex offenders to register with law enforcement officials is effective and has contributed to a sizable drop in sex offenses committed against children in the United States. A report published by J.J. Prescott of Jonah E. Rock of the University of Michigan Law School in the Journal of Law and Economics stated that notification laws reduce the number of sex offenses when the size of the registry is small, but that these benefits dissipate as more offenders become subject to notification requirements. This pattern is consistent with notification deterring non-registered individuals, but encouraging recidivism among registered offenders, perhaps because of the social and financial costs associated with the public release of their criminal history and personal information. Further, they found non-public registration of convicted sex offenders significantly decreased the overall numbers of sex offenses. The reductions were primarily observed for sex offenses against victims who were known to the offender, namely friends, acquaintances, and neighbors, rather than among strangers. Madam President, I turn to the experience of the CARICOM region. It was reported in the Bajan Reporter on June the 14th, 2021, once properly implemented, the Caribbean Committee Against Sex Crimes, a group founded in 2014, expects the presence of a public sex offenders registry to deter new sex crimes in Trinidad and Tobago. The article went on to state that the Caribbean Committee on Sex Crimes encourages all CARICOM member states to review this bill and consider adopting some of its provisions in order to help deter sex crimes regionally. The general consensus seemed to speak more to the usefulness of the registry than not, needless to say. I think we are on the right track with this initiative, but the full success of it depends on proper implementation. Mr. Vice President, the article in the Bajan Reporter continued and outlined a few recommendations from the United Nations Office on Drug and Crime and the World Bank 2007 report. Their report entitled Crime, Violence and Development, Trends, Costs and Policy Options in the Caribbean. These recommendations can be used to buffer our current sex offenders registry initiative and add to its efficacy. Some of these recommendations include: 1, the need to standardize best practice for sex offender rehabilitation to reduce recidivism and facilitate rehabilitation regionally. Policy should cause any CARICOM national who is a sex offender to register with the rehabilitation centers in the respective state they may choose to migrate to. 2, the establishment of an amalgamated database of convicted sex offenders in CARICOM to be shared with IMPACTS, that's the Caribbean Communities Implementation Agency for Crime and Security, shared also with Interpol and the U.S. Angel Watch Center in line with international best practice. A similar point that was made by Senator Seepersad in her contribution about getting international involvement. Number 3, model legislation for police-level sex offenders registry should be standardized throughout the CARICOM. Legislation should expressly stipulate provisions for international notification in line with best practice and for registration of sex offenders who commit crimes outside of the region. Number 4, standardize a policy for supporting victims of sex crime within CARICOM. And 5, encourage nation states to reform court systems in order to fast-track sex crime cases. Senator Hazel Thompson made that point very clearly, given what is happening within our systems here in courts in Trinidad and Tobago in terms of the length of time taken for commitment. Those were the 5 recommendations. In considering the fairness of this initiative, I reviewed the comprehensive qualitative analysis prepared on behalf of the Center for Child Rights in 2018 entitled The Benefits and Detriments of Sex Offenders Registries, which highlighted that the collateral consequences of sexual offender registration are profound and extend far beyond the individual offender to family members of registrants who often experience the social isolation and feelings of shame associated with the registration that limits their access to socially valued resources and infringes on their capacity to contribute and participate within their communities. Again, in keeping with the presentation that was made earlier on, that putting a sex offenders registry causes issues not just with the offender, but with their families. And therefore, we have to think of the complications that can be caused, so that when a registry is put in place, we must make sure that every effort is made to decrease the collateral damage. I continue. Research commonly categorizes the main challenges facing offenders as being unemployment, residency restrictions, and isolation and stigmatization. When experienced simultaneously, these challenges combine to cause sex offenders to lose their social and capital support, thus destroying family relationships, causing mental health issues, and often resulting in suicide. It is therefore not surprising that many offenders see registration as additional prison sentences, as they significantly limit the freedom experienced by the offenders post-prison release. Resulting from a destroyed relationship between offenders and the state, registration may even cause offenders to rebel against the system, leading to increased recidivism. So in the light of this, it really is important to consider the presentation made by Senator Hazel Thompson that talked about restorative justice, that talked about ensuring that there is a system in place for making sure that at least an attempt is made so that persons who are convicted of sex offenses can be given an opportunity for rehabilitation. And therefore, it is not just putting the sex offenses register there and expecting that expecting that it's going to have its result without any additional aspects being put into place. Mr. Vice President, there was an article on the Express newspaper dated 8th of February 2021, which stated that an unofficial sex offenders registry had been created to red flag men who have been charged with sexual offenses. The Registry of Violent Offenders Against Women in Trinidad and Tobago was established by a group called My Trini Experience. And their link, mytriniexperience.com, provided a database of persons who were charged and named in newspaper reports. The alleged offenders' names and photographs are in the registry, and a link to the news story was reported, which reported the charge. The page clearly stated that it was not an official government information site. They also stated that all persons are viewed innocent until proven guilty. Yet, they had no problems putting it on their website. They had so many negative comments that were posted online because the persons who were on that list included many well-known personalities. It seems as though the comments were so negative that the website seems to have been taken down since that time. I think it was Senator Hazel Thompson again who talked about the matter that concerns Trinbagonians getting information that is supposedly not for public consumption and having it and talking about busing a mark. The question is the fact that this registry, which is supposedly the part that is supposedly not for public publication, making sure that the Commissioner of Police ensures that the information that is there does not get into the public domain by whatever means. And I do thank the Attorney General for putting on the provision that says that any person who intentionally and without lawful excuse or justification alters, disposes, reproduces, shares, or uses any information published on the website referred to in Section 1 commits an offense and is liable on summary conviction to a fine of $25,000 and imprisonment for 3 years. I am not sure how it is going to be done. In other words, what systems are going to be put in to make sure that the registry is kept in the manner that it's supposed to be kept. But I am asking the Attorney General to make sure that whatever is put in the bill, that there, in other words, not just consequences for disclosure, but making sure that disclosure does not happen by putting systems in place. Mr. Vice President, I would not be much longer. I understand the initiative, and I acknowledge that it is necessary to put such a sex offenders registers in place. My main concern is making sure that we do not put into as a result of this, make sure that other persons are going to be harmed by what we are doing. And as far as the matter that concerns prevention of recidivism, one of the central issues that is at the helm of this issue remains whether putting a person on the registry and their removal subsequent to their sentence being spent, whether it guarantees that a person would not reoffend. So therefore, while I support the initiative, I say again, rehabilitation is the key to ensuring that the recidivism rate is lowered for sex offenses. As such, measures which offer therapy and offer assistance to offenders should be an important consideration. If our goal is building a better future, the emphasis ought to be encouraging change in these individuals to the extent that they can become healthy and reformed members of the society. And again, Senator Thompson-Ahye made a great point of this in her contribution. Mr. Vice President, after all, many of these people continue to be a part of a society. So if we don't make any efforts at rehabilitation and have them just convicted, it will mean that we may just have a set of exiled people who either continue or they remain in exile and are unable to be important contributors to the society. So, Mr. Vice President, I thank you for this opportunity to have this short contribution on this bill.
Senator Nakhid.
In the name of God, most gracious, most merciful. Mr. Vice President, thank you for the opportunity to contribute on this very important bill, Sexual Offences Act. And I will not be long and nor contentious, since I think it's something that's very important given our history as a country and what has transpired most recently. Now, I must say, on doing research into this bill, it would have been very rough waters for the Honorable AG to navigate in drafting legislation, because something like the Sexual Offences Bill or the Sexual Offences Act has so many layers that are nuanced, because upon research, there's nothing more complex than the human psyche when it comes to these kind of offenses. And I will go into that because a lot of the speakers before me touched on a variety of issues. But I would like to go more in depth into some of those things. We heard the previous Senator Remy speak about rehabilitation, as most people have, because it's a very fine balance, Mr. Vice President. You know, do we deal with rehabilitation? How do we balance that with trying to avoid recidivism. You know, it's a very, very complex issue. And I must say I was torn. I was torn because I have my own preconceived notions, and I believe, and I've always believed this, that once someone commits an act of rape or child sexual abuse, he should be given the maximum punishment. I have kids, as so do most of the people here. So I was really torn. And then I said, you know what? Rather than reach to the point where we are in the penal system, where the act has been committed and we have to consider now rehabilitation and how do we balance that, and whether the sex offender registrar and all of that I will go into, what about the actual developmental experience of the people that we are dealing with? And there have been studies that address those things. And I thought maybe, as a suggestion, since I think we are in agreement with, in principle with the legislation, as a suggestion to the Honorable AG in drafting the legislation to perhaps look more at the developmental experiences of both child sexual abusers and rapists, and there have been studies done. And maybe that will determine how we go further in addressing actual penal system and the rehabilitation of said. Because I'm talking more about a preemptive action. And I think the studies have shown, for example, there was a study made in 2000 by R.K. Bergen and K. Bogle, which looked at the relationship between sexual violence, and some people touched on it, but I intend to go more in depth, sexual violence and pornography. Now, I've heard about, and I heard about this when I was abroad still, that Trinidad was #1 and so in per capita in how we consume internet pornography. But when we look at that, we never look at the women's experiences of how the sexual violence and the abusers' use of pornography, the relationship, the abusers of the woman, and that use of pornography that probably precipitated them to commit those actions. So a study was done by the aforementioned R.K. Bergen and K. Bogle, and it was a study at a rape crisis center for about 100 survivors. And I say survivors loosely because does one really survive rape? And that's why I talk about it's very nuanced, it's very difficult. Because sometimes a rape, a murder is cut and dry. Somebody's been murdered, but a rape is something that lives on. Women don't handle it. They end up sometimes themselves being abusers. I mean, it was a very, very complex research into this matter that I was astonished myself. It seems to me that it's as almost, it cannot be one blanket, one size fits all, because every case is so unique. So someone might commit an act, and that person can be rehabilitated. Someone in the same circumstances can commit the same act, and they cannot. So how do we approach it? So my suggestion is that we look at the studies. We look at the studies. There can be nothing definitive. Most times might be a hit and a miss, but at least we could be guided. So they looked at 100 survivors at this rape crisis center, and the findings concluded that 28% of respondents reported that their abuser used pornography, 28%. And that for 12% of the women who survived, pornography was imitated during the abusive incident. And that says a lot. So now we have, as a society, have to make some kind of bold, I would say, because how do you control, how do you monitor our consumption of pornography? Nobody went into detail how we do that. How do we do that? Because all my research shows that pornography actually rewires the brain, especially among our young kids. It's actually rewiring of how we view relationships, how we see the sexual act, how we see women. So it comes to gender equality, because pornography is such a journey from the realities of relationships and sexual relationships, that we find that men, because of the visual instant gratification that pornography provides, they tend to end up frustrated in relationships, dissatisfied in relationships, and that eventually turns, in some cases, not all, into violent acts against women. And in young men, young boys, there's an increase in sexual dysfunction, erectile dysfunction. So, as I said before, my contribution today is more to offer in a line of suggestions that we deal with it in a different way from the rehabilitation side, but try to find solutions from the actual developmental experience of the people that commit or would probably commit these acts. In another study reported in May 2008 by Dominique Simon, Sandy Wertel, and Robert Durham, where their in-depth study of that development experience that I'm talking about was more in-depth. They looked at 269 sexual offenders, divided into 137 convicted rapists and 132 child sexual abusers. And they did a comparative study. So the child sexual abusers reported more frequent experiences of child sexual abuse, 73%, early exposure to pornography before the age of 10, of 65%. And sexual activities with animals, 38%. Okay, so from these studies, what we can bring is that the child sexual abuser, his dysfunction was related more to almost a compulsion or a maladaptive character in terms of how he would see that sexual experience. That's a child sexual abuser. Unlike the rapist, who most of the time was subject at a young age to physical abuse, 68%, parental violence, 78%, emotional abuse, 70%, and cruelty to animals, 68%. So you see immediately, it's not a one-size-fits-all. Even among sexual offenders, you can look at them from a different perspective. So my suggestion is, as we draft legislation, we have to keep an eye on how do we mold development, sexual development. Do we attack it through the schools? Why not? Do we have a more public awareness campaign through churches, through community groups. I think that's extremely important. We don't pay enough attention to how it takes a village not only to raise a child, but to mold that child, to bring him into society in a normal way. Because this is important. I think we need to remove the taboo that we have of the sexual experience in Trinidad and Tobago. We need to speak more about it in the schools, in the churches, in community groups. Only then that we have sane and more focused contributions as it relates to how we speak with our young men and young women indeed. Mr. Vice President, I heard about, as we examined about the sexual offenders registrar and so, and this also was so difficult to pin it down. You know, some people, I've seen it here that the COP, Commissioner of Police, that it would fall under his jurisdiction, his discretion, and he would be privy to that. And I'm asking why we would give that exclusively. I mean, this Commissioner of Police doesn't have quite a lot of things that he's already involved in, and I mean, why? For example, so that registrar is under his purview exclusively, more or less. And we have somebody who wants an exemption. They want to know something, and it takes time. It takes time. And somebody commits a crime in that period of time. Is the state then liable? Why not? Why not have an independent board to determine on this sexual offender's website? A group of people, for example, of course the Commissioner of Police will be there, a judicial officer, a probation officer, for example, to expedite matters quickly. So people ask for an exemption, they want to know, and that is available to them in quick time. So people can put themselves in order. Because God forbid, again, if something happens while they have applied, and it takes time, the bureaucratic process, and I think we see everything is stalled. You know, there's always a bureaucracy that we need to get around. I think in matters like this, there should be some measure of expedition. So I thought about that, and I thought, why not have an independent board, and it can be done to help the Commissioner of Police. Then I said, okay, upon consultation, why not also have, if we want to pay attention or to be concerned with the rehabilitation aspect of it, and also with the anonymity of the victims. We have to protect their right to privacy. So we don't want to have it, of course, open and everybody knows. What about if we have some kind of tracker where we have, you go on the website, and this is if we make it open to the public. I'm giving options here. And on that tracker, you have indicated where, in what area, for example, if you're in Diego Martin, you would have on that tracker, well, in this area of Diego Martin, there's a sexual offender. In other words, it protects the rights, because people in Trinidad is small. A lot of the sexual offenses are committed against your own family. We know all of this. So what it does, it gives an indication that in this area, particular area, a sexual offender lives. Now, I know it's not a perfect solution, and I said that before. There's nothing definitive, because someone might say, in response to that, it could create a lot of suspicion within our community. And that's a fact. But what do we do then? We list the name of the offender. Doing that, in my opinion, also makes it almost impossible after that for him to be seen by the rest of the community in any kind of positive light that could help with his rehabilitation. So I'm thinking all of these things that we would need to consider when we draft legislation, and why it's so important not only to look at when these people have entered the penal system already. We need to start looking at how do we prevent the act, and that all has to do with the developmental experience. So one of my last points, Mr. Vice President, I think that as far as we keep about the point of keeping records, I think the case of was mentioned earlier of one of our two daughters who was recently killed, and as the suspect held, it turned out that he had a lot of cases pending against him. But as a matter of fact, a lot of those matters were dismissed. I don't want to call names. I heard it's not sensitive to call names. But one of these accused, there were a lot of matters pending against him, and most of these matters dismissed were because there was a lot of lax action on the part of the police, who did not show up for the case and so. And again, to keep records accurate, we have to put a duty on the police to report the outcome of the case and keep up with the case. And in my opinion, perhaps attach a criminal sanction, just as a fine, so that people pay from their pockets when they don't comply. How else are we going to keep up with records to make sure that some of these offenders do not get out lightly? Because he got off eventually because the matters kept dismissing because police officers were not showing up until he got bail. And allegedly committed a crime. So, Mr. Vice President, again, I know very difficult waters to navigate, to draft legislation concerning this, but these are some of the factors I think would be important for the Honorable AG to consider when drafting legislation on such a nuanced subject. And so, I don't know, maybe I can suggest while we have vaccinate to operate, don't ask, wear your mask, maybe for the AG to take in consideration, legislate for legacy, for example. I know the government likes all these sound bites, so legislate for legacy. In other words, not only about people being in the penal system, but trying to attack the problem from the developmental sides of things. And of course, we look forward to supporting this with suggestions that we will make. I thank you, Mr. Vice President. Thank you.
Honorable Senators, before I call on the next speaker, permit me to return to item 3 on the order paper. The following correspondence has been received from Her Excellency the President, Paula May Weeks, ORTT. The Constitution of the Republic of Trinidad and Tobago, by Her Excellency Paula May Weeks, ORTT, President of the Republic of Trinidad and Tobago and Commander-in-Chief of the Armed Forces, to Ms. Renuka Rambhajan. Whereas Senator Anil Roberts, who is incapable of performing his duties as a senator by reason of illness, now therefore I, Paula May Weeks, President as aforesaid, in exercise of the power vested in me by Section 44(1)(b) and Section 44(4)(b) of the Constitution of the Republic of Trinidad and Tobago, acting in accordance with the advice of the Leader of the Opposition, do hereby appoint you, Renuka Rambhajan, to be a member of the Senate temporarily with effect from the 15th of June 2021 and continuing during the absence of Senator Anna Roberts by reason of illness, given under my hand and the seal of the President of the Republic of Trinidad and Tobago at the Office of the President, St. Anne's, this 15th day of June 2021. Honorable Senators, the Senator is required to take the oath.
I, Renuka Rambhajan, having been appointed a Member of Parliament, do swear that I will bear true faith and allegiance to Trinidad and Tobago, will uphold the Constitution and the law, and will conscientiously and impartially discharge the responsibilities to the people of Trinidad and Tobago upon which I am about to enter. Senator Mark.
Thank you, Mr. President, Mr. Vice President. Mr. Vice President, we are very happy to contribute at this time to the Sexual Offences Amendment Bill 2021. And Mr. Vice President, in going through this bill, I sought to determine what is the mischief that the government, through the Attorney General, is seeking to cure. What was the objective of these provisions contained in this piece of legislation. Is it an attempt to continue along their merry way or path in promoting as a policy suppression and the promotion of punishment? Or is it a change of course and look at this issue as a public health issue and focus on prevention, rehabilitation, and reintegration? Mr. Vice President, the core, the root cause of sexual violence lies in gender inequality in our society. And unless, Mr. Vice President, this issue, this principle is addressed, then sexual violence will continue to haunt our civilization and our nation, since it is deeply rooted in power relations and control. You know, gender equality has been defined as the state of equal ease of access to resources and opportunities, regardless of gender, including economic participation and decision-making, and the state valuing different behaviors, aspirations, and needs equally, regardless of gender. That is what gender equality means. Mr. Vice President, it is about rights, opportunities, benefits, and obligations. And unless we focus on these fundamental issues, by focusing and addressing these matters and targeting our children and youths in particular, along with the adult population, this violence against our women folk will continue. And therefore, Mr. Vice President, I believe it's very important that in dealing with this matter of sexual offenses, we need to pay attention to the reality, the roots that give rise to this particular development. But I will show you in my presentation that the government continues to focus on punitive and suppressive measures in order to address issues and problems such as sexual violence and sexual offenses. Mr. Vice President, I was hoping that the Attorney General would have given us an update on the 2019 piece of legislation that we spent hours debating, crafting, fashioning, and eventually unanimously passing. It is known as Act number 19 of 2019. I thought the Attorney General would have taken the time off to share with us where are we as a society as it relates to this issue of sexual offenses. Mr. Vice President, in this Act 31, Act 19 rather, of 2019, we advocated, articulated, and advanced the inclusion of the generation of an annual report on the administration of this Act. And if you go, Mr. Vice President, to Section 67A of this piece of legislation, it says that the minister shall cause to be laid in both houses of Parliament annually a report on the administration of this Act. Mr. Vice President, this Act was assented in September of 2019. We are now in June of 2021, almost 1 year and a half, and there is no report in our library. No report has been tabled in this Parliament. In addition, Mr. Vice President, in this Act, Section 68, the minister is supposed to table regulations to govern this piece of legislation. This is under 67 sub 1, 2, and 3. Mr. Vice President, I have searched. I have gotten a headache in searching. And up to now, I cannot see those regulations. So the Attorney General has been sleeping on the job. And he comes here today for further amendments to the Sexual Offences Act, and the Attorney General has not brought to this Parliament the annual reports, so that we as parliamentarians can do an overview, so that we can assess and evaluate where we are. So when we look at this piece of legislation before us, we can say, Mr. Vice President, look, the Attorney General is on the right track. Because we are seeing errors, we are seeing mistakes, we are seeing deficiencies. But nothing, Mr. Vice President. So that is why I asked the question very early, Mr. Vice President. What was the mischief that the Attorney General and the government seeking to cure? What was it? Because we have nothing before us to go by. He has violated and breached the law by refusing to table the annual report, which is a breach of the law. The Attorney General and the government has failed to table the regulations to govern this piece of law. But they have come with new amendments, Mr. Vice President, before us today. Mr. Vice President, I want to let you know that this matter was subject to intense scrutiny and widespread discussions involving the public sector, civil society organizations. We were all involved. And Mr. Vice President, at the end of the day, we all agreed that there is need to establish a national sex offender register. So it's there. It was in the 2000 Act that Ramesh Lawrence Maharaj, then Attorney General, piloted. And it was repeated, Mr. Vice President, in the 2019 legislation. So, yes, a national sex offender register is there. The public sex offender website was also established. But, Mr. Vice President, you know why the Attorney General came with this piece of legislation? And he has admitted, confession is good for the soul. So the Attorney General confessed today that the reason why he has brought us here is because he wants to populate the National Sex Offender Register. He says that there's only one convicted sex offender in the National Sex Offender Register. So the purpose of our meeting today is to pass legislation so that the Attorney General would look good. And in doing that, Mr. Vice President, the Attorney General has intruded, has invaded the sacred spaces of the judiciary by seeking to remove the discretionary powers of the judges in determining matters that are before them, that come before them when somebody says, I want to be exempted from my name. I want my name to be exempt from that sex register or National Sex Offender Register. And unless you make that application, your name will be down in that book, in that register. Mr. Vice President, let me make it very clear. People who do the crime must do the time. We have no problem with that. But do not trip and contravene fundamental rights and freedoms. Do not seek in your haste to bring about what you consider to be a population of the National Sex Register, and now you have created something called the Public Sex Offender Register. Do not trip over citizens' fundamental rights and freedoms, and do not trip over and breach the principle of the separation of powers. We have to be very careful how we are operating in this place. This government constitutes a clear and present danger to our democracy and the rule of law. And we must look at these pieces of legislation very, very carefully, Mr. Vice President, because I am very disturbed as a member of this Honorable Senate. And I'll tell you why I'm disturbed. I am seeing, Mr. Vice President, a trend that has emerged in the last 6.5 years of this administration. And that trend tells me that when it suits the whims and fancies of this administration, they emasculate our Constitution. And you know what they do, Mr. Vice President? Legislation and acts of Parliament that require a special constitutional majority are removed. So rights and freedoms are removed. And you bring what is called simple majority legislation. Mr. Vice President, that is frightening. And you know, the Attorney General, in an Express article sometime this year, I can't remember the exact date, the Attorney General is on record as saying he's going back to Cabinet. I know why he's going back to Cabinet. Because he wants persons to be on the National Sex Offender Register and that website only on the basis of their being charged. So we have moved, Mr. Vice President, from somebody being convicted, and the Attorney General admitted today that one of the pieces of legislation that he would like to bring before us in this Parliament is a piece of legislation, Mr. Vice President, entitled the Sexual Offences Amendment Number 3 Bill of 2021, which seeks to introduce a registrable offences charges registered in relation to person charged with registrable offenses under the Sexual Offences Act. Mr. Vice President, this is not only lunacy, it is utter madness. And when I looked at this piece of legislation, I have it before me, I don't see a constitutional majority included here. But the Attorney General has admitted today that not only is he interested in bringing legislation to create a register on citizens who are all innocent under our Constitution until proven guilty, the Honorable Attorney General goes further. He says, I want to reintroduce flogging in our nation. He said flogging is needed. So he's bringing a bill called the Corporal Punishment Offenders Over 18 Amendment Bill to reintroduce flogging. So when you are charged with a sex offense or a sexual offense, you will not only be in jail, Mr. Vice President, for 5 years and charge maybe $300,000 or $150,000, but you may get 25 lashes with the cat o' nine or the cat o' tail, whatever they call it. But you will be beaten. So the Attorney General is living in the past. I have the two pieces of legislation here that they have circulated for public consumption and for comments. And he admitted today, the Attorney General admitted today, Mr. Vice President, that he's interested in introducing a bill that will bring flogging back to this nation. I want to tell the Attorney General that flogging is something of the past. What we know as corporal punishment is something of the past. And I want to let the Attorney General know he must live in the 21st century and not go back to the Stone Age. That Stone Age thinking. And further, if you want to tamper with people's constitutional rights by putting them on a register and making their information known to the public, you are infringing sections 4 and 5 of the Constitution. It is reprehensible, highly dangerous, and disturbing for an Attorney General who is supposed to be the guardian of our democracy to be bringing legislation to this Parliament that requires a special constitutional majority, and it brings a simple majority. Mr. Vice President, may I remind you that in 1986, when Russell Martino was then Attorney General and he introduced the Sexual Offences Act, he brought that bill with a constitutional majority of 3/5. When Ramesh Maraj introduced an amendment to that act in 2000, it required a special constitutional majority of 3/5. When we debated in 2019, the month of February, and this thing was passed in June, assented in September, that bill called Act number 13 or 19 of 2019 required a special majority. The Attorney General has come to this Parliament today with some very dangerous proposals. One, making the judges place you as a sex offender on that list, on that register. If you do not seek an exemption and go to the High Court or the Court of Appeal, your name goes there. And they are telling the judges, you have to do it. You are ordered to do it. I want to tell the Attorney General that that is dangerous. I want to bring to your attention a very powerful statement made by our friend, Senator Anthony Vieira, when we were debating a report on this same bill in 2019. I could never forget, as long as I live, the infamous Clause 11. It is known as the doctrine of recent complaint, which the Attorney General introduced on the floor of the House, and I termed it ad hominem legislation at the time. And I say today, if we did not stop that Attorney General from introducing this measure, somebody would have been in jail today. And I know who the person is. I won't call the name, but I know who this thing was directed at. Where the judge was being told by this amendment what to do and what not to do. Hear what Senator Anthony Vieira told us. He said, and I quote, this is a report, but he's speaking on the report. We were in committee stage when this thing was sprung on us. He said, and I quote, I think it is extremely important that we must be careful when legislating a judge's duty, because a judge has a duty to sum up a case and give particular directions. And I do not know if it is proper for us to legislate what direction a judge should give in any particular matter. And I just want to register my dissent, Mr. Vice President. That was the statement made by Senator Anthony Vieira when this thing was parachuted in a committee stage of a bill called the Sexual Offences Amendment Act 2019. Mr. Vice President, we are doing the same today. We are legislating. The legislature is legislating and telling the judiciary how they must go about sentencing citizens in this republic. I will have no part of it. We will have no part of it. We will oppose it. We will not intrude on the sacred spaces of the judiciary and the separation of powers. And this Attorney General has been infringing and incrementally reducing rights and freedoms of our citizens on some pretext of something called surat. Everything is surat. Everything is proportionate. Everything is legitimate. And I'll tell you in a short while what the Court of Appeal of this country said in April of this year on a judgment dealing with the same surat and dealing with the same matter of proportionate. It is proportional and proportionate and legitimate. And why is it telling you that, Mr. Vice President? Your rights have been eaten away. So I want to tell the AG, even if you're right, and you say that this bill, Mr. Vice President, does not require a special majority, haven't you read the Court of Appeal judgment? You want to see a copy? I can make a copy available to the Attorney General, Mr. Vice President.
Senator, you have 5 more minutes.
Right? Look at here. Civil Appeal number S246, 2020, between Dominic Suraj and the Attorney General and S. Maharaj and the Attorney General. It's here. I have the judgment, Mr. Vice President. So let me give an advice to the Attorney General through you, Mr. Vice President. We have a system of laws in this country that is the embodiment of the rule of law. We have a constitution which guides this parliament on how it should pass law. It requires a special majority in certain circumstances where constitutional rights are offended. Every previous Attorney General, including this one, in this country, Mr. Vice President, has seen the need to use a special majority when it comes to regulating this area of law concerning how these things are treated in the context of sexual offenses. The question has to be asked, Why would the Attorney General want to encourage litigation against the state by passing a bill that requires a special constitutional majority with a simple majority? It is as if the Attorney General likes to spend taxpayers' money to defend challenges and then claim confidentiality so that we, the taxpayers, do not know who got what by failure of disclosing who the Attorney General has paid, how much he has paid to those lawyers, including his own family law firm. Mr. Vice President, why risk this legislation being struck down as being unconstitutional? Why risk taxpayers' money going to waste? The Attorney General must act in a manner befitting the office of the Attorney General and act responsibly. Mr. Vice President, the AG, of course, will claim the defense and use Surat and push his own brand of Suratism in our law. Yes, we are bound by Surat. But, Mr. Vice President, the Court of Appeal recently, in April of this year, commented on this Surat approach and said simply assessing if the law was proportionate and using that as the excuse to pass laws as these with simple majorities is wrong. The Court of Appeal said that that approach was dangerous. That is what the Court of Appeal said in adopting the minority view of the Barry Francis case, which is the view that we on this side advocate for. The Court of Appeal in April of this year stated in paragraph 123 of the Dominic Suraj case, and I quote, "We are inclined to adopt the minority view. Reading into the Constitution material that had not been placed there by the legislature is both wrong in principle and dangerous. It will result in empowering the legislature to whittle away fundamental rights by asserting that there were legitimate aims that evade precise definition. We are nonetheless bound by the decision of Surat." End of quote. The Court of Appeal has described in our view exactly what the AG has been doing over the last 5 to 6 years. Whittling away rights because he thinks it serves a legitimate aim. Mr. Vice President, while the Court of Appeal is bound by Surat, our Attorney General is not so bound. He has a choice as to whether he can bring legislation and seek a special majority. He has chosen not to do so. One day, Mr. Vice President, when Surat is overturned or clarified, this country will be left in a legislative miasma. Mr. Vice President, we will be in this position because of our Attorney General, this Attorney General, where a number of laws will all at once become unconstitutional, and that will be the legacy of the Attorney General, Mr. Vice President. Mr. Vice President, I want to thank you for giving me this opportunity, but I want to tell the Attorney General, you cannot continue how you are going. We need, if you want this bill passed, insert the special majority. I thank you, Mr. Vice President.
Minister of Agriculture, Land and Fisheries.
Thank you very much, Mr. Vice President. Mr. Vice President, my colleague and friend, Senator Mark, has been in this Parliament for 3 decades. I've seen him in action on the floor of this House. I've seen him in committees. And I must say it's the first time I've seen Senator Mark read from a contribution. The end is really near. Somebody has put words in my friend's mouth, and he simply does not understand what he said. He's read it. He even had to read from a piece of paper, Mr. Vice President, to address you as Vice President. That is not the Senator Mark I know. I mean, the earlier part had trademark Senator Mark. I'll talk about that. But the last part there, the day in which Surat will be overturned and all of that, that is not my friend. In fact, Kenneth Surat, with whom I spoke yesterday, and I've been speaking very often, I mean, my friend Senator Ramdeen, as he done was, he brought Surat here. He introduced me to Surat. And we've had a Surat opposition. But somebody wrote that script for my friend, and I must get to the bottom of it. The part that I understood was vintage Senator Mark. Vintage Mark. And again, it brought back memories of last year, April, when we brought the first COVID-related legislation into this House. And from then on, I heard border closure, infringing, doing disenfranchising, Section 4, Section 5, the whole range. Everything we did in relation to COVID was a threat of constitutional warfare and litigation and all of that, only to see a string of losses in the court. Waste of time. You've just wasted 30 minutes. Because it's the usual formula, Senator Mark. The Senator Mark I know. This is a breach of the law. Where's the report? You know what, Senator Mark? Let me give you the report. The annual report, let me give it to you. You see, I always say my job as a legislator is very simple. My job is to get the legislation in place. And when we debated in 2009, I was very clear in making the point that we do not remember that Trinidad and Tobago was one of the first jurisdictions to introduce sex offenders registry. I made that point. But it was not adhered to. And in 2019, we had to come back and deal with that and fix it. And you know what? My job as a legislator is to pass a law that enables the bureaucracy and law enforcement to do what it has to do. So my annual report, my report on our 2019 work is very simple. One day in December, Wednesday, December 9, 2020, I was reading the Newsday, and I saw a headline, Court orders first man to register as sex offender. That's my annual report. Because that morning, I felt as a legislator, and I felt that we as a Senate, and I felt that we as a Parliament had done our job. Yep. I do not have the power to investigate, to arrest, to prosecute, to hold in the prison. I have today, don't know about tomorrow, the power to make the law. And I felt that we had done what should have been done a long time before, but we had done our job. And when I saw trial without jury, when I saw that process which led to plea bargaining and entering a plea and receiving a penalty, I felt that we had done our job. In those days when we sat late at night and we did DNA regulations, 2 sets one night, to give effect to the legislation which had been passed and sitting down there, which gave the power to hire somebody to run the registry and to actually collect the samples and swabs and so on, I felt we had done our job. And I could list many, many things. regulation of non-profit organizations, everything, insurance. I felt we had done our thing. And that day, Wednesday, 9th December 2020, when I looked at the Newsday, I copied the link and I sent it to my friend, the Honorable Attorney General, and I said, we've done our job. So that is the report. When you say, where is the report? That is the report that I saw, and that is how I know that we're doing our job. We've heard so many times about this intrusion and the claim that the Attorney General came here to look good. But you know, the Honorable Attorney General said while we are here, we've come here based on the experience, one, of the law so far, to perfect the law. And he's not only said that, you know, he said he's going to have to come back again. He set out what we're going to come back again on this issue of voyeurism. We're going to have to come back again and again because the technology, the society, the influences, particularly the influences on our children, the dangers posed by technology and predators and other things, movement of people and the movement of characters, changing nature of the society. The fact that many of us, we wouldn't admit it, many of us are not comfortable with sending our children to overnight by even family, going on the beach Easter time and camping and so on. You're going to have to come back and fix, and that is what we do, so that the fact of coming back is another form of annual report or reporting. That there are two things and two main things in this bill. One relates to a matter that we grappled with in the select committee and even in the debate, the difficult aspect of making this type of information known to the public. We've grappled with that. Because I remember the contributions I made on those bills. And I said, we have been part of the problem. Sexual offenses have become pervasive because mothers, fathers, family members have historically felt the need to protect the perpetrators of it. And many, if not all, sexual offenses involve an element of protection, and not protection of the victim, you know, protection of the perpetrator. And we have been reluctant because I remembered in that debate when we had the provision in the bill about making the notation on the passport, there was great reluctance on the floor to do that. Because we felt that the person who had this passport had some right to be protected. And I had a different view, not only in the fact that the passport explicitly says it does not belong to the holder but to the state. I felt that the balance should be in favor of the victim and not the protection of the perpetrator. And that is why the law itself, when you talk, Senator Mark, about infringing 4 and 5, the law explicitly allows that. The Constitution allows that. In certain circumstances, well established in Surat, and long before that we could come here and do that. And I then and I now believe that the balance should tilt in favor of the victim once and for all. So to say that we've come here to infringe, the law allows us to do that. And we're not doing that today. That's not what we're doing that day. To talk about Clause 11, when you mentioned Clause 11, Senator Mark, I do often invoke this response, but I'll tell you, you mentioned ad hominem and Clause 11, I went straight back to Section 34. Because that is what Section 34 did. That is what Section 34 did. It placed, as the law, as we're entitled to do in our parliament, it placed the judiciary in a position in which if a certain time frame had passed and a certain point in the prosecution of a matter had not been reached or passed, there was an automatic process that followed. That is what it was. So what you describe as, and that is not happening here, but what you describe was straight Section 34. That is what you described. And that is why Section 34 was eventually rejected. So, Mr. Vice President, notwithstanding all the fanfare and all the usual threats, and the only thing Senator Mark has not threatened to do is to throw down the government. But I guess that threat has been made earlier in the week, and he knows we've had enough of that. This piece of legislation, Mr. Vice President, seeks to do two things. To create the two registries, one in the form of a public website, and one in the form of the National Sex Offenders Registry, something, as I say, we grappled with before. And secondly, to detail in a manner we had not done before the role of the Commissioner of Police in the creation and the maintenance of those two registries. It is as simple as that. And the other parts of the bill seek to create consistency based on the amendments which were made before, to create consistency among the various pieces of legislation, including consistency in the fines and sentencing in relation to the DNA Act and the Police Service Act, which is set out in the schedule to this bill. It's as simple as that. There's nothing, and it is reflected in the contributions which have preceded me, that lacked complexity, that demonstrated a strong desire to make this further step in the evolution of the sexual offenses legislation in this country, and to bring certainty in a manner the previous work may not have done before. And most importantly, to address further that issue of the registers that any legislator who was here at the time would know, both in the select committee and in the debate, we all grappled with. I thank you, Mr. Vice President.
Senator Richards.
Thank you, Mr. Vice President, for recognizing me and allowing me to make a contribution to this, the Sexual Amendment, Offences Amendment Bill 2021. Good afternoon, colleagues. A lot has changed in our country, but the need to protect girls and women and boys and men from predators has not changed. While I support the bill in principle and the intention to offer yet another layer of critical protection against perpetrators of sexual violence against the vulnerable in society, I hope we're not lulled into a false sense of security about this being a panacea. It's one of the layers that I think is important, all things being equal and protections being afforded. But it has to be, of course, part of a more sustainable, consistent and comprehensive approach. Most of the research anyone can do on national sex registries indicate they generally don't attain the objectives. They sometimes give a false sense of security. Like Senator Dillon-Remy outlined in her presentation, public sex registries tend to be effective in preventing or mitigating against first-time offenders because of the obvious public ridicule. The larger the registry, actually, the less effective they are. Fortunately, Trinidad and Tobago's population is much smaller. This bill is packed with many punitive measures, as it should, but unfortunately is absent of provisions for treatment options for offenders and the families of victims, including the families sometimes of offenders who are also affected in a second-hand manner. It's important also to note that after psychiatric evaluations, Not all offenders are going to benefit from treatment and rehabilitation. Some simply need to be locked away forever. But some can benefit from treatment and rehabilitative measures. Generally speaking, an offender is anyone who's convicted of a sex crime, and sex crimes have been clearly identified in this bill and others in our country. California began registering sex offenders as early as 1947. Sex offender registries did not become widespread until the 1990s, after state registries became part of federal law in the U.S. And the passing of the Jacob Wetterling Act in 1994. Comprehensive research of data did not show significant decreases in rates of rape or sexual violence or the arrest rate for sexual abuse after implementation of registries or the access to registries via the internet by the public or any other means. The Department of Justice data also tracked individual sex offenders after their release from as early as 1994, and they did not show that registration or public publication had a significant negative effect on recidivism. We continue to talk rehabilitation, but seem unwilling to walk the talk. We don't seem to have a national philosophy toward rehabilitation and a comprehensive approach to restorative justice. And when you say that, sometimes people kind of have a visceral reaction because of the sensitive nature of sexual violence, particularly against girls and women, because, we all understand it, we've seen the history in this country, and one of my colleagues earlier on spoke about the two high-profile rapes and murders recently, but this has been happening for decades in Trinidad and Tobago. We're just more exposed to it now through the media. Recently, in a motion I piloted, many of my colleagues in this Honorable House, or our colleagues in this Honorable House, told us about their own experiences with violence in home circles. I do believe that while this approach is important in the right construct, I think those convicted of sexual offenses may be better monitored by electronic devices or ankle bands, which is now available, and I think has been part of a judgment recently. This may prove to be much more effective than public sex registers in protecting the public and consistently monitoring the offender. And if we're applying this science state and looking at the data globally, as I said before, they don't generally attain the objectives. They are more of a fear factor and in some instances provide information to persons in specific communities about where a sex offender may reside or may be frequenting. But research is important, and science is important, and there are psychometric measures that can be used to assess the propensity of an offender if he or she qualifies for reoffending. One such is the Multiphasic Sex Inventory, MSI, by Nicholas and Molinder, 1984, which is a psychometric measure specially designed to assess the psychosexual characteristics of sex offenders, rapists, child molesters, exhibitionists, etc. It provides information that is independent of personality and psychopathological tests, and is found to provide data that corroborates with physiological indices for arousal. It's used in more than 1,400 hospitals, clinics, and agencies in the assessment of sex offenders globally. If we look at the science of it, there are some persons, as I said before, that can benefit from this sort of approach, because in many instances, the reason that we are going through this process today is because sex offenders, in most instances, will come back out into society. Do we want an offender back in society simply to monitor them? Or do we want an offender to come back into society having gone through some sort of rehabilitative program that moves them in the direction of being less likely to reoffend? That's the question we have to ask ourselves. Because just having them serve their sentences and come back into society where we have to monitor them without even a modicum of them being exposed to some sort of rehabilitative process is counterproductive. It's almost like we put them back or we allow them back outside because they served their sentence, and we just on eggshells waiting for them to reoffend, because nothing has been done in terms of passing them through what should be, to me, a mandatory regimen of some sort of process to get them back in line with what is expected of them in society. Isn't that the more productive way to do it? Wouldn't that put us more at ease? And passing them, having them be assessed by these instruments gives us a clearer sense of those who need more intervention and those who are much less likely to reoffend, as opposed to just monitoring. I think that is something that's worth consideration. In an article by Amanda Egan, University of Chicago, 2021, titled Sex Offender Registries, Fear Without Function, the registries, as our bill, contain names and addresses, photographs of sex offenders, now generally easily accessible on the internet, and people appear to value the information and pay to avoid living near registered sex offenders. In the US, there's some data that suggests that homes close to a registered sex offender sells for about $5,500 US, less than comparable homes. Now, this may be a controversial statement, but I prefer people know in certain constructs where an offender is and suffer the loss in value of the property, because the property value is nowhere near comparable to the safety of persons. But that's a fact. One of the other issues that we really have to consider in terms of sex offender registries, and I have to commend the Honorable Attorney General for the disaggregation of the public registry and the nationally available registry. I think that's a move in the right direction, which I haven't seen in many other jurisdictions. And it's important that that disaggregation takes place, because there's some, I guess, who will end up on the public registry that really need to be available to the public under certain circumstances. And some persons who I think, as I said before, may be open to rehabilitation that should not end up necessarily on a public registry. But one of the issues that we have to consider, which is widely available for research, is the issue of vigilantism and the danger that may be posed to the family and community that will now become associated with the offender while back in society, because at the end of the day, they have to live somewhere. And they are generally associated with a particular family or community. And I think it's very important to put systems and mechanisms in place to ensure that, and I know it's in the other parts of the law, that persons who engage in acts of vigilantism face the brunt of the law. That's very important. The bill contains a provision for the commissioner to publish the locality of the offender, but just thinking about it, what happens if you have 15 offenders in the same locality? What happens in that case to that particular community? Because it's quite possible. It means that there'll be even more intense focus on a particular community, which puts a different kind of spin in that community in terms of public perception. We have to consider all these possible eventualities when we are passing law, or making law, I should say. Our colleague, the Honorable Minister of Agriculture, Land and Fisheries, indicated that we're here to perfect the law. Well, I just want to amend it. We're here to improve the law, because I don't think in our context and the evolving society that we can ever have perfect law in any iteration. One of the other concerns I have, Mr. Vice President, through you, is Section 9, Clause 48, where the Commissioner of Police, and I'm not talking about this particular Commissioner of Police, I'm talking about the Office of the Commissioner of Police, is required to maintain reasonably the information contained in the registry and maintain its security, and there are several other applications or responsibilities assigned to the Commissioner of Police. And I don't see any consequence to him or her acting in the position of the Commissioner of Police if those responsibilities are not maintained to a reasonable standard. So I'm hoping the Attorney General can address that. Maybe I missed it in some other part of the bill or the Parent Act. One of the other interesting studies I found in terms of information on sex registries globally is one by the Justice Policy Institute, and it's titled Registering Harm and How Sex Offense Registries Sometimes Fail Youth. And I know this particular bill does not contemplate persons under 18 years of age, which makes sense. But we sometimes have a very defined, and I understand the legal aspect of it, to 18 and over 18, when in some instances, persons certainly have not reached an age of intellectual or emotional maturity by the time they're 18. And I know they're culpable in law as adults as 18, but we really have to have a different kind of juvenile justice system and provisions of a juvenile justice system, a more effective juvenile justice system to deal with persons who may have attained the age of 18, but really through their circumstances are not intellectually, emotionally mature and may not understand the implications of their actions at that age. Mr. Vice President, through you, one of the bits of information that came through that same article is that, and the source is Howard Snyder, sexual assault of children and young persons reported to law enforcement, victim, incident, and offender characteristics, Washington, D.C., from the year 2000, is that it's interesting to note that the majority of persons who are sexually assaulted and are victimized are by people who are already known to the survivor or victim. 59% by an acquaintance and 34% by a family member. And only 7% are victims of sexual assault by a stranger. 59% by an acquaintance, 34% by a family member. What is that? How should that inform how we make law when you think about it? Because in some instances, it is clear that the person, the perpetrator, may end back up in a close proximity to someone very close to them or someone who's an acquaintance or maybe in the same community. And we have to really look at those possibilities in terms of how we mitigate against them. And that's why I suggested earlier on that one of the accompanying or parallel mechanisms to a public sex registry is maybe the implementation of the electronic monitoring device for persons who would have been convicted of sexual offenses and also have served their terms and allowed back into society, at least for a particular length of time. I referenced earlier on the importance of research. In some instances, if we do not do proper assessments, psychological and psychometric assessments of offenders, we will be missing the opportunity to garner valuable research on what may have led that person down that path. What are the antecedents in their life or the influences in their lives that would have led them down that path to make those kinds of decisions, that we may be able to red flag certain behavioral patterns and intervene before the offender actually commits the act. And to me, that's also part of what effective restorative justice entails in Trinidad and Tobago. Part of a restorative justice process also is ensuring that the perpetrator comes to a clear understanding of the impact of their activity on not only the victim and the victim's family, but also themselves and their own families and their communities. And I think the absence of that aspect in the bill is somewhat of a missed opportunity in terms of how we can move forward, because we don't want to be, in my humble opinion, continuously making law to deal with situations as if they have to happen, as if we have no agency in how we raise our citizens in the country and how we intervene if pathological behavior patterns start to emerge through particular influences in society. So I think we have to start looking beyond just punitive measures and look at, one, rehabilitative and restorative justice measures, and certainly measures that can impact the direction of lives if we see red flags start to arise in a particular direction by getting the kinds of antecedents to behavior patterns which end up on the wrong end of the criminal justice system. So in closing, Mr. Vice President, as I said before, I, in principle, support this, but I think we have to be a little more holistic in our approach to lawmaking in Trinidad and Tobago. And with those few words, I thank you.
Senator Rambhajan.
Thank you very much, Mr. Vice President. Members of the Senate, good afternoon. I was turning over in my mind how I would start dealing with this piece of legislation because it is such a touchy subject. And Senator Rambharat started his contribution when I came into the House, and he spoke of the annual report and the fact that the court ordered one man to register, Mr. Justice Sinclair Douglas, in December 2020. It's the first judgment, and there is a lot of patting on the back that we got things done. Then there was talk about the legislative agenda to deal with crime and that, DNA regulations were passed and plea bargaining was done. And as a member of the bar who practices in the criminal arena, I am subject to my oath, and I must be honest, even though I might be the bearer of bad news, to tell the learned Attorney General and Senator Rambharat that the gentleman who was ordered to register in 2020, that's not the first order the court has ever made. I have prosecuted in cases where Mr. Justice Mark Mohammed, as he then was the trial judge, and he ordered it then. The problem was it could not be implemented. So let us not say this is novel legislation. It is groundbreaking. It is not. Firstly, plea bargaining was always there. The DNA regulations, though it was not there, the legislation was there and it was implemented in a case called the State versus Quincy Jeremy, in which I was the junior prosecutor. So perhaps it was fortuitous that I was given a temporary appointment today to put on the Hansard the actual legal facts and what has happened in the courts of the Republic of Trinidad and Tobago. Having said that, this piece of legislation, the Sexual Offences Amendment Bill of 2021, feeds on the 2019 Act. And I trawled through the Hansard and I looked at everybody's contribution when the legislation was first passed, with its 90 amendments. And there is still work to be done, in my respectful view. My role and function is not to criticize. It is to recommend and suggest because of where I sit. I sit as an attorney first, politician very many moves after that. So as a politician, my role here today is to educate from a place of experience and to tell you that while this piece of legislation is groundbreaking and it can serve a good purpose, it cannot be that we are passing legislation in a fashion where we are reacting to things in society. This honorable House should not be reactive. The Honorable Attorney General said in his opening, should we ignore the marches? No, you should not, absolutely not. The voice of the people is the voice of God. Listen to them. Let them assist you to understand the grassroots and ground issues that the people of Trinidad and Tobago are dealing with. But do not let them dictate to you your legislative agenda. Do not stand on the pulpit of political pressure or popular vote and pass a piece of legislation that you are not ready to implement yet. So my purpose today, ladies and gentlemen of this honorable chamber, is to say to you that the legislation can work, the registry can work, but we need to tweak it. Senator Rambharat said, the Honorable Attorney General said, we'll have to come back again to deal with voyeurism. We'll have to come back again to deal with social media and how it impacts on sexual offenses. Why are we coming back? Why can't we sit and develop a clear policy on this matter and then legislate? That's what they did in England in 1997. When they passed their legislation to implement the sexual registry, there was a white paper that was produced. And the white paper was entitled Protecting the Public, the Government Strategy on Crime in England and Wales. Where's our policy? What are we hoping to achieve? Or are we passing legislation to ensure popularity and to give the impression of public relations? Because when it hits the court and the judiciary has to implement, that's where the problems rise. And while there was talk back and forth about constitutional motions and actions before the court, why do we have to wait for the court to get it right when we here can sit and debate and figure it out? When we look at this legislation, and we look at the terminology of the Honorable Attorney General when he laid it in Parliament, and even today, it is a lot of talk of punishment, of the rights of the victim versus the rights of the perpetrator. That is a very myopic view, regrettably, of the law and justice. When you look at Lady Justice, she has scales in her hand. And those scales do not tip in one direction, honorable members. It is balanced. And that is what we must seek to do with this piece of legislation. We must balance the rights of the victim while not infringing on the rights of the convicted. How do we do that? We do that by carefully drafting legislation to ensure that persons' fundamental rights and freedoms are not infringed upon, while also ensuring that a victim feels that their voice has been heard. And I was grateful to see in the legislation that victims have the opportunity to provide statements as to their feelings when a person wants to make an application to come off of the registry. The role of victim impact statements in the courts of Trinidad and Tobago continue today. And it is something that we ought to consider when we look at the registry. But is the legislation as laid covering of all of the necessary issues that we need to deal with when we set up a registry? Are we looking at populist punitiveness? That's not my term. I wish I could take credit for it. It was actually in an article. Many persons here quoted from articles. But I like the term populist punitiveness because it says that we are punishing so we can remain popular. That's what it means. Are we legislating with purpose? And what is our purpose? We must understand that there is a balance to be struck between the victim and the offender. And I do not want anybody to say that I choose the offender over the victim. That is not my purpose. Every victim's voice needs to be heard. And every victim should have the right to say to the Commissioner of Police, I want this person on the register. That is a recognition of their right, of their voice. Because you know what sexual offenses do? They take away the voice of the victim. So anything to give them their voice back, I will respectfully support. So I'm supporting the bill in my own way, but I'm also making recommendations for the Honorable Attorney General's consideration. We are looking at preparing a list of persons, the national registry, which would be used by those in authority, and then a website that the police will fashion, maintain, update, populate, and ensure security of. So when we look at that website, you have a number of persons who would be listed there. But when we look at each section, there is nothing there about rehabilitation. There is nothing there about counseling. There is nothing there about restorative justice. And I'm grateful to follow on Senator Richards, who raised those very points. What is the purpose of having a list of offenders, convicted offenders? Because that is all this legislation does. It lets you create a list. What do we do with that list? Do we use it to investigate other matters? Do we use it to develop treatment plans for persons so that they do not reoffend? Do we use that information to target certain sectors of society who may not be educated in terms of sexual deviance? Because we all know that in some sectors of society, sexual offenses occur because of tradition, misapprehension, culture, and simple education where you tell a child this is a good touch or this is a bad touch can change the way people perceive sexual offenses. Are we implementing any of that in this bill? Or are we just creating a list of people that we are condemning because they are sexual offenders? What use is that information going to be used for? In England, they have something called a spectrum of protection that works in tandem with their sexual registry. Senator Bethelmy indicated in her, permit me one moment, indicated in her presentation that in the United States, the Department of Justice has implemented a registry. What she has not also said is the Department of Justice has also created a number of rehabilitative programs so that when the sexual offender is being monitored in their registry system, they are also being required to attend counseling services. Unfortunately, sexual offenses is not like a man going into a place and robbing a store, or somebody in the heat of the moment in a crime of passion. A person ordinarily who commits a crime of a sexual deviant nature, something is not right with him mentally sometimes. And when I say something is not right with him mentally, offenses like rape, incest, all of the offenses listed in the schedule, they carry a certain degree of anguish on the side of the perpetrator. And why do I say that? Because very often the offender was once a victim. So are we creating a cycle where we now identify the offender, but we do not see whether or not he is in fact a victim? And that takes me to the Act. There is an amendment here that makes it discretionary for a court to order a mental health assessment report before making a determination whether or not the person should be added to the register. It is my respectful view that that mental health assessment report should be mandatory. And I want to recommend to the Honorable Attorney General that we move back the may to shall. The reason that should be done is because if I am putting your name on the register, I want to see how I can assist you. How can I rehabilitate you? Because the probability of you reoffending is extremely high. So how can I fix you? So if we're creating a registry, can't we not use it to break that cycle of abuse and prevent those potential victims of those persons from suffering at the hands of these individuals? You wouldn't save all of them, but at least you would have in there the opportunity and the framework to create some sort of change in this person's life. And who knows, maybe 10, 12 years from now, he or she might make an application to come off that registry because he has proven that he is rehabilitated. We need to consider how this register is going to work as well. If I am an offender and I am placed on that list because I have been convicted of an offense and the police is required to monitor me, what do we think the likelihood of that person saying they feel harassed by the police would be? Isn't there potential for that individual who has served his time, who has gone to the police station and registered and said, I want to move on with my life and I want to put this behind me. I was convicted and I want to put this behind me. And then he has police officers coming to monitor him. He has to provide all of this information. He's listed on a register. We think that would affect his employment chances? And if that affects his employment chances, how are we making money to survive? And what is he going to turn to? Not the very same thing that put him in jail in the first place, because that is the only thing that is providing him with comfort. We need to break that cycle. So I'm saying if we are creating the use of this register and website, that we need to balance not only the punitive arm of the state, but we also need to consider the rehabilitative arms of the state. They must go together. That is why the scales of justice are twofold. You can't have one without the other. But in this piece of legislation, we only have one. It is only punitive. You cannot only legislate to lock up, to list. And that is what we are doing, unfortunately. Great talk about bail. Great talk about 120 days and sunset clause, all of these things. Why is our approach to lock up and list? Why isn't it to help and assist? When this bill was first laid in Parliament, the Honorable Attorney General used statistics. And the statistics showed that there is a 3% conviction rate for sexual offenses in the Republic of Trinidad and Tobago between the period of 2000 and 2019. 3%. At that rate, that list not going to get full anytime soon. 1. 2. Why are we legislating post-conviction and not for the prosecution of the offenses? Why aren't we looking at why there is only a 3% conviction rate? Why aren't we focusing our energies on fixing the problem rather than coming after and trying to fix it? This is not a raffle. We're not taking chances. Set the policy, figure out what it is we want to do, and then let us legislate for it so that the population can feel confident when legislation is passed that the powers that be can enforce that legislation for their protection. If we do that, if we are able to factor in rehabilitation with punitive measures, then the Senator Thompson-Ahye spoke about the roles of juveniles. Statistically, younger persons are committing sexual offenses. I'm sure we've all read in the newspaper horror stories of children going to school and being attacked in school by other classmates, and they are sexually assaulted, sometimes by gangs. It happens. Cannot turn our eye to it. This legislation says carte blanche, no child offenders is to be listed on the registry. Again, is that a holistic approach? Or are we doing things again in a piecemeal fashion, where we're only dealing with one sector of society, the convicted older offenders? The Learned Attorney General spoke about Mr. Justice Sinclair Douglas's decision to have the man who was convicted to 9 years imprisonment to register after he came out. I am sure when many of you were here for that debate in 2019, you did not anticipate that the first man who would be on that register would be a man who fathered 3 children with the victim between the time of 13 and 18, and that they were in a relationship together. Because when we think sexual offender and we think sexual offense registry, we think rapist, we think this, we think that. That was a case of statutory rape. And yes, it was right that he is being registered on the sexual offenders registry because he is a sexual offender. Because she was a child and he was a 24-year-old man. But the reason I raise the facts of the case is to show you that what we think we are putting on the register is not the crime, it's a person. And that person has the potential to reoffend. Why isn't the role of probation referred to in this piece of legislation? Why isn't a probation officer's report requested to determine how this person is doing, having been released into society? If we look at the role of the police in this proposed legislation, the police have so much to do. They have to police us, protect us, serve us, and now they have to maintain a registry. They have to populate it, ensure the information is accurate, and implement security measures so that persons cannot hack into the registry. That is a lot of responsibility for an already overburdened state enterprise. And I would want to recommend that perhaps there should be consideration for a third party monitoring and populating the registry. Perhaps an ex-judicial officer, former judge who has retired, sitting with the Commissioner of Police, and somebody else who understands the role of rehabilitation and the balance between punishment and restorative justice. When we also look at the role of the police, where are they getting the resources to do this? The last time I was here, I spoke about the practical and the pragmatic, and I have to repeat myself. When you have 3 police prosecutors using 1 laptop to do virtual court, and the bandwidth is so slow that they cannot access the court unless they turn off their camera, so all we are hearing is their voice. How are we implementing this registry through the TTPS? How are they going to be update after update and names of persons who are coming in who are convicted for them to maintain when they don't have computers for their own use in the police stations? When you look at the application that is being made to the police for access to the website and the information, why are we giving the Commissioner of Police a judicial function? Why is he making a determination whether or not your application to get the information should be granted? If we had the ex-judge sitting on the panel I just suggested, that takes care of that. It would also take care of the fact that no matter how you cut it or dice it, the police still involved because they are the ones who will populate the registry. Under this new amendment, an application is to be made to the Commissioner of Police under Section 50. But the old Section 50...
Senator Rambhajan, you have 5 more minutes.
Thank you very much, Madam President. The old Section 50 was repealed, and there's nothing in this amendment. I'm, of course, subject to correction. But an application in England under the same registry, I want to read from an article called Use of the Sex Offenders Registry in the UK, which was published in 2016 by 3 college professors in criminology, English professors. The scheme of this sexual offenders registry is not a US-type community notification scheme and is actually quite limited. An inquiry must be made via the police about a person. The person must be in contact or have access to children or a child, entitling him to the information. And it is only if the subject of the inquiry meets certain criteria of risk that the disclosure would be made. The legislation is silent on all of this. What is the criteria that is being used to judge whether the information should be given? Then we talk about vigilantism. Locality. There was an amendment where we take the address out and we put the locality. I commend the change, but the problem is Trinidad and Tobago is such a small place. If you put, I'll use myself as an example. I'm from Kelly Village. Village. Locality, village. Anybody who go Kelly Village and say they're looking for the fat lawyer, they will find me. That is how simple it is. I'm being real with you. That is how simple it is to find someone in Trinidad and Tobago. So if you go on that website and you see the locality of a person, and then you start to check and you see 3-4 people there in close proximity to where you live, doesn't that raise the anxiety of a parent? So we need to be careful what information is available to whom. We also need to be careful of abuse by the police. We have excellent police officers, but we have some not so good ones as well. I am not confident that a police officer may not use that information against someone. It has happened. How do we put protections in place? I do see that there is a section that speaks to confidentiality, but I want to recommend to the Honorable Attorney General that we create a specific offense for persons who have access to the register or the website, posting information on social media. Right now, we have a serious problem where people's information is being spread on social media, and after it is out there, you might send 10 pre-action protocol letters. The problem is, it's already out there, and you have destroyed a man's character by just the click of a button. So perhaps we can consider putting some sort of penalty and offense in the legislation there. Now, at the end of the day, while we recommend these changes, there is one recommendation I want to end on, and that is that we must be slow to remove judicial discretion in situations like this. When we look at criminal enterprise, criminal offenses, the criminal justice system must have its say. And any attempt to remove judicial discretion should not, in my respectful view, be supported. At the end of the day, what we want to do is to create a piece of legislation that creates a register that can be used for a much larger purpose than just public perception. We want to make it a tool that the police can use in the investigative process. We want it to be a tool that can be used for the protection of the public. We also want it to be a tool for deterrence. so that persons who are engaged in this type of offense will know that their picture is out there for people to see. But at the same time, we also want to use it so that they can be rehabilitated, and restorative justice can go hand in hand with the punitive measures being implemented. So I end as I began. Remember the scales of justice when you legislate. It is not for one side, but for both. I thank you, Madam President.
Minister in the Office of the Attorney General and Legal.
Madam President, I thank you for yet another opportunity to make a contribution in this most honorable chamber. Madam President, this is an opportunity I will say I do not take for granted and will never take for granted, because God knows with all we say and do in this Senate, may we inspire confidence in our fellow citizens and make a positive contribution, Madam President, for the peace and prosperity of our nation. Madam President, before I support any bill that is brought to this honorable chamber, I always step back, analyze the law, and ask myself, what positive impact, if any, is this piece of legislation going to have on our population? Madam President, you see, there are two simple reasons why I entered into politics, and I will share that with the honorable members of this chamber. The first, Madam President, to be very honest, it carries a name, and that name is Dr. Keith Christopher Rowley. You see, I do believe, and will always believe that my political leader is a leader phenomenal, and it is because of him legislation like this is brought to this chamber. I will never forget on an occasion while discussing young people and the role of young people in our society with the Honorable Prime Minister, he said to me, and I will quote him, he said, "You speak for them in the Parliament, so do a job of that. You have a soapbox that most don't have. Use it." And I'm saying this, Madam President, because every time I'm blessed and privileged with the opportunity to speak in this chamber, I understand that I have a privilege that not many citizens in this country have. And when I come here, it is always my intention, and us on this side of the Parliament, to make a contribution that could only uplift our society. Now, the second reason why I entered into politics, Madam President, is perhaps most relevant to this debate. I genuinely, like all of my colleagues, I'm sure, in this chamber, I genuinely want to serve, and I genuinely want to attempt and help in protecting all of our citizens. Now, all of our citizens and all of our people, Madam President, we understand what that word all suggests. It suggests every creed, every race. It suggests law-abiding and even non-law-abiding citizens. And you heard me correct, Madam President. Even those little bad boys and girls in prison, I recognize that we have a responsibility as legislators to equally protect. Madam President, I was a defense counsel, so it is in my DNA. And I am certainly never going to turn my back on even those who are the perpetrators of crime in this society. But, Madam President, I recognize standing here, I have an equal responsibility to protecting the innocent and the law-abiding citizens of this country. So, when I support and when I place my support towards any piece of legislation brought before this Parliament, Trinidad and Tobago, you can rest assured I will never support and encourage legislation that perpetuates injustices in our society. Because coming from a criminal and a defense background, I understand the importance of protecting the rights of even those little bad boys and them in prison, quote unquote. But now as a legislator, I have an equal responsibility to our law-abiding citizens. And I want to place on the record again, as my colleagues on this bench would have already done, my support for this legislation, for I believe it balances the rights of our perpetrators, protecting their human rights, which they are all entitled to, together with ensuring and reassuring our citizens that the days ahead are going to be better and safer. Now, I immediately want to respond to, my presentation may not be very long today, Madam President, because there are really points that I intend to rebut on. And if time permits me, I will focus on Clause 11 of the bill that appears before us, because that clause is what amends Section 50. It repeals Section 50 of the Sexual Offences Act, introduces a new Section 50, and I believe that is what, that clause in particular is what I call the Scarlet Letter Clause. And for A-levels, there was a book that I did in school that was called the Scarlet Letter. And if I get to that place in my presentation, Madam President, I will discuss what is the comparison between terming this clause the Scarlet Letter Clause. But I want to immediately answer a question respectfully put to this chamber, or a statement made by the Honorable Senator, whom I have the honor of sharing her name, Senator Renuka Rambhajan. She asked the question, why can't we sit and wait and then legislate? Honorable Senator, respectfully, I have a 13-year-old daughter and I have a 12-year-old son, and I shudder to think that as a parliament we're prepared to sit, wait, and legislate. Because while we are sitting, waiting, and legislating, our children are victims to monsters outside there. They are. And I think, I'm not saying that if you're not a parent, you don't understand, because people have nieces, they have nephews, we are all connected. But I shudder to think that this parliament will be expected to simply wait and have it right and have it perfect before we present any piece of legislation that has the potential of protecting our vulnerable in society. There's also another statement made by the Honorable Senator. The Honorable Senator stated that we balance the rights of victims while not infringing on the rights of the convicted. It is, as an attorney at law, it's my personal pet peeve not to read articles and not to read from articles. I always prefer to refer to a point of law, a case law. But in some reading and in trying to answer to that statement made by the Honorable Senator, I want to quote a 2010 journal published in the Journal of International Criminal Justice, entitled The Rights of the Accused versus the Rights of the Victim. And this particular article, Madam President, it stated the balancing of the victim's participation against the rights of the accused should be inspired by some procedural principle and imperative nature which represents the backbone of international criminal procedure. The presumption of innocence, the right to a fair hearing in full equality, and the right to an expeditious trial, the right to confront and present evidence, and so on. Now, Madam President, it's my respectful view that by virtue of this bill, we strike a balance while we protect the vulnerable. We do not seek to trample, as the opposition seems to think. We do not seek to trample on the rights of the vulnerable. We do not seek to trample, on the rights of the convicted, in that throughout the length and breadth of this legislation, and that is why I want to really get into Clause 11, especially in that Clause 11 that brings amendments to Section 50 of the Sexual Offences Act. That particular section identifies safeguards that has been placed in this amendment that allows for due process. It allows an application for someone it allows the accused or the convicted person, the opportunity to make an application for their name not to be placed on the website. It allows, it speaks, I believe it's Section 52, the new Section 52. It speaks to what happens when someone appeals their conviction, and then it goes on to speak 53 and 4, it goes on to further speak to what is within the contemplation of the court. And even that same mental assessment that we spoke of, those sections all speak to what in my mind is due process. A process that, a provision that allows the convicted person at all time an opportunity to be able to make necessary applications wherever they see fit. So certainly, Madam President, when I get to that section, I will address that point. I want to say respectfully to Senator Thompson-Ahye, Senator Dillon-Remy, Senator Paul Richards, even Senator Deyalsingh, I believe, agree and fully support your position that there is a need for rehabilitation in our country. I do honestly believe that. Because yes, I had for many, many years, my clients were persons whom I know the system had failed them. And they had turned to crime and became reoffenders because the system failed them. And I agree with that. And I agree there is a need for rehabilitation. And you all have offered many wonderful recommendations, which I agree with. But I simply want to say to these honorable senators, the need for this rehabilitation, I do not believe it in any way devalues the law that exists and has been presented before this honorable Senate. So while I agree that there is a need for rehabilitation, while I agree that there is a need for restorative justice and all of that, I do not believe that the need for this has devalued the law that appears in its current form before this honorable Senate. And I'm respectfully asking these honorable senators to consider giving the support that this bill requires, because God knows our vulnerable in society are depending on us to do same. Most respectfully, Madam President, I also want to address some statements. Well, I'm not going to spend too much time on the contribution made by Senator Mark. I'm not going to spend too much time addressing flotsam and jetsam contributions. But, Madam President, and I mean that most respectfully, Madam President, Senator Mark, in his contribution, he spoke about the charges register, and there was a constant repetition about the charges register. And respectfully, Madam President, the bill which was sent out for public comments to the Law Association and other stakeholders, that was the bill which made reference to the charges register. The bill that appears in its current form, that appears before this Parliament, makes no mention of a charges register. And what it does make mention of is a person being placed on whether it's the National Sex Offender Register or the Public Sex Offender website. It makes mention to persons being placed on either only if and when convicted of a particular offense. So I just wanted to clear that as a matter of record, and I'm sure that the Attorney General will deal with those issues in his contribution as well. Now, there are 2 points that I want to also address that was made by the Honorable Senator Lutchmedial. Now, the Honorable Senator suggested that and these are points of law, Madam President, just for the public's benefit and for the record. Now, the Honorable Senator suggested that in Section 51, that we revert to a discretionary may. The judicial officer, she said, I believe, is best placed to make a determination whether the information needs to be published. Now, I want to turn to the law of interpretation, Madam President, as it relates to the concept of shall and may in the law. Now, the learning is that the interpretation of shall, Madam President, has been left to judicial construction. It has been persuasively argued, as a matter of fact, that shall may be construed to even mean may when, and these are the circumstances, when no right or benefit depends on its imperative use. And there is case law in the case of Reed and Wellman, Madam President, that supports this position. So I just wanted, as a matter of law, to indicate that notwithstanding the fact that in law, in certain provisions, we may have, there is the existence of the word shall, the learning in the law of interpretation is clear as to how even that mandatory word shall can be construed. And this is for, of course, this falls on our judicial officer, the officer of the court, Madam President, to do so. So therefore, Madam President, it is my respectful view in response to the Honorable Senator that this section does not in any way stifle judicial discretion, and it is certainly in keeping with the doctrine of the separation of powers. Another point, the final point that before I get into the crux of my presentation, that was made by the Honorable Senator Lutchmedial. Senator Lutchmedial suggested a mandatory requirement for a mental assessment. She indicated, the Honorable Senator indicated that a report should be done. Now, respectfully, Madam President, the Senator in her earlier, I'm a bit confused because the Senator in her earlier argument advocated against the use of the word shall, and now she wants an obligation to be imposed for a mental assessment in order for a person's name to be removed from the register. Now, Madam President, if I may respectfully take this honorable chamber to section 63(1) of the Act, because we must remember when amendments are brought, these amendments cannot be read in isolation. These amendments must be read in tandem with the entire legislation. So these amendments has to be read in line with the entire Sexual Offences Act. Now, in accordance, Madam President, with section 63(1) of the Act, it is stated that a registered sex offender, and this is what that provision says, a registered sex offender may make an application to the court for his name to be expunged from the register on the basis of compelling reasons. Now, what this simply identifies in law, the existing law, is that he has an option, meaning the convicted person has an option to produce a mental report. By virtue of, because that if it is, that is one of his compelling reasons why he believes his name ought to be expunged. So if we are to read section 63(1), it is clear in the law that if you have an opportunity as an accused, as a convicted person, Madam President, to make an application for your name to be expunged, and the basis of that is to show compelling reasons, if you believe your compelling reason is because of an unsound mind, then this gives you, under this particular section, the convicted person still has an opportunity to present to the court, Madam President, a mental report. Now, clause 18, let's turn to the bill now that appears before us. Madam President, clause 18 of this bill that appears before us, it amends section 63 of the Act and replaces the word shall with may in section 63(3). Therefore, again, Madam President, the court may at this time also can request a mental assessment from a psychiatrist and so on. So I also respectfully believe, Madam President, if we were to keep it in a mandatory requirement, this means that for repeated offenders, the court is now obligated to conduct a mental assessment again. So if a man comes before me 20 times, every time this man comes before me, I am mandated as a judicial officer to require a mental assessment. That is madness. That is legislating madness, because what it means is we always complain as citizens the duration of time. We complain about the criminal justice system. We complain about the length of time it takes for matters to be adjudicated upon. If we are to support a provision that makes this mental assessment mandatory, it means, because we have the recent case that everyone knows about, this man, what I think is 70-something convictions or charges or something like that he had, right? But imagine you have a case in small Trinidad and Tobago, somebody come before you, a repeated offender 70-something time, and every time this man appears, you're mandated as a judicial officer to wait for his psychiatric evaluation or his medical report. That is legislative madness. And that is why I'm in full support of this medical report not being mandatory. Because we have to, because this is only going to prolong and derail justice. It is only going to prolong and derail the adjudication of this matter, something that Trinidad and Tobago always complains about. The complaint is that we take too long in court, matters are not addressed expeditiously. These are little ways in which we could improve the system. All right? So that was just, Madam President, my effort to respond to some of the statements made by the Honorable Senator Lutchmedial. Now, to the crux of my presentation, Madam President, as I indicated to this Honorable Chamber, my intention is to look at Clause 11. And I will try, well, of course, if time permits, look at Clause 11 in its entirety. Now, Madam President, this particular clause, as I indicated before, my first focus will be on the proposed amendments that Clause 11 brings to Section 50, well, it introduces, a Section 52, 53, and 54. And those are the first sections that I want to focus on. Now, as all of my colleagues, both on the side opposite and here, we have already established that the purpose of this law is to introduce two registers now. We have the National Sex Offender Register, along with the Public Sex Offender website. Now, I know colleagues before myself, throughout the length and breadth of the chamber, Madam President, they would have gone into what the National Sex Offender Register is and what the Public Sex Offender Register is. So, not to not fall victim to tedious repetition, I won't get into that. We all understand, Madam President, respectfully, that one of the critical differences that exist between the National Sex Offender Register and the Public Sex Offender website is that on the National Sex Offender Register, that information is held closely to the chest of the Commissioner of Police, whereas the information placed on the Public Sex Offender website, that is what could go viral. That's what the public is aware of. Now, this is where my story and my comparison with the Scarlet Letter comes in. We know that from the time information hits a public registry, especially, and I agree, in a small country like Trinidad and Tobago, one can only imagine the negative implication that can have on an accused who really is remorseful for the crime that he has committed, and for that accused who really wanted to move past some sort of deviant act or criminal act he may have committed in his or her earlier years. Now, the Scarlet Letter, I'm not sure if many of my colleagues read that, but it was a novel in which it was a novel set in the Puritanic society. And in that Puritanic society, I did it for A-levels at Lutchmedial Girls Hindu College. And at that time, in the Puritanic society, one of the biggest crimes to have committed was to be an adulteress. And in that particular era, that particular time, what had happened is that the heroine of the book, to make a long story short, of course, she had an affair with a priest, and she gave birth to a child, and you're living in a time where, of course, to conceive without being married was a sin, and the Puritanic society ordered that she wear a scarlet letter A, signifying adulteress, for the rest of her life. So that's to make a long story short. And the point is that she was branded as an adulteress until the end of her time. Her child paid the penalty because the mother was branded as an adulteress. And from the time I read this particular clause, this novel came to my mind, because I'm thinking, once this information goes public, you have this person having to wear this scarlet letter, or this scarlet letter is bolstered to their chest for the rest of their life. Well, not for the rest of their life, for as long as the information is on the register. And of course, God one knows the repercussions they're going to have to face. But then, as I looked closely at the clause, I said, thank good, because within the parameters of 52, 3, and 4 of the law that appears before us, we are ensuring that the convicted person is not or does not have the burden of carrying the scarlet letter bolstered to his chest for the rest of his life. And what do I mean by that? If we look, Madam President, at the proposed, now Clause 11, which proposed amendments, brings proposed Amendment 52. If we look at that particular amendment, Madam President, it reminded me of the case of Ashingdon versus the United Kingdom. And one of the learning that came out of that case, a little quotation that I liked, it said, "A fair balance must be struck between the demands of the general interest of the community and the requirements of the protection of the individual's fundamental rights." And this particular clause, 52, it provides an avenue for the convicted person to make an application to the court.
Minister, you have 5 more minutes.
Thank you, Madam President. It gives the convicted person an opportunity to make an application to the honorable court if they do not want their name to be placed on this public sex offender website. Unlike the book, The Scarlet Letter, she had no choice in the matter. But our convicted persons in this scenario, Madam President, they have an opportunity if they have reason, and of course they must convince the court as to why their name ought not to be placed on the public register. And what this does is that this is where in the law we have created that balancing act. And it comes back to when I began this debate. I recognize, having been a defense counsel, our responsibility to protecting even those who are convicted of criminal offenses. Because you have convicted of criminal offenses, save and except for your right to movement and all of that, if you're incarcerated, a person's right remains intact. And I understand more than ever that there is a need to protect that person, and I respectfully submit to this honorable chamber, Madam President, that 52 provides that opportunity. Now, 53, Madam President, it speaks about the issue of an unsound mind. And this, Madam President, what that particular clause does is that it gives a discretion, of course, for a person, for the court now, to request a mental assessment of the person appearing before them. But more than that, 54 is what is important, because this actually identifies what will be within the contemplation of the honorable court in deciding if they're going to grant the application to the convicted person. And the application, if so, you make an application to the honorable court that your name not be placed on this public sex offenders website. The court we now are prescribing and creating parameters in which the court can assess this application that appears before him, the judicial officer, and make a determination as to whether or not this person, the application should be granted. And this, in my respectful view, Madam President, this particular section, 54, we are actually codifying to an extent the principles and the dicta that came out of that case, the State versus Everton Joseph. That is the case that has been discussed in some detail in this honorable chamber, that case that the Honorable Justice Hayden Sinclair Douglas would have adjudicated upon. Now, so Madam President, with this being said, I want to respectfully say, Madam President, that when this bill becomes law, the hiding grounds for these sexual predators, Madam President, will be taken away. They will now be forced, Madam President, to walk in broad daylight, and their identities would be known to all members of the public. But at the same time, as responsible legislators, we have ensured that every convicted person is given an opportunity, if they believe that there are compelling reasons and substantial reasons why their name ought not to be placed on this public register, they are still provided with the opportunity to make said application. Then later on in the bill, we spoke about what happens when the convicted person appeals their conviction. We understand once an appeal is filed, automatically the court is stayed from placing your name on the public register, the public it's the public website, sorry, Madam President. So I ask the members of this honorable chamber to understand that we have been very responsible as a government in drafting this legislation. We have ensured that we have balanced well the rights of the convicted persons with the obligation and right we have as legislators to protect the vulnerable in our society. And to that extent, Madam President, I support this bill. I support the Attorney General, and I do ask the members of this honorable chamber to give the government, give the people of Trinidad and Tobago the legislation that they desire, because certainly it has the potential to protect our vulnerable. With these few words, Madam President, I thank you.
Attorney General.
Thank you, Madam President. May I start off by thanking my colleague, the Honorable Renuka Sagramsingh-Sooklal, for an excellent contribution on the law. She has made my task tremendously easier with a very well-positioned research and response to the issues raised. Madam President, may I thank all honorable senators for their very passionate and excellent contributions here. It's very good to see Senator Rambhajan back with us in her animate style, which I always enjoy. It's very good to see you back, Honorable Senator. Madam President, may I say that notwithstanding the differences that we have in terms of certain perspectives on the law, I think it's safe to say that I feel that this was a very productive debate. I actually found Senator Nakhid's contribution to be the most relevant contribution that I've heard from him. I don't sit in this chamber, so forgive me, I don't mean to be pejorative, but I thought the contribution was a good one. And I thought that Senator Lutchmedial brought across the points that Senator Mark attempted to make in perhaps the correct tone that was required, because I think it necessary just to touch the issues raised by Senator Mark for the record, lest someone walk away with the wrong impression. In responding to this particular debate, a number of issues have been raised. A lot of what has been said necessarily and very poignantly includes what else ought to be done. We've heard the word holistic many times during this debate. And it is true that in looking at the concept of the victim, the offender, the criminal justice system, and the society, that we need to be holistic. But dare I say that it is axiomatic that a piece of law cannot be within the whole of what is required. Each end must take the piece that it does and work in tandem with others. Senator Rambhajan's contribution, joined by Senator Lutchmedial, Senator Nakhid, honorable senators on the independent bench, Senator Deyalsingh, Senator Thompson-Ahye, Senator Dillon-Remy, all honorable senators raised the correct point that we are treating with a multi-pronged issue and that we must be mindful of the approach that we take. So I agree, honorable senators. I agree that we have to look at the issue of rehabilitation, reform, recidivism, the voice of the victim. Senator Rambhajan said it very, very well. In these matters, you take away the voice of the victim, and that's a very true point to make, very powerfully true point to make. But this law is not about the reform aspects. This law touches and concerns those things, and perhaps I ought to take the immediate opportunity to say, Madam President, we have a significant bill to come to Parliament very shortly on the parole reforms of Trinidad and Tobago. It's been decades in the making, and I assure you as Attorney General that I have completed the work. We are dealing only right now with the issue of child parole. That's the one issue that has to be harmonized inside of here. We are dealing with the reform inside of the prison's conditions, the operationalization of the prison's rules, which were done since 2014 and not yet operationalized because the plant and machinery has not yet been put into place, and therefore one has to work oneself and position towards that. We are, Madam President, now in a state where we are talking about the criminal justice system, but we're in a very different place from 2015. I recall vividly the disbelief when I came to present the Family and Children Division to create the Children's Court. I recall the disbelief amongst honorable senators when I piloted the Criminal Division and District Courts. I recall the disbelief when I piloted the judge-only law. I recall the disbelief when I piloted the law to treat with plea bargaining. I recall the disbelief in introducing electronic payments. I recall the disbelief in tackling the backlog by removing 104,000 cases a year from the Magistrates' Court by simply amending the Motor Vehicle and Road Traffic Act. I recall the disbelief in breaking the backlog in terms of annual load as well, in removing 8,500 marijuana cases per year. I recall the disbelief in piloting the law to introduce electronic and virtual hearings on a laptop. But today, Madam President, we stand in this law's context with double the number of judges from 36 to 64 in the High Court legislatively. Masters have gone from 2 masters to 25. We stand now with full judicial immunity for magistrates. We stand now with an entirely improved administrative structure in the magistracy. We no longer have the centuries-old clerk of the peace running the Magistrates' Court. We have a completely digitized environment in that Magistrates' Court. Today, Madam President, we have the coordination in a particular trial, for instance, where a witness who is a critical witness appeared in a judge-only trial for murder on their phone, sitting in the back of a cab of a truck in an interstate highway pit stop in the United States of America. We have had people use the judge-only system, which applies in this law's operational context, as raised by Senator Rambhajan, in the context where people said that nobody would ever use judge-only laws. Now, Madam Speaker, Madam President, Senator Rambhajan raised the case of Mr. Justice Mark Mohammed some 14 years ago in raising the sex offenders registry. Later, of course, Mr. Justice Hayden St. Clair Douglas did this point. But the point is that Mr. Justice Mark Mohammed could not operationalize the listing because the law was just plainly badly drafted. The 2000 law, when you look at it and you look at Part 3 and what was amended, it could not operate, which is why we had no listings on the register. 0. Now, Senator Rambhajan raised a very interesting concept and point. The Honorable Senator raised the experiences that we see elsewhere where policy papers are produced and we take an holistic approach towards the development of law, etc. Madam President, if I could say this, upon becoming Attorney General, one of the first things I did was to look at the Law Reform Commission. And in looking at the Law Reform Commission, I asked for a listing of all bills that were produced by the Law Reform Commission, and I asked to see how many of those laws actually became law. And you'd be shocked to know that notwithstanding the immense effort, expertise, and hard work put out by the Law Reform Commission, and in fact, if I could say so now, and I say publicly thank you, the drafters of this particular bill from the Attorney General's office come from the Law Reform Commission, and they are phenomenal lawyers. And I would like to say that what hit me was that we were on this excursion of perfection constantly. We had nothing to show. And honorable senators know the mantra that I preach inside of this honorable chamber all the time. It's called just start. Just start. And in answer to Senator Rambhajan, the reason why we are just starting and did start, because we amended the law in 2019, we put it into operation, and at the Office of the Attorney General, we constantly check what's going on. We took avail of the law as it was put in. We checked what was actually in court. We spotted that the Section 6 repeal offenses of the repeal Section 6 of the Sexual Offences Act were not covered. We amended the law. We came back in December 2020. We dealt with the issue of the mental reports. We amended the law. We come here today again to amend the law because it is born out of the experience in the court. So we are actively tracking the cases, not in an ad hominem way, but in a general purport way within the construct of lienage, that famous case that we're all guided by, so that we can actually get to the point of having the annual report put in. But Senator Rambharat is completely correct. A report has been given because there's been one case. There is no requirement for regulations just yet. Today, we seek to cause an amendment, which will be circulated as I'm speaking now, where I'm inviting honorable senators that we can include the power to make rules of court. Now let's get to the point that we must look at this holistically. Agreed. I ask honorable senators to bear in mind that alternate sentencing is already a feature of our laws operationalized by this government. The use of electronic monitoring in effect, bracelets being put on, anklets being put on, the use of community service orders, the use of psychological assessment. Now, one of the reasons why we have left the discretionary aspect of mental reports, psychological reports, in the judge's discretion is that we have an extremely litigious society. The case of Lendor alone out of the Privy Council tells us that there are significant consequences to be had to the state in not being ready for operationalization. And therefore, to get the job done, the flexibility of law has to be in effect. I say nothing pejorative of my colleague, Senator Lutchmedial, who's frequently against the state, and legitimately so as an attorney at law in practice, together with other persons, or Senator Rambhajan, who has appeared in commendable cases as well. The Dominic Suraj matter alone, the Honourable Senator appeared in. There is a right to test the law. And in that right, I noticed that there is a significant frequency with which the state, under my watch as Attorney General, is being tested on laws that were never tested before by the same people when they had control of the reins, administrated those laws. And I'm referring to my colleagues who happen to be frontline parliamentarians or politicians for the UNC. So be it. You want to test prison conditions? So be it. You want to strike out the laws on bail for mandatory no bail for murder? So be it. You want to sue the state for not having a child rehabilitation center when you proclaim the law? So be it. How it go look is a different question. Is it technically right to challenge the law? Yes. But oh, Lord God Almighty, it doesn't ring right, Madam President. It just doesn't ring right. That is where the Trini in me comes out and say, you had to watch them so cokey eye. But, Madam President, I can't say that it is wrong to challenge it. Madam President, let's deal with this so-called 3/5 issue. Senator Mark, actually, after making a huge song and dance about the Court of Appeal in the Dominic Suraj matter in paragraph 123, recognizing that they felt obiter dicta that the minority decision in Francis should be followed, that is the strict interpretation of a 3/5 majority, that very paragraph was followed by paragraph 124. And in paragraph 124, the court went on to acknowledge that the whole concept of proportionality or a strict 3/5 was obiter. And they said and recognized the fact and the law that the Privy Council stands as our highest appellate court, and the Privy Council's decision is that proportionality is what prevails. Surat is the classic case in that regard. There are lots of others, Northern Construction, etc., etc. But the bottom line is, bearing in mind the jurisprudence coming out of the European Court in particular on the issue of mandatory vaccines as an example, they've upheld mandatory vaccines in the European context, in the COVID climate, on the basis of proportionality and reasonableness. So, as Attorney General, in advising for the promulgation of laws and this bill, I am bound to advise on what the law of Trinidad currently is. And the current law is, we do not need a special majority. And let me prove it quite simply. I have here, Madam President, the letter from the Law Association, 27th April 2021, written to me, copied to the Leader of the Opposition, all independent senators, all government senators, all opposition senators. The Legislative Review Committee of the Law Association has provided its comments. 1, 2, 3, 4, 5, 6, 7 pages of comments, 34 paragraphs. Not one of them say the bill requires a special majority. Not one. But if we listen to Senator Wade Mark, who I had cause to consider may have had need for oxygen in the position that he was speaking in, so passionate was he about his submission that a 3/5 majority was required. Senator Mark, I say respectfully, is on his own. Because this law is here to treat with the preservation of the jurisdiction of the court. There's no whittling away of the separation of powers principle at all. And I draw in aid of that argument nothing less than the Constitution of the Republic of Trinidad and Tobago, Section 5(2)(f), as in Foxtrot. In Section 5(2), without prejudice to subsection 1, but subject to this chapter and to Section 54, Parliament may not, F, deprive a person charged with a criminal offense of the right, 1, to be presumed innocent until proven guilty, etc. 2, continue, according to law, but this shall not invalidate a law by reason only that the law imposes on any such person the burden of proving particular facts. Reversal of burden is not uncommon, but Madam President, it's not that we're even trampling upon the innocent until proven guilty point here, I draw this by way of analogy. The Constitution says you can reverse the burden, and nothing is unconstitutional about that. In this case here, it is the discretion of the court that we are reorganizing. We're saying that the court shall put everybody who is a sex offender under a conviction after due process onto a register unless the person shows cause effectively why they should not be there. And we invite them to consider that approach of application. It's no different from putting your plea in mitigation at the point of sentencing. No different at all. And as Senator Renuka Sagramsingh-Sooklal so correctly and capably and elegantly pointed out, the law is further balanced in Section 50, in Section 54, in 61, and 63, where you can approach the court and make the application and show cause why the law ought not to apply to you. So respectfully, Madam President, there is nothing inside of here that ought to occupy us in the very loud contribution of Senator Wade Mark. Madam President, we dealt with therefore special majority, the fact that there is no intrusion in the separation of powers principle, because what we are saying is that the court must be guided by the application that is to be made. Due process is therefore preserved. It is the court's decision. The court obviously must act as the construction entity of the laws of the Republic of Trinidad and Tobago. That's where Senator Sagramsingh-Sooklal's point on shall and may comes very sharply into focus. But in any event, the discretion is plainly set out in the law because it's subject to the application and consideration of the court. Madam President, I definitely wish to thank the honourable members of the independent bench who reflected upon the need for us to tighten a number of our provisions. The tightening of our provisions in terms of the treatment of the offender, the alternate positions I've already addressed. I would like to say, Madam President, that this isn't a bill which is myopic in view, as Senator Rambhajan had sought to persuade us. This is certainly a bill where the scales of justice are in balance. This isn't a bill intended to satiate any desire of a populous mass. This is a bill intended to address a mischief. What is the mischief? The mischief is allowing the population to know who is a sex offender of a particular type after that person has gone through a trial, after that person has been convicted and sentenced, and after that person has exhausted all of their appellate rights to set aside the conviction. You can't get a little closer to being very careful than that. Because what we're looking at here is the societal interest in knowing who an offender is. Now, I'd like to point out, in response to Senator Thompson-Ahye, that those persons who are currently incarcerated are potentially the subject of this law. Persons who were sentenced and came out of incarceration and have served their sentence are not, because the court has funked us and we couldn't put them on in terms of the retrospectivity. Even though you have the ability to make retrospective laws, the due process has ended, and therefore they would be subjected to a form of penalty that they weren't invited to address to the court or have considered by the court. So unfortunately, we can't do that. We do agree that counseling, etc., is a necessary aspect of this. In drawing the point of painting the mischief, Senator Rambhajan correctly referred to the circumstance of the case dealt with by Mr. Justice, the Joseph case dealt with by Mr. Justice Sinclair Douglas. The reason why the court gave that 9-year sentence, and I commend the judge on an excellent judgment, it was very, very useful to look at the heads, is really because the judge felt that a 26-year-old man had no business as a pan teacher, a music teacher, in interfering with, as the judge said, a 12-year-old child. And that there is a societal scorn that must be applied, notwithstanding the hardship of the fact that he fathered 3 children with this particular victim. He also fathered 3 children with someone else, and according to the judgment, looked after none. None. And in that hardship and circumstance, the judge said a lesson must be sent to society that certain things are off limits. A 12-year-old child is off limits. That's a child. And therefore, I borrow Senator Sagramsingh-Sooklal's passion in saying that we make no complaint and we need not hide our heads in the sand in saying that there comes a point when you have to be punitive. I accept that justice is blind. I accept that the veil of ignorance in the classic context of the law must be applied, that we must apply the law with a careful poise and balance. But it comes down to what view and vision of society do we have for ourselves? And a government's role is to fashion a society in the mechanisms available to it. And one of the mechanisms available to us, Madam President, is the ability to fashion the law in the way we do. Lord Falconer, in considering the bail amendments and the law in the United Kingdom, said very plainly in the House of Lords that Parliament is there to take care of bad judicial decisions as well. It's why we have a legislature capable of making law, and why we have the court that will interpret it in case it goes wrong. But it will not be the first time that a legislature says to a country, this is the law. It may be strict liability, it may be mandatory, it may be lacking in discretion.
Attorney General, you have 5 more minutes.
Thank you, Madam President. But there is nothing odious in seeking to shape society. I'll give you the classic example. Madam President, I witnessed a bill called the Motor Vehicle Authority Bill. For decades in the works. Decades. And when I became Attorney General, and that Motor Vehicle Authority law was brought to me, I said, we're not going with that. We're just going to start. 3 sections were introduced into law. We amended Section 20 of the Motor Vehicle and Road Traffic Act. We introduced a new Section 20A, 20B, and 20C. Simply to convert the road as a place where you have a license or privilege to be. And we converted offenses into liabilities of a civil nature. We birthed demerit points. And as a result of those 3 clauses, which became sections, we saw Trinidad and Tobago witness the lowest number of road traffic deaths in 65 years. Because all of a sudden, people slowed down. All of a sudden, the reality of demerit points became conscious reflection. All of a sudden, people lining up to check their tint, to make sure they're not going too fast, to make sure their backlight is working. All of a sudden, the digitization programs to see where your demerits are, etc., became a reality. That is a very good example of shaping society. This is what this bill intends to do. This bill intends to shape society, to take bold decisions, like abolishing child marriage. I remember the histrionics from persons across me now in relation to abolishing child marriage. Madam President, there comes a point where you have to be possessed of courage and determination to just do it. Just start. And I have repeatedly and consistently given my undertaking to the Senate, to the House, to the Parliament, to come back as often as is necessary to amend laws where required. Because it is a living, breathing thing that must be monitored whilst it's being operationalized. I take the caution from Senator Rambhajan that we need to make sure that the operational functions are there. I take solace in my colleagues Senator Backus and Senator West in the digitization program, which is fast afoot. I know Senator Rambhajan will smile under that mask. In agreeing with me, lawyers didn't believe that we could go to court from home. Be in Tobago, San Fernando, and Port of Spain within 2 seconds flat. The world has changed. Some of it for the better, the vast majority. So, Madam President, I am confident that this law is what is required at this moment. The other laws which I have given intention to continue discussing in the public domain, which include revenge pornography, criminalizing that, voyeurism, criminalizing that, further bail restrictions associated with savage rape and other abuses. And yes, Madam President, testing the population, if not the law, on flogging. Why? Because it is something that is out there. You need to poll the constitutionality, the lawfulness, and the appetite. Why? Everybody knows if you spit gum on the sidewalk in Singapore, you have consequences. Everybody knows if you're crossing through with a suitcase in Singapore and there are drugs in there, whether you put it or not, man stripping suitcase in the airport, taking videos and cameras to make sure. So, Madam Speaker, Madam President, I look forward to committee stage. There are amendments in circulation under my hand, and I thank you for this opportunity and beg to move.
Honourable Senators, the question is that a bill entitled An Act to Amend the Sexual Offences Act, Chapter 1128, be now read a second time. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
Entitled An Act to Amend the Sexual Offences Act, Chapter 1128.
Attorney General.
Madam President, in accordance with Standing Order 66-1, I beg to move that the Sexual Offences Amendment Bill 2021 be committed to a committee of the whole Senate forthwith to be considered clause by clause.
Honourable Senators, the question is that the Sexual Offences Amendment Bill 2021 be committed to a committee of the whole Senate forthwith to be considered clause by clause. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The Senate shall now go into committee of the whole to consider the bill clause by clause. Honourable Senators, are we now in a position to proceed? Everyone has sight of the amendments proposed by the Attorney General. It will be on the rotunda, as you know. That has now been our Attorney General. You ready as well?
Yes, please, Madam Chair. Thank you.
Clauses 1 to 4.
The question is that clauses 1 to 4 stand part of the bill. The question is that clauses 1 to 4 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clauses 1 to 4 now stand part of the bill.
Clauses 5 to 7, sorry.
The question is that clauses 5 to 7 stand part of the bill. The question is that clauses 5 to 7 now stand part of the bill. Those in favour say aye. Aye. Those against say no. The ayes have it. Clauses 5 to 7 now stand part of the bill.
Clause 8.
The question is that clause 8 stand a part of the bill. Attorney General.
Madam Chair, the government proposes an amendment to clause 8. Specifically, Madam Chair, in the proposed 47(6), that we, after 47(5), we put a new subsection 6. And this came as a result of submissions that we got from persons prior to this debate. And therefore, the request came in and we considered it prudent to agree that we put in the penalty for persons who intentionally and without lawful excuse or justification obstruct the commission of police or alter, disposes, reproduces, shares, etc., those things which are captured under the registers. And we make that, therefore, a summary conviction liable to a fine of $25,000 and imprisonment for 3 years. So it was intended to put a penalty to the offence. We have very purposefully put in the lawful excuse exception to allow for the reasonable circumstances. We're relying upon the concept of plain and ordinary meaning here, and these come from amendments proposed from the public as we were coming to this bill.
Senator Richards.
Thank you, Madam President. I know we're on 6. Can I just ask a question on 5 before I go to 6?
I beg your pardon?
I know we're on clause 8(6),
Yes.
as proposed for amendment by the Attorney General. But can I just ask a question on 5 before I comment on 6?
On 8(5)?
Yes.
Oh, yes, okay, yes.
Thank you, Madam Chair. Through you to the Attorney General. The 5 says the Commissioner of Police shall make reasonable security arrangements to protect the information contained in the register against unauthorized access, collection, misuse, alteration, disclosure, or disposal. What happens if the Commissioner fails to do that?
That's where, what happens if the Commissioner fails to take the steps? There's a mandatory obligation upon him. So we don't criminalize the positive obligation of the entity such as the government or ministry or commissioner. But what you would be subjected to here is a mandamus. And you would also be subjected to damages that flow from breach of liability. So there's a civil remedy that's available to you in that end of the law.
Thank you. And on 6, in terms of shares, are we to interpret shares as publication, digital sharing, etc.? Is that comprised as shares, or to be understood as shares in any way whatsoever? Yes. Thank you.
Honourable Senators, the question is that clause 8 be amended as circulated. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The question is that clause 8 as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 8 as amended now stands part of the bill.
Clause 9.
The question is that clause 9 stand part of the bill. Attorney General.
Yes, Madam Chair. Madam Chair, the Law Association made a very useful comment that we ought to contemplate a number of factors. Number one, the certainty and clarity of the law specifying what happens in the context of an appeal. Secondly, urging us to also consider the consequences as to how that works out in space and in time. And therefore, we have sought to amend the clause by dealing with subsection 2 in the manner circulated to provide for the circumstances that it will not go onto the website pending the determination of the appeal for conviction or an application for exemption under 53 or an application where there's an appeal on that application which was denied under 53 by tying it to 54. We also say that it should not go onto the register until the Commissioner of Police has received the order of the court. So therefore, there can be no slip or mistaken inclusion onto the record. We then continue in paragraph B of this proposed amendment of doing exactly as we did in relation to clause 8, which is to provide the penalty for persons who intentionally and without lawful excuse or justification obstruct or alter, etc. And this is to take care of things like fake news or manipulation, etc., so that we put a positive obligation to make sure that this is used as best as is possible for legitimate purpose. Just a fun fact, if I could say this, this type of notice is actually on the Privy Council website. So when you're tuning into the Privy Council, you notice that they put a huge caveat saying you can't alter what you're seeing here, lest you be subjected to penalties. So thank you, Madam Chair.
Senator Mark. Through you, Madam Chair, could the Attorney General indicate the public notice under clause 9, subclause 4, B. Now, we said that it must be displayed rather, in a conspicuous place. Now, is this register, the public sex offender register, is it going to be centralized, Attorney General, at the headquarters of the Commissioner of Police, or is it going to be decentralized, as the case may be?
So, Madam Chair, the funny thing about the World Wide Web is that it's the World Wide Web. It's not centralized. It's the World Wide Web. So it's the website. So just to assist my learned friend with that and to assure him that this comes from the very law which we passed before. It was the old 48(1)B. So it is the same position. And why I put the fun fact in about the Privy Council is that that's the way they do it as well on their website.
Senator Lutchmedial.
Please, Attorney General. Thank you, ma'am. The proposed 48(6), which replicates what we did before, attaches a penalty, but this is in relation to the public website. But reproducing and sharing, what would you anticipate to be, a person who intentionally and without lawful excuse? Do you need lawful excuse to share? And I could understand the altering, but the whole point of it being on a public website is to share it. So I'm thinking of an example of someone pulling the information off of the website and sharing it on these community groups, WhatsApp groups, which I'm sure we're all in, one or two or many. And that's the type of thing that could possibly attract a sanction here. But that really does, isn't that part of the point? That you have this information on a public website and it's intended to be brought to the attention of the community and so on. So I think maybe some clarification is so that people really know what they're allowed to do and not allowed to do and what can attract a penalty here.
Thank you. May I?
To add something?
Sure.
Back to Senator Mark's point.
Okay, so I'll let you respond to Senator Lutchmedial.
Thank you, Madam Chair. Madam Chair, I'm very grateful to my friend for raising this issue because surely it would occupy the innocent infringer aspect, etc., the proper purpose. Madam Chair, we borrowed from the cybercrime legislation this particular concept, and it is intended, obviously, if you are in a neighborhood chat and you are saying, this is the list that comes from the website, take notice somebody has moved in, etc., that will not be an improper purpose. It was to take care of the circumstances that much of the case law in other jurisdictions has brought about, where wrong material, altered material, is in fact shared. So it was quote unquote, the wicked sharing which went there. That's why we used very carefully the intentionally and without lawful excuse, so that we bifurcated the gravity of the mental intention specifically to catch it there. It's really to give you the fighting opportunity in this world of fake news to have the law enforcement authorities push back and say, hey, take notice, what you're doing is wrong, and cause people to quote unquote scatter.
Senator Vera.
Okay. AG, Senator Mark had raised a question, and I was wondering what he was really getting at. We have the register, which is not accessible to the public, and the website, which is public domain. In relation to the register, not accessible to the public, I believe Senator Mark was trying to ascertain from you whether this was paper-based at a central repository, or whether this could be a virtual register, but could be encrypted and protected.
It'll be both. Under the current Data Protection Act, there's a mandatory obligation to reduce things to paper. It's something we're looking at now as we amend the Data Protection Act. And under the Electronic Transactions Act, all things that are paper can be done electronically. The intention is to have it in compliance with the law, which means both paper and also electronic. But I should give notice now. We are literally right now doing the electronic digitization process, including the amendments to all of our paper-based products. So that we intend for this thing to be electronically done and encrypted, of course.
And it would also make sense so that law enforcement, wherever they are, can tap into this protected register and be kept abreast.
Madam Chair, if I could just add this, Senator Vera has also touched, and permit me to put it on the record. Remember, we have, in relation to child offenders in particular, even though they may have certain aspects, we have also a protocol in effect under the Children's Court and the structures of anonymizing records in certain instances. So it's not only digitized, encrypted, unavailable, but there will also be certain amount of anonymity in terms of the child issue aspects when that arises.
Senator Lutchmedial, you wanted to say something?
Just that, Attorney General, I accept what you're saying, and I think it is necessary to prevent the sharing and reproducing of fake material, but the way the clause 48.6 is crafted here, sharing even the legitimate material contained on the website appears could be criminalized. The chapeau of intentional and without lawful excuse or justification, I don't think cures the issue here that I understand alters, but disposing if you're hacking the website or something, but reproducing, sharing, using, those are things that could be criminalized if you take them individually by someone, and they may do it intentionally. The intention is to share it as widely as possible amongst my neighborhood, and it could be criminalized by this section. So I think that we just need to clean up and perhaps split, particularly that subsection B, to some extent, to criminalize only the sharing of altered material or the fake news, as you say, and not any information from the website, because persons should be allowed and it should not be criminalized to share or reproduce or use the material contained on the website.
So Madam Chair, this is a very interesting aspect, and I'd just like to borrow from the copyright realm now. Altering, reproducing, etc., also involves sharing. So we have here a construct. The intention behind this is not only precedent-based in that it exists in other jurisdictions, but it is intended specifically because there is a danger in correct information being shared or used out of context. So the problem is that one size doesn't fit all. You can take what is perfectly correct information out of context and put it alongside. I recall a video of something that I had said in Parliament, which was then clipped. It appeared on a couple sites, the UNC sites, kick out the PNM, etc. And when they clipped it, parts of what I said were true, and they left out all the salient bits in between, and it caused a human being, a lady who had lost someone, extreme anguish to the point where she took to Facebook and went to town until she realized that what had been put out was a lie. Sorry to use that term. And it was only then that the recovery began to happen. So this is intended to deal with issues of how we box the mischief. That's why the intentionally and without lawful excuse were carefully put inside.
I still don't see how the sharing of public information by itself could, or should be criminalized. And if you see, you can run into a situation here where a person who has their information shared widely, let's say within the community, can make a report to the police and say that my neighbors have infringed Section 48.6 by what is their lawful excuse, what is their justification. And I mean, I guess a police officer would have to make that determination, but it ought to be clear that I think that sharing information from a public website really shouldn't be criminalized. And when you're reading the law, it has to be, you have to take each one. So yes, if someone alters the information or so on, that's fine, like what the example you used, but sharing by itself shouldn't be, I think, included there.
The intention of the law, like the precedents that we've come from, is that you are free to go and have a view of this thing, But sharing it is we want to limit the aspects of it. If your neighborhood watch were to say, please, everybody turn on to the website www.sexoffenderstt.com to update yourselves on recent positions. That's an entirely different thing from saying, hey, Faris Al-Rawi name just get added onto that. So the intention is really to focus people in as disciplined a way. We're very cautious about opening Pandora's box in this thing. One of the main arguments against sex offenders registers in small societies is that there is the risk of victimization or the risk of vigilante justice, etc. And you really want to have a fighting chance to put the genie back in the bottle if you can, if that's ever possible in this world.
Senator Vera.
Thank you. AG, what does uses mean or cover in this section, please?
So we looked at that because a comment had come in relation to that, and we went down to the interpretation. Uses is the plain and ordinary meaning of uses. Obviously, the use would have to be something which was not a use that you could lawfully explain. Yes, I used it. I put up a notice saying, guards that are private security guards in an area or municipal police, we want you to come and have a monitoring watch. We're having a children's party outside and there's a child offender living in the neighborhood. So that use would be lawful. So yes, the use, much like the share, is problematic depending upon how you look at it. But this is intended for the police to be able to give a caution, to say, listen, that is not allowed. It's to manner the society back into the point. It's a hard concept to box, I accept, but it is intended to give the push.
Thanks. So on the record, I just wanted the public to be assured that it's not an offense for them to go and look at the website and to draw information from it. No. In that sense, use is not offensive.
Yes, thank you for allowing me that opportunity to put that on.
Let me just ask the Attorney General, through you, the victims who would want these sex predators' names to be publicized on the register, don't you think, Attorney General, how it is captured here may discourage individuals who are victims from participating, and then the ulterior objective of people actually reporting these developments could be defeated at the end of the day, and therefore the website that is seeking to capture people could, at the end of the day, backfire in a negative way? I'm just concerned about...
Senator Mark, are you treating with Clause 9?
No, I'm just dealing with the matter of a person who intentionally and without lawful excuse. And that's the one that Senator Vera...
Yes, that is what Senator Lutchmedial and Senator Vera, they have raised issues on. And
yes, I was just consolidating and advancing some concerns that I have as it relates to
how this thing could backfire.
How it could backfire.
In other words, and so on, victims.
But
all right, okay. Let me leave it so. I'll leave it so.
So, you've just made, So, Honourable Senators, the question is that Clause 9 be amended as circulated. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The question is that Clause 9 as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 9 as amended now stands part of the bill.
Clause 10.
The question is that Clause 10 stand part of the bill. The question is that Clause 10 now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Clause 10 now stands part of the bill.
Clause 11.
The question is that Clause 11 stand part of the bill. Attorney General.
Thank you, Madam Chair. Madam Chair, Clause 11 is relative to Section 50 of the Act, and consequent upon amendments that were suggested by a number of stakeholders, we took the opportunity to craft amendments in terms circulated. We have thought it important, if you look at that circulation, in this particular point, to add in the process of appealing the conviction, etc., holding of the making of the order. And very importantly, the process came to us from the Law Association saying, well, look, we think that you ought to put in prescriptive times for these things to happen. So in the new subsection 3, Madam Chair, you'll notice a sex offender may, within 14 days of the date of conviction, or such other time as the court may prescribe, giving the latitude to enlarge that or treat with it otherwise, apply to the court to be exempt from the provisions of being published, and show cause why. And then where the court has not granted in subsection 4 an exemption, the sex offender may, within 21 days of refusal, appeal that, and the court shall, pending that, withhold making the order. So what we sought to do, Madam Chair, was to put in some more safeguards to ensure that, as the Law Association had pointed out, that we capture in express terms the right of appeal, the time frames within which that ought to be done, etc. This tacks on to a later clause that we ask you to add into the bill, which is the rule-making power of the court, so that we can use the criminal proceedings rules, etc., to manage this process, Madam Chair. Those are the effective substantive amendments. The rest is, of course, in tandem with what was there. It looks long because what we did for neatness sake was just to repeal and replace, or rather remove and replace with what is there. But those are the essential core features of the amendment.
So, Honourable Senators, the question is that Clause 11 be amended as circulated. Those in favour say aye. Aye.
Sorry, Madam Chair. Attorney General, I'm going through the amendments here as circulated. Could I just flag one issue? The only person entitled to make an application for the court not to make this order is the offender. But this section hasn't considered the views of other parties who are involved. For example, the victim. The victim may wish to make an application to the court to say that, listen, if you publish this information on a public website, you are running the risk of exposing my identity. Because you have used the shall, and I don't accept that shall could be interpreted as may in these circumstances, because that's usually the case where you have a lack of clarity. But if the court is compelled to do it, the views of the victim are essentially excluded from this assessment. Even the offender's family may have a particular, because of the nature of the offense, may wish to make submissions to the court, and the court may wish to hear them. So by having a mandatory requirement, save and except if the offender is able to prove to the court that it is and it's his view that this thing be excluded, then you exclude all other persons who are affected by the publication of the material from the opportunity to be heard by the court.
Madam Chair, thank you. In reading the Act as a whole, we had traversed this when we did the first round of amendments in 2019. If we look to Section 61 of the Act, etc., we do preserve the right for anybody to approach to stop the registering per se. And that is also inclusive of the victims' rights, etc. And the court has the widest discretion to consider those factors. It was a very live discussion when we were considering the issue of incest in particular. And that was something that we spent nearly a year considering in the Special Select Committee with very careful detail. Senators' eyes are sharp, and I know that it's not easy to pick this up in one go as part of the workings that we had considered. So the existing law treats with that.
So despite Section 50, they would have to go under Section 61 and make the application.
Yes.
Any other affected person.
And that is, if I'm going to use the term, even ab initio, before you even get registered.
Right. So wouldn't it then, shouldn't you include here then that's subject to any application being made under Section 61 as well?
The law is read as a whole.
Well, yes, but...
Right? So remember, we're at the point, it's a bifurcation. The sentence is passed. The first step is you're going to become a registered sex offender. You can't become somebody on the public website unless you're registered in the first place.
Sure.
So that is step one, where you have the opportunity to say, look, I don't even want this person to be registered. The second aspect is that there is also the right to say, look, I don't want this to be published at all either. Now, remember that the court, in the context of the sexual offences, does consider victim impact statements, etc., as we saw most recently in Justice Sinclair Douglas's very fine judgment that we referred to, the Joseph matter in 2020. So the victim impact, the other aspects, any interested parties, for instance, the Children's Authority or the Solicitor General acting as child advocate, all of these are part and parcel of the equation.
Senator Vera.
Thanks. I understand what you're saying, Honorable Attorney General, but I also sense the Senator's concern that that might be in conflict with the language of this new section, because it's saying, subject to these specific subsections, the court shall do these things. And so, now, you know, I have a particular concern, and I'll say this now because it's going to come up later on. I never use the word shall. I think it's one of the most problematic words in legislation and in agreements. There are other words that one could use, but there's a difference between shall being directory or mandatory. My understanding of the word shall as defined in law is that it doesn't mean must. It can mean should. It can mean has a duty to. It can mean may. It can mean may be lawful. But because of all of these different meanings and juxtaposed against a popular perception that shall means must and it is mandatory, that's why it's so problematic. So I am thinking that here, to avoid the conflict, perhaps we could say the court shall be entitled to or is entitled to, because that way it means that it's not bound to if there's an application made by the victim. And as you know, we spoke a lot about the victim not being made voiceless. And I think it's a very important consideration.
Thank you, Madam Chair. I thank Senator Vera for expressing so clearly what is a very important point. I'd just like to say that the legislative structure that we use that is well traversed in court is shall or may. And yes, shall is may, and may be shall, and we've had lots of discussions from Bennion come down as to what is what. But the fact is that as much as I would love to see us take that step towards the plain English reading like the English do in their legislation, we're not there just yet. We still use mutatis mutandis and other positions from our Latin roots, etc. So I would be cautious, because this is a terminology used throughout the Act as amended to touch one particular aspect of it from a phrasing point of view and plain English point of view. I'd like to say that in the process of exemption from registration or reporting, that we contemplate a person applying to the court. And we do capture the voice of the victim, in particular, in mandating that the court take into account the victim's voice, which is in the parent law. And in those circumstances, I fall upon the defense that the Act is read as a whole because of the process by which you get to become a registered person and then ultimately a published person if that happens on the website, pursuant to the structures that we have. So I would respectfully invite honourable senators to be assured, having put this on the Hansard as well, that risk of somebody else not having a right, or the victim's voice, which is a critical issue inside of here, the victim's voice is very securely managed in the judicial considerations in the other provisions of the Act that correlate with this.
Rambhajan.
Yes, please. Thank you, Madam Chair. Honorable Attorney General, I'm looking at Section 61, and from my reading of it, it says a person may apply to be exempt from registering or reporting. So the person referred to in 61 is the same sexual offender referred to in the amendment. So what my friend is saying, Senator Lutchmedial, is the way the both sections read, the amendment as well as the Parent Act, it envisages that the offender is the one who's making the application. From my reading of it, there is no room for a victim to make an application for the offender not to report or to be exempted. And even though we have the consideration of the victim impact statement, consideration of a victim impact statement is very different from a right to make an application. So I think this may be one of the places we may want to consider the voice of the victim as well.
So, Madam Chair, thank you, Senator Rambhajan. Section 61 is a person, and he, and then subsection 2 in 61 is where the sex offender has made the application, the registrar shall inform the victim or the family of the victim, and the victim or family may make oral or written representation. So it's the victim impact statement. So the Honourable Senator is correct there. That's where I was alluding to the voice of the victim aspect. The entire construct of the parent law as we passed it in 2019, which in fact had a lot more cautions than the 2000 version of the law, was to allow for the victim impact concept. But we've left the discretion of the court intact as to whether you go on the register or not. Even though we use the word shall, the fact is that the court will interpret what its parameters are, because this law must be read alongside the other laws. So for instance, the shall in the context of the children's court, the laws that prevail there are anonymization, etc., and the preclusion. We've left out children, we've left out incest. They can't be reported statutorily under this law. It's the other factors that can. What we're doing on this occasion, we had mandatory shall in the 2019 law for Section 4, Section 9, Section 12, Section 9A, rape, etc. We had that as mandatory. What we are doing right now is all the rest where we said the judge may, which is all other sexual offenses, we're saying shall, but subject to the right to say no. So we've improved on that particular provision in Section 50. Why I'd be loath at this point to have a tweak on this is that it's going to pull a thread on the rest of the law. What I can say is that we do have 2 other amendments to come to this law, which we're at the cusp of bringing to Cabinet now. And I think this is a very useful point to have a look at in a more round purpose, because if we touch this particular provision, it's going to touch many other sections that are in the Act as a whole. So what I can do is to give you that square undertaking in the presence of the chairman of the Law Revision Committee right here, Mr. Rambharat, that we will look at it. I think it's a very good point, but I'd like to look at it holistically within the language of the rest of the Act.
Thank you, AG.
Thank you.
Senator Lutchmedial.
So the point is that both Section 61 and Section 50, the right to invoke the discretion of the court is only with the offender. But what I think might be useful, based on your explanation of Section 50, would be to add the word registered before sex offender in 51 in the chapeau. That's okay.
Sorry, would you repeat?
Right, just based on your explanation of how you envision Section 50 to work, that you must become registered first before you become published. I'm still maintaining my view that 61 and 50 they only invoke the discretion of the court when the offender makes the application, based on our reading. So you said you'd look at that. But in addition to which, if 50 is meant to be triggered only for a registered offender, I think you should insert the word registered before sex offender in the chapeau there. So subject is 2, 3, and 4, the court shall in relation to a registered sex offender. So you cross the hurdle of registration before you get to the publication on the website.
So if I could explain that, it's the reason why we've separated out sex offender from registered sex offender. So you're a sex offender, but you're only registered when you report to the police station for registration. So we need to use sex offender in this case here, because you only become registered when under 54, you get to the police station after you've been released or your sentence was suspended, etc. It's at the point of turning up that they register you, and then you become registered. Until then, you're just a sex offender.
So you're going to publish even unregistered, before you become registered, you could be published then?
Yes, sex offenders.
Right.
So at the point of conviction, you're a sex offender. You're a registrable status, which is where you report. So the registrable really means I have now a reporting requirement. I have to turn up X number of days, I have to do that. So the concept of registration is not the fact that you're on a register, it was the fact that you were subjected to requirements for reporting to the police station. That's what the registration exercise really is.
Right. Because if someone were to make an application to become exempt under 61 from registration, and they were granted that exemption under 61, then they ought not to be published. Or they could still be published on the website.
They can, that's why we put in section 50 the ability to say, I don't want to be published at all. So there's certain circumstances in 50 where we say, look, you can't be published on the website if you have an appeal. You can't be published if you have made an application to not be published. You can't be published if you have an appeal which was rejected on your application to not be published. It's only when due process is complete, and mind you, that goes all the way to the Privy Council if you want to. So you can't be published in those circumstances. So you become a sex offender when the court is finished with you. You become a sex offender on the website when the court is finished hearing your objections as to why you ought to go there. When you become a registered sex offender, you're now outside and reporting to the police station in that registration requirement.
So if you are published as a sex offender at the time of your conviction, so all of the time that you're serving your sentence, for example, you are on the website.
Yes.
But when you come out of prison and you register, you can also make an application to not be registered under 61.
Yes, because registration also involves reporting requirements.
Sure. If at that point in time a different fora, a different quorum or whatever considers that application, or the court, whoever, and they determine, yes, you should be exempted from registering for good reason, whatever reason you put forward, you would have already been published on our website for X number of years.
Because the court said, you did it. You raped someone, you brutalized a child, you're a sex offender.
Great, but it really renders the exemption under 61 meaningless.
And you exhausted all your appeals to not be listed.
Sure, so then what is the purpose of 61? It serves no function after the fact. If you could provide some good reason when you come out of prison why you ought not to be registered, of what use is that protection or that facility that you provide to the offender under 61 if they've been published already on the website?
Well, the publication and the reporting are mutually exclusive in some circumstances. You may be a paraplegic, you're still a sex offender, you did it at that point in time, your name is known, etc. You then find yourself incapable, you left the country, you were incarcerated again. There are all of those circumstances as to why you ought not to be reporting to the police station in regular cycle.
Okay, and then that doesn't assist us with the point that you said that section 61 was the reason and the justification why you don't need, why only the offender makes the application under 50, because you said 61 could take into account victim and all of that. But if 61 kicks in only when you come out of prison or, when you're released and you go to register, then that offers absolutely no protection for the victim or other people who might be impacted on the publication at the time of conviction under section 50.
So let's get to the point. Sorry. Thank you.
Go ahead.
So yes, 61 treats with the registered person and the registration requirements. 50 treats with, look, am I going on the website? So you get convicted, you're a sex offender, you say, I don't want to be on the website.
I'm not on the sex offender and him not wanting to be on the website. I'm on the ability
victim.
of other
I know,
people.
the person other than the offender. I got
Other
your
than
point.
the offender, right.
I'm saying, number one, the prosecutor would take care of that, the voice of the victim impact statement in the course of criminal prosecution for sex offenses will do that. The criminal proceedings rules will assist us with that. And what I did say is that I would specifically look at the point coming back to the Senate, because I accept the considerations that you and Senator Rambhajan and Senator Vera have said. And my caution, my only reason for not doing it immediately is that I'd like to look at it carefully because I know it impacts on other sections of the Parent Act as well. I think that the point is well taken. Let's have a look at it carefully.
Madam Chair, if I may just suggest.
This will be the last on this particular clause, yeah?
Yes. Perhaps, AG, what we might consider is putting a time when the application for exemption is to be made. So perhaps upon conviction, a sexual offender may make an application to be exempted, and then that does not preclude the registered sex offender, when he comes out of prison, having the same right to make the same application. So if we put a time, we may clarify it.
We did put the time. That's where we put the 14 days, the 21
Right.
days, etc. The golden point that stands out, thank you, Madam Chair, for allowing us this. The golden point that stands out is somebody other than the offender.
Thank you.
That's the simple point that I'm taking away here. Look, can somebody else come and say, look, I have a problem with that? Yeah? Okay. Thank you.
So the question is that clause 11 be amended as circulated. Those in favor say aye. Aye. I need to hear other than the Attorney General. Those against say no. The ayes have it. The question is that clause 11 as amended now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clause 11 as amended now stands part of the bill.
Clauses 12 to 15.
The question is that clauses 12 to 15 stand part of the bill. The question is that clauses 12 to 15 now stand part of the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. Clauses 12 to 15 now stand part of the bill.
Clause 16.
The question is that clause 16 stand part of the bill. The question is that clause 16 now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 16 now stands part of the bill.
Clauses 17 to 19.
The question is that clauses 17 to 19 stand part of the bill. Senator Lutchmedial.
With your leave, I just want to raise one thing under the clause 18, Attorney General. Again, the offender under section 63, and it's just something worth considering, it just popped into my head. Again, the onus is on him to make the application here. I've actually seen situations where after someone is convicted and is serving his sentence and doesn't appeal, or the appeals process was exhausted, that the state has to reopen the case on fresh evidence, such as a victim recanting. And in this circumstance, I don't know that the offender alone should be able to make this application to the High Court to have the information expunged. I don't know if you can flag it for further consideration that the court, if fresh evidence is introduced, or even if the state reopens the matter at an appeals process on the basis of fresh evidence. I think that's how it's done when fresh evidence. They file an appeal and ask for the period to be extended, that the court can, as part of that process, order that the information in the register be expunged. So I just wanted to flag it as it should. I don't know if it's right to just shift the onus to the registered offender.
Thank you very much. I certainly will take a look at it. I had thought that would have been taken care of in a matter being reopened under the inherent jurisdiction of the court to treat with orders that it had made, particularly because it was the same matter and not a fresh matter, not a point there. But I thank you for flagging it, and we certainly will look at it.
Okay. So the question is that clauses 17 to 19 now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clauses 17 to 19 now stand part of the bill.
Clause 20.
The question is that clause 20 stand part of the bill. Senator Mark.
Attorney General, was this increase from $50,000 to $250,000, and the 6 months to 5 years, was it a recommendation from the judiciary?
Thank you, Madam Chair. No, it wasn't. We amended the Interpretation Act last year to raise those limits. Okay. So because we knew that, we didn't want to rely upon the consequential, inferential amendments, so we just fixed the law at the same time. So this is, the Interpretation Act itself was amended in this way, so we're just putting the language right here.
Okay. So the question is that clause 20 now stand part of the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. Clause 20 now stands part of the bill.
Clause 21.
The question is that clause 21 stand part of the bill. Attorney General.
Madam Chair, it's usual when you have a schedule to refer to the springboard from which it comes, which is section 21, so we are just simply doing that.
Honourable Senators, the question is that clause 21 be amended as circulated. Those in favour say aye. Aye. Those against say no. The ayes have it. The question is that clause 21 as amended now stand part of the bill. Those in favour say aye. Aye. Those against say no. I think the ayes have it. The clause 21 as amended now stands part of the bill.
New clause 20A, new section 69 inserted.
The question is that new clause 20A be read a second time. Those in favour say aye. Aye. Those against say no. I think the ayes have it. New clause 20A will now be read a second time.
New clause 20A inserted, new section 69 inserted.
Attorney General.
Thank you, Madam Chair. Madam Chair, it was an omission to not have included the ability for the court to make rules under the rules of the Supreme Court route, and therefore we have just sought to add this in to allow for the harmony of rulemaking, particularly with the criminal proceedings rules and family proceedings and children proceedings rules as we have them now. Thank you, Madam Chair.
Senator Vera.
Chair, I wonder if you could just allow me an indulgence. Just for the record, Honorable Attorney General, I know that we have in the Act that a child offender will not be included on the register. Now, the register is private, it's not public. And we know there have been serious situations where children, and a child could be 18 years old, 17 years old, have committed heinous crimes, including sexual offenses. We had this situation, remember, with the Slenderman case, 2 young girls brutally stabbed up another woman, or the one in England with Venables, where they brutalized this little child and left him on the rail track. If you have a child offender who's a real risk to other children, shouldn't the police and law enforcement be aware that this is a dangerous person?
Madam Chair, this was the subject of heated debate by the interest groups, in particular in the Special Select Committee. That strict line of the child and the prospect of the rehabilitation and reform of the child. As a result of which, we listened to the voices that were in the Select Committee and did not include the child offender, notwithstanding the potential gravity and seriousness of the child's propensity or ability or capability to offend in a very serious way. What I am comforted by is that the experience in the children's court is growing significantly, and that we do have a whole line of investigation that we're looking at right now. That's why I mentioned the parole board, and I said the one reason that we had not come forward yet on that is that we are looking at the issue of child parole, because it would be odd to bring a parole bill and leave out all the child offenders inside of that, because one of the aspects of parole that is very persuasive is that you get enrolled in programs to qualify, so that there's a whole training and reform and other aspect that goes on with parole. Parole is much more than, hey, can I get out? As you well know, but I'm just saying it for the public right now. So the issue of including the child would require us to have a significant amount of coordinated conversation with. My colleague, Ayanna Webster-Roy, is leading that particular dynamic, and of course, I with the judiciary on the other side. So it's something that's being looked at because we need to settle that ground a little bit more. But I take your point.
Senator
Madam Chair.
Thompson-Ahye.
Yes. If I may, the body of literature, all the international standards and norms in child justice, they all speak against it, and there's a whole set of learning on it, research papers and so on, which go not in that direction at all. So that I can make some available to you, Mr. Vera.
Thanks, but it's not public currency. It is restricted just to law enforcement. And I'm thinking that's where the balance lies.
Senator Vera did ask for an indulgence, so that I will now put the question. The question is that new clause 20A be added to the bill. Those in favor say aye. Aye. Those against say no. I think the ayes have it. New clause 20A now stands part of the bill.
New clause 22, schedule 3 amended.
The question is that new clause 22 be read a second time. Those in favor say aye. Aye. Those in favor say aye. Aye. Those against say no. I think the ayes have it. New clause 22 will now be read a second time.
New clause 22, schedule 3 amended.
Attorney General.
Madam Chair, the proposal for the amendment for the addition of new clause 22 is to correct some cross-referencing that we needed to take care of in the schedule. So it was upon a scrubbing of the bill that we spotted this, and therefore we're seeking to tidy it up by the addition of this clause.
The question is that new clause 22 be added to the bill. Those in favor say aye. Aye. Those against say no. The ayes have it. New clause 22 now stands part of the bill. Honourable Senators, the question is that the bill as amended be now reported to the Senate. Those in favor say aye. Aye. Those against say no. The ayes have it. The bill as amended will now be reported to the Senate. Attorney General.
Madam President, I wish to report that the Sexual Offences Amendment Bill 2021 was considered in Committee of the Whole and approved with amendments. I now beg to move that the Senate agree with the committee's report.
Honourable Senators, the question is that this Senate agree with the committee's report on the Sexual Offences Amendment Bill 2021. Those in favour say aye. Aye. Those against say no. I think the ayes have it. Attorney General.
Madam President, I beg to move that a bill entitled An Act to Amend the Sexual Offences Act, Chapter 1128, be now read a third time and passed.
Honourable Senators, the question is that a bill entitled An Act to Amend the Sexual Offences Act, Chapter 1128, be now read a third time and passed. Those in favour say aye. Aye. Those against say no. I think the ayes have it. So I will allow for 3 minutes for all members to return to the chamber.
Mr. Rambharat.
Yes.
Mrs. Gopi Schoon.
Yes.
Mr. Sinanan.
Yes.
Mr. Hussain.
Yes.
Ms. West.
Yes.
Dr. Brown.
Yes.
Mr. Mitchell.
Yes.
Ms. Cox.
Yes.
Mr. De Freitas.
Yes.
Mr. Singh.
Yes.
Mrs. Sagramsingh-Sooklal.
Yes.
Mr. Bacchus.
Yes.
Mrs. Lizama Lee Singh.
Yes.
Ms. Bethelmy.
Yes.
Dr. Ibrahim.
Yes.
Mr. Mark.
Yes.
Ms. John.
Yes.
Ms. Lutchmedial.
Yes.
Mr. Nakhid.
Yes.
Mr. Lyder.
Yes.
Ms. Rambhajan.
Yes.
Mr. Richards.
Yes.
Mr. Vieira.
Yes.
Dr. Deyalsingh.
Yes.
Ms. Dillon-Remy.
Yes.
Ms. Seepersad.
Yes.
Mr. Timor.
Yes.
Mrs. Thompson-Ahye.
Yes.
Dr. Dillon-Remy. Madam President, the result of the decision is as follows. 28 members voted for, no members voted against, and no members abstained from voting.
Honourable Senators, the result of the division is as follows. 28 senators voted yes, no one voted no, and no one abstained. The bill has therefore been passed.
A bill entitled An Act to Amend the Sexual Offences Act, Chapter 1128.
Leader of Government Business.
Madam President, I beg to move that this House do now adjourn to Friday, 18th June 2021 at 10 a.m. We propose on that day, Madam President, to deal with the Gambling, Gaming and Betting Control Bill 2021. Madam President, I just also want to indicate that the government proposes to also sit on Monday, 21st of June 2021 from 10 a.m. Thank you.
Honourable Senators, the question is that this Senate do now adjourn to Friday, June the 18th, 2021 at 10 a.m. Those in favour say aye. Those against say no. The ayes have it. This Senate now stands adjourned to Friday, June the 18th, 2021 at 10 a.m.